me from my winter hell. I've got candles and candy, I can be your daddy if you only let me creep into your prison cell. Hey baby, can you tell I'm not a criminal? Your choice is seminal. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. Speak low, stand in your row, try not to show this life's a show. Try not to glow way down below. Oh, it's a lot of woe, and that's not a place where you would like to go. I've got cigarettes and brandy, which could come in handy if you just help me loosen up my hand grenades fuse. Baby, don't refuse my truth, but it's up to you not to choose. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true. I want you to stay true to what's right for you. No matter who or know what will others say, just find your way and try to stay true, 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 true,
Good morning, you guys. How are you? Mike. Guess what day it is? Hump day. I see that you guys were a little concerned about your girl, and I forgot that I needed to put, excuse me, I should have made a post. Yesterday, Judge Bev just said that at the end of the day, she said that that the court would be an hour. I can't even talk. I should just end this and just go back to bed. Yesterday, Judge Bev said that the court would be an hour late today, so that's why I'm late. But we're here, and I'm ready to get going. Just a little tiny bit of an update. I did go ahead and move the hamper back to the closet. All is well. I did notice that once the hamper was moved back into the closet, lo and behold, it was like a miracle. The dirty clothes just fell in there the way that everybody intended. Okay. As it's written in the Bible. The dirty clothes go in the dirty clothes hamper. Good morning, OnlyFan. It's good to see you. Let me say good morning to you guys. Good morning, Sissy's mom, Jen. Good morning, Neat Noodle. Good morning, MK Lynn. Good morning, Birdie. Good morning, Rachel. Good morning, Tosh. Good morning, Carolyn Cooper. Good morning, Lil Red. It's good to see you guys this morning. Good morning, Melissa. Good morning, Violet. Good morning, Claudia. Good morning, Tess. Good morning. Good morning, Brandy. Good morning. Good morning, Julie A. Good morning, Nicholas. It's been a minute. Good morning, Christina. All right, so we're ready to go. We've got the OnlyFans here. The OnlyFan is up and ready to go. Now, after I left you guys yesterday, I did do a little watching. Good morning, Shelly Bean. Good to see you, babe. I did do a little, I did watch the second half of, the day, like after lunch. And it was just as pointless, in my opinion, anyway, nothing really good or worth mentioning. And as the first part of the day, okay? At the end of the day, my issue is they have, good morning, Shmeda. They have not proven that that John O'Keefe let me start again. At the end of the day, none of this testimony means anything to me. I don't give it a whole lot of weight because they have not proven that John O'Keefe died as a result of being hit by a vehicle, that it was Karen's vehicle, and that Karen was driving that vehicle. So all this, I backed up, I did all the things. I reenacted. I was not moved. I was not convinced. It did nothing for me. Good morning, non-blonde millennial. It's good to see you. Good morning, Mrs. Troy. So yeah, I'm not moved. All right. Now, apparently, at the end of yesterday, Brennan said that he was almost done. And then it would be cross-examination. Shmita says, they gave me a possible theory that they have of what could have happened, but they didn't prove anything to me and certainly didn't prove that Karen did it. Say it again, Shmita. Also, Shmita, give them boys a hug and a kiss from their Aunt Jinjin, would you? It's been a minute. I haven't seen any pictures. Hope everybody's doing well in the Canadas. I miss you. So to me, hey, Violet, good morning. To me, it proves nothing to me. They haven't proven anything yet. Oh, cool. Thank you, Claudia. It's exactly 12 a.m. Perfectly timed live. Jen Lou, I aim to please. So yeah, that's what's going to happen this morning. I expect that cross-examination is going to go quite long. Mr. Alessi is very thorough. He is going to check all the things. He's going to ask about all the things, etc., etc. So it should go long. The Commonwealth is supposed to rest today. Tosh, I wish that you could too. But the thing is, it's YouTube. And I would never recommend doing that on the tubes, ever. Okay? These streets be wilding out. These people be wilding out. You never know. So I just would, I wish I could see them. I'm sure they are adorable. And you got to protect them babies, So Tess says, to me, they fit the data and evidence to their story, but didn't prove anything. Yeah, Tess, like when you have to do a bunch of math and move stuff around to make it fit, I got a problem there. I do. You just have one. Oh, okay. You just have one little baby. Oh, one boy is enough. You just can't post anything anymore. It's just really sad. But anyway, when you gotta, now I love a loophole. Y'all know this, okay? But if I have to contort myself, and in that contortion, in order for me to see the perspective, I got to get my head up my own butt. It ain't happening. No, then that's not good. That's not a good loophole. I'm never gonna, if that's what I got to do to be able to see things from the Commonwealth's perspective, I'm going to have to take a hard pass. No thanks. Ain't happening. And I feel like, okay, I'm just going to say this. You guys take it how you want it. But to me, this testimony is so reminiscent of John Fogelman in the West Memphis 3 trial, taking that dadgum grapefruit and hitting it with the knife to try to replicate injuries he said were on the boys. It's just as ridiculous as
All
that.
right.
Oh, Judge
Good
Bev
morning,
is already
everybody.
sighing. You guys are all in big
All
trouble.
right, so Dr. Welcher can testify that the data he downloaded and analyzed and the damage to the Lexus is consistent with Ms. Reed's vehicle being in a collision on January 29th at 12:32 a.m. because he's a qualified expert and his opinion is based on reliable methodology appropriately applied. In addition, Dr. Welcher can testify that Mr. O'Keefe's injuries are consistent with his having been struck by a Lexus that is physically identical to Ms. Reed's Lexus, because this opinion is based upon, among other things, his experimental work that came into evidence without objection as to scientific methodology and application. However, he may not testify that Ms. Reed's Lexus collided with Mr. O'Keefe, because that conclusion is not based on the application of reliable scientific methodology. The problem here is not that the opinion concerns the ultimate issue, because in Massachusetts, that's not a bar to admissibility. Rather, it is that Dr. Welcher, the expert, is drawing an inference based upon more than scientific method. His opinions set the stage for argument and a permissible inference to be drawn by jurors through the application of their sound judgment to the opinions that they find credible. But the jurors are as well positioned to draw or reject the inference as is the expert. That is, the inference is not compelled by the application of any scientific method. So that's the ruling. All right, so the jurors are lining up. We should have them momentarily.
Thank you for the late call today.
Okay. Is Dr. Welcher right around?
Yes.
Why don't we bring him in if he's here before the jurors?
So, Tess, you're right. So, Tess says she knew how bad it looked yesterday, clearly. I heard it was close to a mistrial about what happened at the end. Yes, it was the way in which Brennan asked the question.
Updated version, we provided a copy to the defense with all the redactions.
Okay.
The
Are you in agreement with this, Mr. Alessi?
I haven't gone through it, but I have no reason to believe that I wouldn't be in agreement, so
Okay.
I'm just go away the way it is.
There is one slide, so I'll admit it conditional to redactions that you didn't rule on, but I feel as though you probably will exclude, and that is in that version. I didn't want to pull it out with the court's order, but I'll talk to.
Do you know the number? You don't have to find it if you don't.
It's 131.
Oh, is this was it 130? Was it 131 yesterday too? So at Sidebar, I said we could go back to that, and Mr. Alessi agreed that we could go back to that. So, and I know I thought we were starting there, and I think Dr. Welcher thought we were starting there, and then you went to
Jesus,
132.
fuck, this is a mess.
That was my understanding at Sidebar.
Jesus.
Subject to me being able to object. I was basically, because we wanted the jury to come in, so I want to look at the slide.
Okay, so look at it again. That's not my understanding, Mr. Alessi. It was you were concerned just about the heading, and then I said we'd go back to both slides.
Oh, my
Oh,
God.
yeah, no, I'm okay with that.
Yeah.
That one, yes, Your Honor's recollection is.
Yeah, and we were going to start on that, but you thought because I struck it based on the objection, but then at Sidebar I said we could go back to that. That's your understanding too?
Correct, Your Honor.
Yeah, I'm sure the Dr. Welcher took off the heading on 131.
I think he did, but because I think he took off from 124 to 1.
I think you did as well.
I did.
Thank you very much.
Okay.
I would have liked your prediction to come true.
Are they out there, Paul? Okay, thank you.
So it was the way in which the question was posed to Dr. Welcher yesterday. And it did seem as if Dr. Welcher was testifying to really what is at the crux of this case and is actually left to the jury to determine. So maybe at lunch today, we can go back and listen to what happened yesterday at the end, and then we'll talk about it. Hear ye, hear ye, hear ye. Also, hold on a minute. I just want to say this. Whenever I hear Judge Bev say drawing, you know what it reminds me of? Remember on Pinwheels a long time ago? Well, hello, my name is Simon, and I like to do drawings. That little cartoon. Yeah, that's what it reminds me of every time. Here we go. Oh, Judge Bev's going to be nice to the jury. Oh, Judge Bev.
Were you also able to follow the instruction and refrain from doing any investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left yesterday? Everyone said no or shook their heads. Thank you very much. All right, Mr. Brennan.
Thank you, Your Honor. Morning, Dr. Welcher.
Good morning.
When we left off yesterday, I was asking you about some of your opinions. I'm going to ask you those questions again, but before we do, I'm going to ask you two other questions. The first is, I'd ask you to turn to your PowerPoint, slide 110.
I'm so tired of you.
You want me to display it?
Please. I'm going to ask you a question about a series of your slides regarding this effort. This is 110. Could you also follow through to 111, 12, 13, 14, 15?
You want me to play the videos?
You don't need to play the videos. I just want to acquaint you for the question.
111,
12,
112, 113, 114, 115.
How many times did you engage in testing where your arm and forearm touched the rear right of the exemplar Lexus?
3 times.
In any of those 3 times, did it ever leave any paint on the underside of your arm or forearm?
No.
If you could turn to slide 130, please. What? There we go. Could you go back one, please?
Yes, Boho, they did do it on Saturday Night Live, but it originally comes from Pinwheel. Trust me, I promise you,
Perhaps it's
because I've
131,
seen
Dr.
it on the
Welcher.
tubes, because I
Here we go.
remembered it, and I was like, I wonder if they
Could you explain
have
the
this
significance of
cartoon
this
on the
slide,
tubes. They do.
Your Honor, this is.
Oh, could you take that down, Dr. Welcher?
Sure.
Thank you, Mr. Brennan.
We're going to move forward. Yesterday, when we left off, I had asked you,
So we need to take this slide down.
Sorry.
you
Oh,
can take the
my-
PowerPoint down, please.
That was in a different spot on this line.
Okay, look, Welcher, I'm going to need you to get it all the way together today, okay? We don't have time to be playing around. We don't have time for you to figure it out. This is your presentation. Stop playing with these people. Pay attention to what's going on. Let's go.
Hold on a second.
Yes, it was on Saturday Night Live, Rachel. It was
Thank
Mike
you.
Myers. He
Sir,
was
I
in
had
the
asked
tub.
you yesterday about some of your opinions. I
Right.
want to ask you about some of your opinions relative to that last effort that you made regarding testing between the Lexus and your arm.
Correct.
Look at
You
his
had mentioned
face.
earlier
Hold on a
in
minute.
your testimony.
I'm sorry, you guys. I'm sorry. I need to. Normally, I just let it go, but and I wait and all the things. And I know we're trying to get into it, but all these little pauses, all that'll happen, you're not going to miss anything. We just get to skip through the breaks. But this is really annoying. Look at his face. He looks confused, bruh. Need I remind you for the 11 billionth time? This is your work. How are you confused by your own work? And I'm already yelly. Here we go.
That you reviewed a number of pieces of information and offered that you relied on some of those pieces for your opinion. Can you share with us, for this part of your analysis, what pieces of evidence or information did you rely on for the opinions I'm going to ask you?
Relative to the testing on the arm contact on the taillight?
Yes.
So it was the physical evidence at the scene, the photographs of Miss Reed's vehicle, to a certain extent, my analysis of the Ring doorbell and the One Meadows event, the nature and
Excuse me, Your Honor, pardon my interruption. I just want to know if you're reading from something or not reading.
Looks like he's counting on his fingers. Are you reading from something?
No, I am counting on my fingers.
Thank you.
So I am counting on my fingers. The Ring video doorbell, Mr. O'Keefe's height, the type of shoes he's wearing, because I needed the same type of shoes, my exemplar inspection where I matched up the heights, the locations of the lacerations, and then the text stream data as well.
That information that you considered, in addition to the text stream data you considered, considering both those areas of information, do you have an opinion to a reasonable degree of engineering certainty in whether the damage to the defendant's Lexus is consistent with a collision with Mr. John O'Keefe on January 29th, 2022 at around 12:32 a.m.?
So there's been two potential theories that I've seen on that issue. One is a glass was thrown at the rear of the vehicle and shattered it. The second one was an impact to the arm. If the impact is basically more than approximately 8 miles an hour, it will likely break the taillight lens.
And do you have an opinion whether, based on the data and based on the physical damage and your testing, whether that is consistent with a collision or a impact with Mr. John O'Keefe?
It is consistent with the collision as long as it's greater than approximately 8 miles an hour.
Do you have an opinion whether it's consistent with an impact or collision with Mr. John O'Keefe on January 29, 2022 at around 12:32 a.m.?
With that caveat, yes.
In your testing, did you consider, or do you have an opinion to a reasonable degree of engineering certainty, whether John O'Keefe's injuries on his arm, inevitably in the back of his head, are consistent with being struck by a Lexus identical to the defendant's Lexus on January 29, 2022?
Yes,
What's your opinion?
that it is. It is consistent with being struck by a Lexus and ultimately contacting a hard surface such as frozen ground.
And does that specifically pertain to January 29, 2022 around 12:30 a.m.?
Objection, Your Honor.
I'm going to allow that.
Yes, it does.
To finish, I'd like to ask you a few more questions. You've written some papers on side swipe collisions or clipping. Can you describe for the jury and explain what a side swipe collision is or a clipping and how that may or may not differ from a direct hit on a pedestrian impact?
Sure. So what generally differentiates say, side swipes or clipping contacts compared to, say, an inline impact or, say, a T-bone impact. It's what refers to that the object that you're hitting isn't accelerated up to the speed of the object that's coming in. So, for example, if I rear end a car, that car will be accelerated up as a result of the contact, and they reach what's called common velocity, and then they separate. And so in a glancing hit, you can have a glancing hit, and you don't have what's called complete momentum transfer, meaning the momentum from the car, because it's a glancing hit, doesn't completely transfer to the object being struck. For example, you can drive down the road at 100 miles an hour and clip the mirror of a parked car, and you'll break the mirror off, but you're not going to go from 100 to 0 instantaneously. You're just going to keep going because you don't have all that momentum transfer. So when you have glancing contacts, you can have much higher speeds without a lot of damage to the car because you're only in momentary contact and it's a glancing type hit.
You mentioned about potential damage to a car. How about potential damage to the pedestrian?
It's the same thing. So when you have a glancing hit to a pedestrian, this is referred to as a fender vault. In this case, they call it a fender. Fenders on the front of cars, because most pedestrian impacts involve the front of cars. In this case, it would be called a quarter panel vault, which means you're kind of vaulting off the corner of the car. Those are much more complicated because you don't have that common velocity that I referred to. So it's difficult to calculate the exact speeds at which the vehicle contacted without a whole bunch of information in that type of crash. If the impact had occurred in the center of the vehicle and we knew where the point of impact was and the point of rest, we'd have a much better chance of determining how fast the vehicle was going. But when you have just a corner clipping or glancing, it makes it more difficult to determine, even when you have an area of impact, which is where the person was when they got hit, and a point of rest where they landed, makes it more difficult for glancing contacts because you have that side swipe problem where they don't obtain what's called common velocity.
And what are some of the other difficulties in attaining specificity in a side swipe or being hit by a quarter panel as opposed to a fender?
So for a pedestrian, correct?
Yes.
So pedestrian impacts and how you move post-impact are very sensitive to your exact body position. For example, whether your right foot is on the ground or off the ground, whether your left foot is on the ground, off the ground, whether you jump up in response to the crash. Simply raising and lowering your arm changes the amount of rotation that's going to happen. Post-impact motion of the person. So cadavers, crash dummies don't have any muscle reaction. So the motion of a crash dummy is just going to be like you're hitting a dead body, to where people will step, try and regain their balance if possible, will do additional activities that alters where they come to rest.
In your studies of direct pedestrian collisions by front or back bumper as opposed to side swipe or clipping somebody, is there a similarity or difference in type of injuries that you see?
Yes.
And what is the difference?
So in direct centralized impacts, you tend to get much more severe injuries. Really what's occurring is you're getting that momentum transfer. So it's more, you're accelerating the person up to the vehicle. They can wrap onto the side in front of the vehicle at higher severities. Their head will hit the hood, their head will hit the rear of the vehicle. So when you have that direct contact, there's actually more momentum transferred to the actual occupant. There's more applied force to the occupant as well.
When you see direct impacts, is there ever the existence of lower body extremity injuries, broken bones in the legs?
So there can be both, depending, and again, it's very sensitive to where the foot is on the ground, whether the foot's on the ground, as well as the severity of the crash. In the presentation that I gave at the actual reconstruction Collision Safety Institute on pedestrian injuries, I went through all the literature on lower extremity injuries and looked at what parameters affected that. And so depending on how it was loaded, some at 15 miles an hour had no injuries. Some at 15 miles an hour had some fractures. It depended on how exactly the foot was loaded.
Is it uncommon in sideswipe pedestrian accidents to see no lower body broken bone?
No, it is not uncommon.
Have you had cases that you've studied or been involved with where you've studied the effect of a sideswipe or a clipping impact where there's an absence of broken bones in the lower body extremities?
Yes.
I'd ask you to turn to slide 139, please.
Oh, sorry. I fixed those other two slides.
Okay. Could you share with the jury what this represents?
Sure. So this was a trial that I was involved with in downtown Los Angeles. I've redacted the name at the top, but this was an instance where we had, this is a image from the police report. Well, let me see if I can. So AOI in this diagram stands for area of impact. That's where the pedestrian was when they got hit. AOR is area of rest. And you can see we have information on exactly how far the pedestrian was thrown. Then on the right-hand side, we have photographs showing the impact to the pedestrian. This was determined by experts on both sides of this case to be between a 25 to 35 mile an hour impact. And then what you see is a close-up on the bottom slide of where there was DNA transfers, hair and tissue samples on the vehicle from the individual that was hit by the vehicle.
Next slide, please. And what does this represent?
So this is the decedent in the case, the person that was hit. He was killed at the scene. What you see on the left-hand image, oops. On the left-hand image is he had a massive laceration to his right forearm, but it didn't break his arm. There was no broken bones in his arm. On the right-hand side of this image, you see the autopsy report. What you'll notice is he had red marks on his leg, left buttocks, but he had no leg fractures. And again, this individual was hit at between 25 to 35 miles an hour.
Can you expand that? I'm sorry.
Yes, yes, sure.
Do you want that expanded like other times?
There you go.
Thank you. I'm sorry to interrupt you.
Yeah, no, my pleasure, Your Honor. Thank you. So at the top, he had a severe brain injury, which again is the most common injury in pedestrian crashes. He did have fractures of the right 11th and 12th rib and a liver laceration. If you look at the extremities, it says right upper extremity. Again, that's from a shoulder to the end of the hand. Extremity wound with vascular injury, so no fractures. If you look where I was talking about the multiple abrasions, so when they're looking at the lower extremities, they're noting a number of red marks, but there was notably no fractures to the lower extremities.
Thank you. You can take that down, please.
Okay.
Dr. Welch, regarding your analysis of the data and the evidence in this case, do you have an opinion to a reasonable degree of engineering certainty whether the absence of lower body breaks to Mr. O'Keefe is consistent with the defendant's Lexus impacting in a side swipe or a clipping Mr. O'Keefe?
Yes, you could definitely have this type of impact and not have anything beyond, say, red marks to the lower extremity.
Thank you, Dr. Welcher.
My
Your
pleasure.
Honor, I would move into evidence subject to redactions, Dr. Welcher's PowerPoint presentation.
That's by agreement, Mr. Wilson, with that
That is, Your
caveat.
Honor, thank you.
Put in both the flash drive and the notebook.
Upon representation, it's consistent with the same as that I am noted.
So let's put them both together now and decide later,
Thank
okay?
you.
Those two slides are incorrect on the flash drive.
Yeah,
Okay, so we'll switch that.
that was.
Thank you. Yes. What exhibit number is it? Oh. 206, thank you.
Exhibits 206A and B.
All right, Mr. Alessi, whenever you are ready.
Your Honor, if I could have a moment to set up.
Sure.
Morning, Dr. Welcher.
Good morning. We haven't been formally introduced. Your whole name?
Robert Alessi, sir.
Robert Lessie. Nice to meet you.
Nice to meet you. Dr. Welcher, the area in which you engage can also include, and I believe you used the term on direct, forensics, correct? Do you engage in any forensic activity in your profession?
Yes, the general umbrella of you basically coming in and giving scientific evidence in court applies to forensics. So my main job is action reconstruction and biomechanics. And so that's what I do. Sometimes it doesn't involve court. When it goes to court, that's generally forensics.
Right. So you're here today. That is my question. You're here today, at least in part, with regard to forensics, correct? Because forensics is the Latin term for it is basically you're going to have some type of court or jury presentation. It's for the law, correct? Would you agree with that? It's for law, forensics?
I mean, exactly the way you asked that, no. It's for engineering and it's for biomechanics. It's in the court of law, I think is what you're asking.
That's exactly it.
Okay, yes, certainly for the court of law, yes.
It ends up to a court of law, and in forensics is a common term.
Yes, sir.
So it relates to, or it's used in, or it's suitable for a court of law, the analysis. You'd agree with that? It's a general principle?
Yes.
Not a trick question. Okay. And so in forensics, what you're doing, among other things, is you're applying the scientific method and principles in here in a criminal matter, correct?
Yeah, you try and apply as much as possible.
Right. And so the primary goal of forensic science is to uncover the truth and to provide objective evidence that can be presented in court.
That is generally correct. Again, there are elements, for example, this analysis that are relying sort of on subjective evidence, like the testimonial, the witness statements. So it's not solely based, but ideally you'd want it as much as possible based on objective data.
So you would agree that truth and objective evidence is part of the presentation in terms of information for forensics in a court of law?
Certainly objective information. Truth sometimes, again, can be subjective.
Oh, so you don't believe truth? You believe sometimes truth applies and sometimes it doesn't?
If you know for a fact it is true, but if you take someone's deposition testimony, you have to look at it relative to the evidence, and it's either consistent with the evidence or not.
Okay, so now let's go to your direct examination that you just went through.
Please.
Hopefully this is fairly straightforward. You have testified to, and it's varied a bit, a reasonable degree of engineering certainty. Is that correct?
Correct.
You've also, have you used the word sometimes to a reasonable degree of scientific certainty?
I may have.
Right. So
I don't know.
in terms of your role as a biomechanical engineer and accident reconstructionist, is it important to engage in a critical analysis of the data?
Critical analysis? Yeah, I think it's important to have a critical analysis. You want to try and look at it from all sides, consider all possibilities.
So it is therefore important to try to review the data as objectively as possible. You had mentioned sometimes subjectivity comes in, but I understand the goal is to try to look at it as objectively as possible, correct?
Correct.
Now, you stated with respect to your conclusions early on in your direct testimony and your analysis that you don't, and I think I've got it quoted, you don't have a dog in the fight. Is that what you said, sir?
I did.
And that you, quote, don't care, end quote, about the outcome. That's what you made a point of saying in the beginning,
That
correct?
is 100% correct.
Now, you simply follow the data. Is that correct?
I try to do that.
You try to do that.
I'm not perfect. So
Okay.
I do my best. I believe I've done it here.
Okay. So, in terms of you've agreed that you apply the scientific method, so I want to see if you're in agreement generally so the jury can understand what the scientific method is. Are you familiar with NIST, National Institute?
Yes.
Yeah. So would you agree with this definition of the scientific method? The systematic pursuit of knowledge involving the recognition and definition of a problem, the collection of data through observation and experimentation, analysis of the data, the formulation, evaluation, and testing of hypotheses, and where possible, the selection of a final hypothesis. Is that a general fair statement of the scientific method?
So for forensics, you'd have to add in the testimonial evidence aspect of it. So those are testimonial, or things are in evidence. So frequently there's one or two versions, and you're trying to match which version is most consistent with the evidence.
Okay, adding that to what I stated relative to NIST, you would agree that evaluation and testing of hypotheses, and where possible the selection of a final hypothesis, is the scientific method, correct?
Generally, yes.
Is it correct that a proper biomechanical injury analysis utilizes a sound scientific methodology that's been subjected to peer-reviewed and a publication that's been generally accepted in the engineering community?
Well, I can't. So this, I've done my analysis here, biomechanical analysis. I can't submit this analysis to peer review. I'm not allowed to give this to people outside the court. So there would be no way for me to submit my analysis for peer review. So this occurs forensics all the time. The forensic analysis in court generally never goes under a peer review process. The methodologies underneath it, and looking at, like, for example, I think I referenced 25 papers in my report. That goes to the issue of trying to follow the science. 26.
So I think you may have misunderstood my question, sir. I was talking about your methodology, your biomechanical injury methodology. The methodology that you use and apply is to be subject to peer review and general acceptance in the engineering community. Is that correct?
So I have no way of publishing this analysis.
I'm
So
sorry, sure to interrupt you.
I need to.
Go ahead and answer your question.
You're asked peer reviewed, like you said, means I give it to my peers. I send it out to somebody to review for the scientific method. That's what the peer review process is. So I will gladly send this out to peer review with the court's permission, but I haven't and cannot do that.
Sir, my question is not your analysis here in this case.
Oh.
My question regards the methodology that you used here. Is the methodology, you said 26 references, right? My question is simply, is the methodology that you used for your analysis in this matter, is the methodology for a proper biomechanical analysis, should that methodology be generally accepted in the engineering community?
I think with the forensic application, yes.
Okay, that was my question, just the methodology. Thank you.
You're welcome.
Now, the scientific method that you've used in this case, part of the use of scientific method, the purpose is to avoid what is called bias in the scientific method, right? Not cultural bias, but just bias in terms of the application of methodologies and principles. You would agree that's a pretty fundamental purpose of the scientific method, is to avoid biases?
The purpose of the scientific method is to get the most logical and correct answer without bias. Exactly.
To do it apply the scientific method without bias being part of the application of the method, correct?
That's hopefully what you can do.
That's hopefully what you can do. That is the goal, right?
That is one of many goals, yes.
So, are you familiar with the term confirmation bias?
I am.
And that relates, confirmation bias is part of a larger term. Are you familiar with cognitive bias?
Generally, I'm not a human factors expert, though.
Pardon me?
I'm not a human factors expert.
All right, biases are, don't you agree that cognitive biases are not just for one category? You would agree it applies to medical analyses, it applies to doctors doing studies, engineers doing studies, and other scientists doing studies?
I'm not a cognitive expert. I think I would generally agree with it, but I don't want to step out of my lane. I'm not an expert on cognitive. I can talk to you about confirmational bias, if you like.
Let's talk about confirmation bias. Now, confirmation bias is actually when someone selectively gathers and interprets evidence to confirm one or another's beliefs, as well as neglecting evidence that contradicts those beliefs. Is that a fair statement of confirmation bias?
That is a statement. Yeah, it could be broader, but sure.
But you would agree that that is generally correct, what
Generally,
confirmation bias is. And an example of confirmation bias is not considering alternative hypotheses once an initial hypothesis has been selected, even though data and information might contradict the initial hypothesis. Is that an example of confirmation bias?
That could be, yes.
And confirmation bias is antithetical. It's against the scientific method. It's to be avoided, correct?
You would like to avoid it, yes.
Are you familiar with the term failure analysis?
Generally, you might need to define how you're using it for me.
Sure. So is failure analysis the enablement of a scientific examination of an alleged incident by beginning at the undesired consequences? Is that a fair use of that phrase?
I was thinking something different, like a piece of metal failing. I guess it could fall into that category.
Okay. And would you agree that the first question, or one of the first questions that are to be asked by a biomechanical engineer when conducting an analysis of, say, an injury, is how did this happen? Is that one of the first few questions that you ask?
No, that's usually the last question.
Oh, so for you...
So hold on a second.
Okay, I'm sorry.
Generally what you want to do is gather data. You want to know what injuries there are, what evidence there is, like, for example, on the vehicles. And then the very last thing you want to know or define is, given all that information, how did it happen? So that's the end.
I think you may have misunderstood my question, sir. I wasn't talking about the method or the process. I was talking about when you get to answering questions, whenever that is in the process. Isn't one of the questions, and maybe one of the first questions, how did this happen?
No, that's not one of the first questions. One of the first questions is, where's the damage? What are the injuries? What's the evidence? What black box or tech stream data do we have? What physical evidence was at the scene? So that is certainly not one. It is a question, but that question is at or near the end.
Isn't every one of the questions that you just mentioned part of the data gathering?
Correct, but,
Okay.
but when you're gathering data, you're always asking yourself questions along the way, like, what is this? Where did it come from?
But you would agree that for you at least some point, it's how did this happen, correct?
Yes.
And don't you ask that question to come up with hypotheses?
I generally have many working hypotheses as I'm working on the case, and then as the evidence comes in, I'm applying that to my hypotheses and either accepting or rejecting the hypotheses based upon the factual information.
Sir, how then is it just a matter of logic or a syllogism? If you don't ask the question, how did this happen, until the end, how do you then not get your hypotheses up front when, under the scientific method, you should be having different hypotheses up front? How is it that you ask the how did it happen at the end and not go through hypotheses in the beginning? Can you help me with that logic?
Sure, I guess I misunderstood. Like, I was trying to give you an answer to how it happened. So when you're answering how it happened, or you want to be able to answer that question, you want to make sure you've looked at the totality of the data, accepted, rejected, things as they came along, to be able to answer that final question, how did it happen? But along the way, like, for example, a right eye laceration, you want to know how that happened. So you look for the evidence of how that may have happened.
So you would agree then that questions of how it happened, formulating and identifying hypotheses, does and can happen toward the beginning of the analysis. It doesn't happen at the end all the time. Would you agree with that?
So the ultimate question of how did it happen happens at the end. The questions about the elements of what occurred to make it happen, those occur at the beginning, middle, all along the way.
You would agree that creating hypotheses occurs more toward the beginning than toward the end of the analysis. Is that correct?
There are probably more hypotheses in the beginning, but I am continually forming, looking at hypotheses, either accepting or rejecting them upon the evidence.
So you would agree that the creation of hypotheses does occur more toward the beginning of the analysis. You would agree with that?
There are more towards the beginning. The process occurs throughout the whole investigation.
Right. I'm asking about the hypotheses, sir. You would agree that the hypotheses occur more toward the beginning than the end, just the hypotheses.
So I don't know if you and I are saying different things. More hypotheses in the beginning because you have more questions in the beginning. You continue to form hypotheses as the data presents itself, so you don't stop the formation of hypotheses. It's just as you get more evidence, you window down the number of questions.
Maybe I can just this last question to make it clear for you, sir. You would agree, not analysis, which you added, as I heard it to the last part, just hypotheses. You would agree that even though hypotheses can be created and changed perhaps all the way up to the end, you would agree that it's important in the analysis to create at least some hypotheses, plural, in the beginning, correct?
Yes.
I have to say, I don't understand what this guy's deal is. This is something that he does all the time, okay? He is hired by one side and called to testify by one side, which inevitably results in the other side cross-examining him, whether it's a civil or a criminal trial. So why are you over here with an all-day ticket to the struggle bus, bro? Like, you don't understand what homeboy's asking you. Okay, I have a good enough diploma. I've said that 11 billion times. I understand what he's asking you. I feel like you're being deliberately obtuse and you're starting to get on my nerves. All right, let's keep going. I'm sorry I got yelly.
And once you create these hypotheses, would you agree that those hypotheses should be tested?
So if you take the word testing to mean testing compared to testimony, compared to physical evidence, yes.
And when you test those hypotheses, isn't it often the case that, particularly in your line of work, the one that most consistently produces the same injury will emerge as the mechanism of injury?
I guess it depends on the scientific evidence behind it. Again, sometimes we get very unique injuries.
So my question, sir, is this. Isn't it the case that when you have multiple hypotheses, the one that most, out of all of them, it's a relative thing, the one that most consistently produces the same injury emerges as the mechanism of injury? Is that a fair statement?
I think generally, again, it's on a case-by-case basis. You have to look at the science and the facts of what you're basing it upon.
I think that's what he's asking you. Jesus, Mary, and Joseph, all the saints, for the love of Pete. And why are you writing things? Is that even allowed?
I think as a general premise, what you're saying is accurate,
Okay,
but there's exceptions.
fair enough. But as a general principle,
Sure.
with some exceptions, that's a fair statement, correct?
Yes, sir.
We're going to have several topics, sir, and what I'm going to try to do to make it a little clear is I'm going to say when I'm switching topics.
Oh, good.
So what I'd like to do now is switch topics.
Okay.
You're aware that the Massachusetts State Police has troopers who specialize in accident reconstruction, correct?
Yes.
And there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section whose sole responsibility is to engage in accident reconstruction. Do you know that?
I do not know that.
Do you know that there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section who engage in accident reconstruction?
Just based on what I've seen in this case.
Right. Based upon what you've seen in the case, that's a fair statement.
And I just know that those people are doing it.
Are you familiar with a Massachusetts State Trooper named Joseph Paul, P-A-U-L?
Yes.
And you
Well,
know...
I'm familiar with his reports. I don't know the man.
Okay. Familiar with Trooper Paul through his reports in this case, correct?
Correct.
And are you aware that he was assigned by lead investigator, former Trooper Michael Proctor, to be constructionist in this case on January 29th of 2022, as evidenced by that report or those reports of Trooper Paul? Do you know that?
Well, you put a lot of things in there. I know he issued a reconstruction report. I don't know who told him to do it. So the first party question, I don't know, but I did see a reconstruction report from him.
You were retained, and so do you recall, is it the date, January 29th of 2022, is that a rough time period of him being assigned, or you don't know when he was assigned?
Don't know. That might have been in his report, but I wouldn't have paid attention to when he received an assignment.
Do you know when, the date of the first report of Trooper Joseph Paul in this case?
I can pull it up. I do not know off the top of my head.
You know that the date of the incident in question is January 29th, 2022, correct?
Correct.
Yet your firm and you were retained for this case by the Commonwealth 2.5 years after the incident in question. You were retained, your firm, on September 23rd, 2024. Is that correct, sir?
No, I believe we were retained a couple days before that.
A couple days. Okay.
Correct.
So
Actually, I might be able to find out if you'd like me to look at the documents.
it's not all that important. You would say it's within a week of September 23rd, 2000. It was in September of 2024?
I believe it was in September, yes.
Right.
I would
So-
want to double check.
That's 2.5 years from the date of the incident in question, if I did the math right, correct?
No, I never thought about it. Yeah, approximately.
And as we just discussed, and you stated on your direct examination, you have no dog in this fight, correct?
Correct?
On November 5th of 2024, your firm Aperture was paid $44,500 by the Norfolk County District Attorney's Office to conduct work that was at least similar to the work of Trooper Paul, correct?
I have no idea. I don't get the billing or the statements.
Do you recall whether Aperture has, well, do you believe Aperture is working for free in this matter?
Oh, no, I don't believe that. No,
So you
we're an
would-
engineering company. We bill for our time.
So you know that Aperture is getting paid for its work in this case, correct?
We are billing for our analysis work.
Well, you're not just billing, you're billing and getting paid, correct?
So I have not seen any of the payments. I would assume that we're getting paid, but I don't know that.
Sir, you are a senior vice president of Aperture, are you not?
I am?
You would know, wouldn't you, if your firm was not getting paid for work since September 23rd of 2024, wouldn't you?
No, probably not. Usually it takes, 9, 10, 12 months of not getting paid before the accounting department reaches out to me.
Exactly. So you've been on this for 2.5 years. So if it would take 9 months or 12 months, if you weren't getting paid, you would have been notified by that by now, correct? According to your own answer you just gave.
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's, what, less than a year ago.
Understood. I'm moving on to the next question because I want to move away from that discussion and just
Okay.
go right to the bill. You, as you sit here today, do not have a recollection of whether Aperture has been paid. Is that your testimony?
It has nothing to do with recollection. I'm not part of that process. We have an accounting department. I don't have any involvement in that.
Did you hold
Are
on a minute?
you-
Okay, let me just streamline this for you, buddy. Did you get paid from your company, from Aperture, for the work that you did on this case? Jeez, come on.
So is your testimony you have no knowledge about any contractual relationship between Aperture and the Commonwealth?
Oh, no. I was sent a contract by the Commonwealth to sign, so I'm aware of the contractual agreement, but the day-to-day or month-to-month invoicing and billing, I'm not involved in that.
Okay, so you're aware there's a contract between Aperture and the Commonwealth,
I signed it.
and you signed it. And wasn't that contract obligating the Commonwealth to pay for the services of Aperture? Isn't that the purpose of the contract, in part?
In part, sure.
Yeah, it's a legal obligation of the Commonwealth. Your firm does work, and the Commonwealth pays for it, correct?
That's the idea.
Right, and so you know about that contract because you signed it.
Correct.
Also, you testified on direct that there was a purchase of a Lexus exemplar for your testing.
Correct.
Who pays for that Lexus exemplar?
Aperture?
And is that then cost passed on to the Commonwealth?
No.
So you pay for the Lexus, you don't pass that cost on, correct?
So what we're doing is we paid for the Lexus, we're keeping it till the trial's over, we're selling it and charging the Commonwealth the difference in the price.
Wait, back the milk truck. So now you know about the billing? Now you're aware of that? Now you understand how it works? See? This is why this is the whole problem with the Commonwealth's witnesses in this aspect. They say they don't know things, and then they get another question, and all of a sudden they know all of the things. Bruh, get out of here. Now you're Susan from accounting. Shut up.
Exactly. That was where I was going, sir. So,
But they're only paying the difference. So, and in theory, if we sell it for more in California, then we'll reduce the bill.
okay, I don't want to speculate. I just wanted to see what the obligation was. So
The
if
obligation is the difference.
exactly. So the obligation is the difference.
So you're aware of the obligation. You're aware of the billing. You're aware of the payment. See? Man, get out of here.
Are you aware that on April 5th, 2025, the Norfolk County District Attorney's Office amended your contract? Are you aware of that, sir?
I am.
And isn't it the case that that amendment authorized the amount of $325,000 to be paid to Aperture? Isn't that what that amendment contract states?
I believe that's correct.
So the Commonwealth is obligated to pay at least $325,000, and is that correct?
That is you're asking me a legal opinion now about a contract. That is my understanding of how contracts work, but I'm certainly not an attorney.
And on top of that, are you aware that Aperture has been already paid $44,510 for its work? Are you aware of that?
The second time you asked me, no, I'm not aware of anything we've been paid.
And as you stated yourself, those amounts reflect, as you say, less than 6 months worth of work?
That's not what I said.
Well, no, my question is, you've been on the case, you said, since September of 2024, when we were talking about dates. You said that was about 6 months that your firm's been retained. Did I have your answer correct about how long you've been on it?
I guess it's closer to 8 months.
All right, so 8 months. So for 8 months of work, about $400,000. Is that correct?
So there's 3 offices working on the case. There's the Boston office, there's Mr. Burgess's office,
We
and
don't-
there's my office in
Look.
Long Beach.
Look here. Oh, you in the LBC? Say hi to Snoop for me. Look here. We don't give a rat's fat kneecap how many offices are working on it. The question is the question. Is Aperture the company getting paid? And the answer is yes. It's that simple. And the more you try to explain it and it comes across as justification and it looks bad. Bruh.
I only know about the billing from my office.
But you signed the contract on behalf of all of Aperture, not just your office, correct?
That I don't know, but I definitely did sign a contract.
Would it refresh your
Yeah,
recollection is to...
Hold the phone. Hold the phone. You signed something you ain't know what you signed? You didn't read it? Oh my God.
Who you signed the contract on behalf of, whether it's all of Aperture in all offices, if I showed you the contract.
Sure.
May I put you on it?
Yes.
Canton Fire Department, this is why y'all are rolling around House Half Acre with windshield wipers that are 7
Yeah,
years
could you
old.
direct me so we're not wasting time?
Well, it's your, what I'd like to do, with the witness, Your Honor, is just ask the witness a question with regard to it.
Why don't you just take a look at that, Dr. Burgess?
Thank you, Your Honor.
That seems to be the company policy, Violet. He skimmed it. Get out of here. This is ridiculous.
And then when he's done, Mr. Alessi, you can take it back to the podium.
Yes, Your Honor, thank you.
You should have read this contract more like you're doing right now. Before you signed it, homeboy.
Can I have a few more questions before I do that, Your Honor, for foundation purposes, if I want to do more than refresh?
All
Or
right.
would you like me to start with
So-
refresh?
Go ahead and start with refresh. Go back to the podium, please.
Sure.
Thank you.
Thank you, Your Honor.
Judge Bev, are you struggling to get your
Dr.
arm on the
Walter, does that
armrest?
refresh
Hold on a
your-
minute. Hold on a minute. Let's go back and look at Judge Bev. Judge Bev, what are you doing up there? You having an issue? Did the armrest move on you? Did it surprise you there, Shug? Watch
Go
this.
ahead and
Look
start
at her.
with refresh. Go back to the podium, please.
Sure.
Thank you.
Whoa,
Thank you.
whoa, whoa. Stop it, Bev.
Dr. Welcher, does that refresh your recollection as to the contract you signed on behalf of Aperture with the Commonwealth?
So it lists the legal address as my office. So for my office, yes.
So are you saying that therefore, and did you see the amount that was in the contract? Did that refresh your recollection?
Oh, no, I didn't even look at that.
Oh, of course not. Why would
you
you do
recall-
that? By the way, to this comment here, Bev is undressing Alessi in her mind. It's very clear that Mr. Alessi has given Judge Bev the vapors. Oh my. Let's keep going.
The amount that of obligation that the contract relates to in this document. Do you recall that?
You just asked me that earlier, and I'm taking what you said to be true. So I was like $325,000. I have no reason to disbelieve that.
And is there also a total, do you recall the total maximum obligation for the contract that's listed in the contract? Do you
No.
recall it? May I approach, Your Honor?
Okay.
And
Look
Dr.
here,
Welcher,
Dr.
I'm now
Welcher,
going
you
to-
finna get a
you asked me Last
refreshed.
time, I hope this is helpful.
Please.
You said please point to the applicable part so we can do it faster. I am now pointing to that part and see if you can just look at that and see whether this refreshes your recollection on the maximum obligation of the contract pursuant to this contract. Without saying what it is, just does it refresh your recollection?
No, but I don't have any reason to believe it's not correct. And that is my signature on it.
Oh, Jesus. You finna be refreshed within an inch of your life. Oh my
And-
God.
We got started on this conversation tying it to, well, we got started on this conversation with regard to a statement you made earlier in your direct that you didn't have any dog in the hunt. You recall that statement in the beginning of your direct testimony.
You misquoted me. I don't have any dog in the fight.
You don't have any dog in the fight.
Correct.
Thank you. Now, switching topics.
Okay.
Hey,
You
Nicholas.
submitted-
Hold on.
And
I need to be doing what Nicholas is doing, a 5-mile walk. I appreciate you being here while you're doing your walk and listening. Thank you so much for that. That's what my trouble ass needs to be doing, getting out there and walking. That's why I had the trouble.
updated PowerPoint presentation, the one that you went over on your direct examination, you created that presentation quite recently, correct, sir?
The updated one was where I had redacted or taken out slides. So in terms of taking out slides, I did add one alternative path a couple weeks ago.
Okay, my question, sir, is this. The updated presentation, we'll get to the changes later, but the updated presentation, you created just how many days ago?
I'm going to say weeks ago.
Weeks? 2 weeks?
I don't actually know without looking at the documents.
Well, was it more than 3 weeks ago that you created it?
I still don't know without looking at the documents.
Do you know when the trial started in this matter, sir?
I do not.
Assume the trial started approximately April 22nd of 2024.
Okay.
Did you create your updated presentation before or after April 22nd of 2024?
I don't know.
Do you know when?
Hold on one second. Dr. Welch, I'd ask that you not do
Not look at,
anything.
okay, I was going to try and answer his question. My apologies. I will shut it down.
Thank you.
You're welcome.
If I may, Your Honor,
Yes.
thank you. Are you able to determine when you created the updated presentation?
I think so. That's what I was attempting to
Your
do.
Honor, may he do that?
Yes, I'm going to see counsel at Sidebar while you pull that up,
Thank you,
please.
Your Honor.
Oh, Bev is getting testy. She wants to see them at Sidebar because it's 11:13 a.m. and it's time for the morning break. Bev needs to go and smoke a pack of Misties right quick. Lord Jesus. In the meantime, I want to show you something that Tess sent me. Give me just a second, right quick. What are you doing, Bindi? Pay attention. All right. Also, Kristen, if you're listening, I did email you, babe. All right. So, y'all ready for this? This is some effery right here. This is a motion filed by the Commonwealth. All right. A motion to preclude the attempted use of any information not produced in violation of Rule 14. It goes as follows. Both the Commonwealth and defense are bound by Rule 14 obligations. During the course of this trial, notably during Shannon, which they typed it with 2 N's. It's only 1 N. Come on, Brennan. Burgess's testimony. The defense presented documents that were not previously provided, which eliminated the ability to review and vet the documents. Well, you should have reviewed and vetted your witness, Hank. Notably, the defense presented a CV provided in 2023 that noted a graduation date of 2024. The effort of providing documents as a witness is being confronted with documents is improper, trial by ambush, a violation of Rule 14, and creates needless delay, resulting in objections, unnecessary sidebars, and a waste of time for the jury. The Commonwealth seeks a ruling precluding the use of any materials that were not noticed by the defense other than materials in the witness's CV.
Welch, what I'm going to ask you to do is get whatever information you need for Mr. Alessi's last.
Excuse me, Bev. The Commonwealth seeks a ruling precluding the use of any materials that were not noticed by the defense other than materials in this witness's CV referred to during presentation or discussed during testimony. Get out of here. Ridiculous. No. And if it gets ruled that, and if Judge Bev allows that, that is absolute, I'm going to be mad, super duper ultra poppycock, because look here. These were submitted. His CV was submitted. It's not the defense's fault that you didn't vet your own witness, Hank. And now you want some type of curative measure. It's too late, homeboy.
Going to ask you to do is get whatever information you need for Mr. Alessi's last question. Mr. Alessi, I need you over there. So,
Yep.
and
I need
once
you.
get that answer, I'm going to ask you to shut your computer down, or at least put down the cover. Thank you.
Close it.
All right, so you can answer Mr. Alessi's question.
Thank you, Your Honor.
Could you give me the question again, please?
Yes. When did you create the updated presentation that you reviewed in your direct testimony?
So that addition I made was taken out. It wasn't in my direct
Sir,
testimony.
If you can just hear my question, it's this. The version of the presentation that you put on the screen, when did you create that version? I'm just looking for a date.
So to answer your question about the version on the screen, I created that yesterday when the judge asked me to take off some of the headers. So yesterday.
Okay, good. Now, the version before that you created yesterday, when did you create that version?
The day before.
And then the version before that one, when did you create that?
I mean, I save it every day.
Understood.
So every day.
So you've changed the presentation every day since when?
No, I don't think I've changed the presentation every day.
That's my question.
That's what
My
he's
question
asked.
is,
Oh
how
my
many times have
God. Look, get the crayons, Alessi, get the crayons, because even though he's a doctor, meaning he has a doctorate, right? These basic ass questions are just too difficult. Even though it's his presentation, he created it, and you're being very straightforward. I understand these questions. And again, I must remind the audience who's listening, I have my GED, AKA good enough diploma, and I'm able to follow along. Dr. Welcher, you need to get right or you're going to get left, okay? I'm over it.
changed it within the last 2 weeks, your presentation?
Let me try and cut to the chase here.
Sure.
That slide was added on May 13th, and then it was taken out before I presented it here. So it was not in my presentation here.
Right. So thank you for that answer. So
You're
here's
welcome.
the question. Your first version, as I understand it, of the slide presentation was January 30th, 2025. Is that correct?
Correct.
When was the next time after January 30th, 2025 that you changed that presentation?
May 13th.
May 13th, in the middle of the damn ass trial. Let me just give me a minute, please.
I am so tired of you.
I'm over it, bro. Let me just be quiet. Let me just walk away because I can feel myself getting out of control. I can feel the yelling. The yelly voice is about to, it's right at the surface. It's about to come out, and I don't want to do that to y'all. So let me just shush. BRB.
Assuming the trial started April 22nd of 2025, you changed your PowerPoint presentation during this trial, correct?
Correct.
And how many times did you change your presentation after April 22nd of 2025?
Well, the last time I changed it was like 10 minutes ago. So in response to various discussions, I've been making continuous changes to it.
I want to make sure you finish your answer so I didn't interrupt.
No,
you.
I'm not sure how much granularity you want to that answer.
Great. So you created on January 30th, 2025. You made your
13th.
Pardon me?
Oh, no, the original one. Sorry,
Yeah.
January 30th, modified May 13th.
Right. If I could finish my question, and I might be able to shortcut this. Thank you. So you created the original one on January 30th, 2025. You made your first amendment May 13th of 2025. And then before you sat for your testimony, which was yesterday, correct? That was the first time you sat for your testimony.
That is correct. I was here yesterday.
Days get foggy when we're in a courtroom, but it was yesterday. How many times had you changed your presentation from January 30th, 2025 until when you first walked in the courthouse yesterday?
Do you mind if I count?
Not at all.
So there was the May 13th change. Half of that was in response to objections from the defense. I had to add all the paths to where everything was. Then when I got out here, Mr. Brandon asked me to take out references to evidence about statements that I was not allowed to present. So that would have been within the last 3 days. And then I've modified it a couple times today based on rulings from the judge.
Okay, let's break that down. You said half of the changes you made on May 13th related to what? Because I want to know about the other half.
Sure, there was two changes. I added the extra path of 138, and then I was told that the defense was having problems with my PowerPoint, so I had to go in and add the paths to every single slide about where the evidence came from, because they were saying I didn't provide everything, and I had provided everything.
All right. So
That was the second half.
got it. I want to go to the first half, sir.
Sure.
And I'm going to try to shortcut this.
Please.
And if I'm not clear, you just let me know. I want to talk about the first half. You called it, I didn't hear it. It was like, did you say path?
Path.
P-A-T-H?
Correct. The path Miss Reed was driving.
Right. What you made the change for May 13th, that first half, that wasn't something that was triggered by the defense. That was something irrespective of the defense, correct?
It was based upon her statements. Is she part of the defense?
All right, so that's what I wanted to get to. You changed the first half based upon statements you allege that Ms. Reed made. Is that correct?
It's because I changed one slide. There was 130 slides originally, or something like that. So half of the changes on that day, which was one slide, I added one line to the bottom of the previous slide.
Did you consider that change significant?
No.
Well, then why did you make it in the middle of trial if it wasn't significant? Why didn't you just leave it off and then discuss it in terms of testimony?
So, A, it ultimately was left off. B, because it was insignificant and I didn't need to have it. So the way it got presented was exactly the way it was before May 13th. So it didn't change anything.
But it was significant enough for you to make a change to your presentation, correct?
So my goal is to be as accurate as possible. So when I saw the path that I gave, the way she could drive, I gave the possible paths. That was one of the possible paths that hadn't originally been included. So in striving to be as accurate as possible, including as much information as I could, I wanted to make sure I included that.
So you were striving. The clip that you used to make the change, you say you made the change based upon a clip you observed with regard to Ms. Reed. Is that correct?
I believe that, yes, that is correct.
Do you know that clip has been in existence for months?
I don't believe I got it until April.
So a clip that has been, assume the clip's been in existence for months. You just got the clip.
Dr. Welch, I have to ask you
Oh, I'm
not to
sorry.
refer to
I'm
that.
trying to be helpful.
Close your
Yeah,
computer
let me
and-
close it. Sorry. I was trying to answer his question.
So I'm going to ask you to close the top.
Yeah, that's probably a good idea.
Just flat down. Thank you.
Thank you, Your Honor. So assume the clip that you said was the basis for changing your PowerPoint on May 13th after the trial started had been in existence for months. You just got that clip, you say, in April?
I believe so, yes.
What was the tell me the circumstances by which...
Okay, so Little Red says that should be precluded. It was changed during the trial. Strike it. It was precluded. It wasn't presented to the jury. But is the way that I'm understanding. But it is representative of the work that he, as a representative of Aperture LLC, did with respect to this case. And it further bolsters the cross-examination where Shannon one N, Mr. Hank Brennan, it's Shannon's name only has one N, sir. You might be more careful next time you're, making a filing, number one. And number two, you better make sure that you spelled it correctly when you put a stop payment on that check. Just saying. So it is symbolic of the type of work that they were doing and when they were doing it and the changes that they were making, whether they presented it to the jury or not. They tried to he didn't know that it was going to be precluded. He thought it would be included. And that's why he did it. Based on what Tess says also, hold on, that he changed it because of Ian Whiffen, not what Karen said in an old interview. That's the point. It's significant because what he's doing is, like I said, being contacted by the Commonwealth. Both Burgess and Welcher have testified that Hank Brennan contacted them during the effing trial. Because they wanted to get it in. But because of the way it was done, it was not in. It was not allowed in.
You got the clip. Did you ask for it?
I was told there was a new interview.
Okay. Who initiated the conversation about the new interview?
I don't know if it was Mr. Brennan.
It was someone associated with the prosecution?
Yes, I wouldn't have known about it.
Exactly. So somebody affirmatively communicated with you when about this clip?
I need to look, but I remember it being about mid-April,
Mid-April.
if I'm thinking of the correct clip.
What were you asked to do, if anything, with regard to that clip?
When I got the clip, I wasn't asked to do anything.
What did you do with the clip once you got it?
So they then indicated there was this suggestion of an alternative route. So then I looked at the alternative route description and added the alternative route.
So it was suggested to you by the prosecution that you look at the clip and they pointed out that there was an alternative route they wanted you to look at?
So I took it to be, we have additional evidence. Please look at the additional evidence and add it to your analysis.
And there it is. Please look at this clip and add it to your analysis. Okay? A clip that by the rules of evidence, the Commonwealth would have had to disclose way early on, okay, that they intended to use, that there were hearings about what could come in as evidence, what couldn't, but they waited until the trial had already started to contact homeboy over here and have him amend his presentation. That's it. That's all. I'm over it. This is ridiculous. I need to step away.
On the topic of additional analysis by Aperture, while this trial is going on, are you aware of Mr. Burgess submitting a report dated May 8th of 2025 in this case?
Yes, I received that report on May 8th.
Right. And so you were aware of the creation of that report on May 8th because you got a copy of it, right?
Correct.
Were you aware that Mr. Burgess was intending to submit that May 8th report to the Commonwealth?
Yes, we had a discussion before that he had found new information that changed the timing.
And there it is
So
again.
he had found new information. What is your basis for saying he found new information as opposed to the information always existed, it's just it was pointed out to him that that should be looked at? What's the basis of your understanding that he found new information?
Objection to the question.
I'm going to allow the question, but you have to ask it differently. Mr.
I will,
Burgess.
Your Honor. Thank you.
Well,
What is
okay, you're going to allow the question, but you have to ask it differently. That means you're not allowing that exact question if you want him to change it to a different question. Judge Bev.
the basis for the statement you made that Mr. Burgess found new information?
I guess it was his meeting in our discussions. He indicated that he had found new information.
Did you ask him, what do you mean by new?
No, I took it at what it said.
So do you, as you sit here today, have any basis to say that that information is new as opposed to it's always been in existence?
Yes,
What is that?
what he told me.
Oh, so you relied upon the representation of Mr. Burgess. You didn't have any independent document to determine whether, in fact, it was new.
I don't quite frankly care whether it's new or not. I just care what's in the data. Whether it's new, old, I don't care. It's not relevant to what I'm doing. I don't say this is new data, this is old data. I just care what the data is.
Sir, has Aperture ever submitted a report, a changed report in the middle of a trial to your knowledge?
I have no idea.
Do you know whether Aperture has ever submitted an amended report in the middle of a trial? You said you testified in federal and state courts. Can you recall one instance where Aperture has submitted an amended report in the middle of a trial?
So Aperture is like 290 people. I can only speak for myself.
Then speak for yourself, bro. Speak for yourself. Is this something that you commonly do?
I have certainly done amended analysis. Only certain courts and certain legal systems require reports. But for example, rebuttal, analyzing testimony that comes up in court, getting trial transcripts. I very frequently have come up with new analysis during the trial.
Sir, my question is, as you sit here now, can you state one court case where you or Aperture has submitted an amended report in the middle of a trial?
I cannot speak for Aperture. I can only speak for myself.
Can you answer? Oh, speak for yourself, sir. Can you then, for yourself, recall any instance where you submitted an amended report in the middle of a trial?
Amended reports? No. Amended analysis? Yes.
Thank you.
You're welcome.
Mr. Alessi, is this a good time for a break or
It-
5 more minutes?
It's a good time, Your Honor.
Okay. All right, folks, why don't we take our morning recess again? Dr. Welch, you can right behind.
Great. Love to use the restroom.
Oh my God. I bet you need to use the restroom. You getting some tummy troubles, bro? This is just, I can't even believe that this is happening. Honestly, this is ridiculous, you guys. Absolutely freaking ridiculous. The fact that I don't even, this is so like, this just makes my brain hurt. We don't need to highlight the OnlyFan, although the OnlyFan is the only thing in that courtroom aside from the defense that's, operating full transparency. My God, this is absolutely unbelievable. Unbelievable. Are you going to be adjusting your presentation again while you're in the bathroom? I mean, hold on a second. Let's see. Skip forward a little bit. See if we. Come on. All right, they're still on a short break. This is embarrassing. This is embarrassing. And not only that, look at the money that this company has been paid, and this is what they bring to the table. Poppycock and dirty pool. Are you kidding me? If I were the citizens of this county, I would be demanding a refund and punitive damages so that the Canton Fire Department can get windshield wipers that were made during this century that actually work, so that their paramedics and their firefighters don't need to take notes on their gloves, that they can have a pen and a pad of paper, for Pete's sake, so that the Canton Police Department can have better, they don't have to use Stop and Shop bags to collect, to hold evidence, and they don't need to use red Solo cups from the neighbor. I mean, that's like something you see on Friday. It's like when Felicia wanted to borrow Craig's VCR right quick. You got the police department going across the street to borrow something to collect evidence in red Solo cups. And they didn't even bother to say, hey, you know what? We're collecting something that is frozen now, but with any level of temperature change will then become liquidy. Okay, maybe we should get some saran wrap or some press and seal or some foil, something. But nope. And again, you know, he's saying, "Oh, well, it wasn't significant." Then why bother to do the work in the first place? Why bother to take a look at her statement? Let's take his testimony about why he did what he did when he did it at face value. All right, let's say that he was sent a clip from something that Karen Reed had said months and months ago in an interview with Dateline. Okay, let's pretend that that's what happened. All right. Then, so you do that, right? You look at you look at the clip, then you create an alternate path for, and you don't think that means anything. You don't, if it's not significant and it doesn't change anything, why bother to do the work in the first place? Why? I'll tell you why. Because I think it's interesting you call it insignificant, because truthfully, at the end of the day, it is insignificant. It matters not, because this Commonwealth has failed to prove that John O'Keefe died as a result of being struck by a vehicle, let alone Karen's vehicle, let alone Karen Reed driving that vehicle. All right. But I digress. Okay. You did the work because you were asked and told to do the work, which you did. You changed your presentation based on what you were asked to do, because because Brennan thought he was going to be able to get it in and you were going to be able to testify about it. That's it. That's all. That's the truth of the matter. Okay. And while Brennan is over here, contacting their expert witnesses and having them reanalyze to analyze another analysis of somebody else's work, and then amending their reports, Burgess, then amending their slideshow, Welcher. He's accusing the defense of just being dirty all the way around. But he's what they say about the guilty dog barking the loudest. And by the way, I find this witness's use of the term, "I have no dog in this fight," quite interesting, since it's widely suspected. I think that it's what happened, but for the purposes of this discussion, most people are leaning towards the injuries on Mr. O'Keefe's arm having come from a dog and him also having been in a fight. Get out of here, bro. Ridiculous. Absolutely. I cannot even believe this is just, is this real life? I've never, ever seen anything like this. Yeah, that's not true. That's not true. I have. Only one other time. You guys can guess the case. Which, by the way, I am working every spare moment that I have. I'm working diligently to get those, the new and improved West Memphis 3 episodes out for you guys. Okay. With bonus content being on Patreon. I don't like doing it. I feel a little guilty putting some of the bonus content on Patreon, but it's not like it's going to be 2 or 3 seconds of bonus content. Like, it's a lot. And some of it I feel like might not be appropriate for YouTube. You know, I got to follow terms of service. It is what it is. So there you have it. Yeah, but that's the only other time I've seen this level of effery in a trial. Okay. And at the end of the day, I'm just so, I don't even know what to say. I'm at such a loss of words and adjectives to describe what's going on here and my level of frustration with what's going on here. I cannot wrap my brain around this. You know, I really cannot. I cannot understand how anybody with a reasonable level of intelligence could think that doing things this way is a good idea. Like, I've had a lot of ideas in my brain over my lifetime, okay? And I typically run through the if then but clauses, okay? The flow chart in my brain. And let me just say this. I have not followed through on many ideas because they simply didn't make the cut. After going through the flow chart in my brain, they turned out not to be good ideas. Absolutely neat. That's fine, babe. I don't understand how people who this is their job are trials, okay? and they think this is a good idea. They think that these conversations aren't going to come out. That the defense isn't going to notice that stuff was changed or amended, which, by the way, over here with your doctorate, Dr. Welcher, amended and changed are synonyms. They're not antonyms. Okay. Like, what in the actual F is happening? You're seriously fixing your mouth to argue what the meaning of is. Are you kidding me? I can't. A lot. Tosh says, how many times has this man claimed to have testified? A lot. Multiple times. So he should know better. Lord. Thank you, Violet. This is it right here. Let's streamline this and bottom line it. This is perfection. Violet says, yes, it's like deciding on bangs. I can't pull it off, so it's a bad idea. The Commonwealth goes full bangs, and they do that mistake because they want the fringe bangs. So they do the twist and they hold the scissors too high. And then when they let go and it untwists, they have a mess. That's this. That is what this is. And Kayleen, how you doing, bud? It's good to see you. Happy for you to be here. I'm happy for all of you guys to be here, but this is what's happening, okay? This is what's happening. Oh, awesome. It's about time. I'm glad. Yeah. And check out Boho Hobo's channel, About Time. Or It's About Time. Thank you, Neat, for putting the link in the chat. Yeah, I mean, look. I can't wear bangs either, and here's why. As you can see from my profile picture, I've got a 5 head at least. It's probably more like a 6 or a 7 head. My kids give me a rash of shit about it all the time. I got a big forehead. It is what it is. This is how I was born, okay? And usually when you have a big forehead, bangs are an option, okay? But due to the hair, the kind of hair that I have, which has curl to it, bangs are not an option. And alternately, I don't know if you can tell in the profile picture, but even though I have a big forehead, I actually have a small face. So while bangs would be nice to cover the forehead, even if I had there's too much curl to it to do it. But let's say I didn't have too much curl and I had the type of hair that you could cut into bangs. My face is too small. So, and I've had bangs before. So if my face, so all it does is make my face look even tinier. And on top of all of that, okay, if I gain any weight, I also have a small head, okay? And if I gain too much weight, okay, I look like a turtle. I have a tiny head on a big body. This is why I'm constantly stressing over the trouble level. I cannot allow the trouble to get out of control because then I'll go around looking like a turtle. Okay. So I know these things about myself. All right. And that's why when delicious snacks are offered at times, I have to say, I run through the if then but clauses in my brain and I say, sounds delicious, really want to, not a good idea. Okay. Please, somebody from the Commonwealth, hear what I just, that whole rant that I just went on, okay? And learn to do a little if then but clauses in your brain, okay? Run through it. Run through it multiple times, okay? And how many times are you going to pull some shady malarkey? And what are y'all doing? Like crossing your fingers and hoping, please, 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 please don't let Mr. Alessi or anybody from the defense catch this. Please, 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 please. Like you think you're going to will it into existence by doing that? You know he's going to catch it. You should operate under the assumption that Mr. Alessi misses nothing. And it's really not an assumption because at the end of the day, he keeps proving that he misses nothing ever. The man is the king of all the details, all the details. Turtles are cute, Chief. However, they should be, turtles look cute as turtles. Bindi does not look cute as a turtle. She just doesn't, okay? It's not good for me. It's not. It's not good for me to look like a turtle. It's not cute at all. See, Rachel gets it. Rachel says, I have a small head too, Bendy, apparently. According to my quote unquote friends, I also have to be careful. Yes. Yes. I feel you. Look, I've lived with this. I've lived with this brand that is me my whole life. Okay. At this point in time, and now that I'm, at this stage in the game, at the age that I am, I understand. I get it. I know. I know what's good. I know what fits, what doesn't, what looks good on me, what doesn't look good on me. And look, at the end of the day, I got to dress for the body I got, not the body I want. Oh, here comes Judge Bev. By the way, Judge Bev has already annoyed this morning. Her sigh meter, the amount of sighs that she's done this morning is off the charts. Me too, Sissy's mom. Every time I hear turtle, I think of Dana Carvey in Master of Disguise. Am I not turtly enough for the turtle club?
All right, whenever you're ready, Mr. Lessie.
Thank you, Your Honor, and if I could please address an administrative matter that I wish I didn't have to address. Dr. Welcher was just using, at least my observation, his computer. He still has monitors on his desk. Could we have all that removed, Your Honor?
It was
Closed, yes.
Would he open?
So did you just turn it off?
No, but I will. I closed it.
Look,
You want the computer all the way off or just?
I want you to look, at this point, you've proven that you cannot be trusted, that you're going to peek. Take the stuff away. He's like a toddler, Judge Bev. You've asked him to to keep it closed, not to look at it repeatedly, and yet he can't seem to follow that very simple instruction. So take it away. Just take it away.
Just everything.
Is he going to need to turn his computer back on?
I do not see a need for the computer to be turned on. Do we have the ability to put the presentation and documents from our
So I'm going to see counsel at Sidebar,
Sure.
please.
Why do you need to see counsel at Sidebar, Judge Bev? You've asked the witness at least twice, maybe even 3 times. I don't know. I lost count because sometimes I get annoyed. Not to look at the computer. Okay? It continues to be an issue. Just take it away. I mean, for real, take it away. He doesn't need it. It's not going to be used. Mr. W over here, that I forget how you pronounce his last name, and so I don't want to mispronounce it. He's quite adept at running the presentations.
Remove those monitors, okay?
I'm sorry?
During the lunch break, I know it takes you a while to set up in the
Yeah.
morning. I'm going to ask you to take all that down during the lunch break, okay? Thank you.
May I, Your Honor?
Yes.
Thank you. Dr. Welcher, we left talking about the amendments you made to your PowerPoint presentation. And in terms of the amendments, are you aware that the defense counsel received your amended PowerPoint presentation at 3 p.m. on Memorial Day? Are you aware of that?
No.
And you began testifying the day after yesterday, correct, sir? Day after Memorial Day?
I testified yesterday.
Yes. Are you aware of any activity in this trial of any kind before you testified yesterday?
Again, as I mentioned, I've been getting random emails, and then I've been seeing it pop up on my news feeds as well. But once I was aware of the reclusion, I made sure to not review any of that. But as recently as last night, I got an email that said biomechanical engineering job, or like applying for a job, and I opened it up and it was some internet troll.
Sure. I'm asking about emails from the prosecution.
Oh, no, there's been no emails about what's been going. I mean, there's been scheduling, you know, when am I going to come, things like that.
How then was it determined that you were going to be able to amend your power presentation if you weren't communicating with the prosecution?
I mean, they asked me about the witness statement of 138 right around May 13th.
How did they ask you about that, sir?
I don't recall if it was a Zoom meeting, a phone call.
So there was a communication with the prosecution. Might have been by Zoom, might have been by another method, but there were communications while this trial is going on relative to you amending your PowerPoint that ended up with an amended PowerPoint on May 13th. Do I have that correct?
I believe so.
I'm going to switch topics.
Okay.
One of the goals of Aperture's analysis and reconstruction was to determine the location and timing of certain text stream events, correct?
Correct.
EDR data.
I'm sorry, my role.
Your role, yes. EDR, and just for clarification, EDR is Event Data Recorder, correct?
Correct.
So I'm going to refer to that, as you have before, as EDR, Event Data Recorder.
Sounds good.
EDR data does not show the location associated with a text stream event, correct?
In this particular vehicle, it does not.
And the EDR data for this particular vehicle, namely the Lexus SUV, also does not provide the time associated with a text stream event, correct?
Not at the time of this event.
So the answer is no, correct?
That is not correct.
So let me ask the question slightly different way. The EDR data does not provide the time. The EDR data for the Lexus SUV that you've been talking about does not provide the time associated with a text stream event, correct?
That is correct.
Instead, every text stream event is associated with a particular key cycle on the vehicle, right?
Correct.
There can be multiple text stream events in a single key cycle, right?
Correct.
And every time you start the car, this one you push the button, that's a new key cycle, right?
That will cause a key cycle.
And the EDR data indicates the number of seconds into the key cycle that the particular event occurred, correct?
The EDR data, no.
So EDR data gives you no information about the number of seconds into the key cycle that a particular event occurred.
You're confusing EDR data and text stream.
I'm not, sir, I'm just
Oh, you're
asking
not?
a question.
So
if it's yes or no, I'm fine with that.
EDR data will, depending on the vehicle, sometimes it has information about GPS date and time. Sometimes it has ignition cycles, which are a little bit different than key cycles, which is why you frequently have different ignition cycles versus key cycles in EDRs compared to text stream.
So let me ask it a different way.
Okay.
The text stream data indicates the number of seconds into the key cycle that a particular event occurs.
Yes.
Is that correct?
That is correct.
In order to properly determine the location and the timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle, correct?
I think I'm going to say yes, that text stream tells you the trip.
I'm just asking if it's important that you correctly identify the trip associated with a particular key cycle. And do so by determining, in order to properly determine the location and timing of a text stream event.
So the text stream tells you the trigger event and it tells you the key cycle. So I'm not determining that, I'm reading that from the text stream data.
Okay. So in order to properly read, to use your verb, the location and timing of a text stream event, it's important that you correctly identify the trip that is associated with a particular key cycle. Is that a fair statement?
I think that's a fair statement.
If you associate the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will be wrong, correct?
It can. I mean, you need to take the totality of the evidence in the text stream with the mileage, the overall timing into account.
So are you saying, sir, that if you have the wrong trip with the wrong key cycle, you can get the correct text stream event?
No, not necessarily. Again, you have to take the totality of the data.
My question is with regard to if you have the wrong trip with the wrong key cycle, then your estimate of when the text stream event occurred will also be wrong. Isn't that just a matter of logic, sir?
So, again, the text stream event tells you the trip and it tells you the time. If you're saying I'm, say, associating that with the wrong infotainment information or vice versa, then that would be wrong. But the text stream data tells you how much time is associated with each trip. There's no difference there.
If you associate the wrong trip with the wrong key cycle, then your estimate of where the text stream event occurred will be wrong. Is that correct?
You can't associate the wrong event with the wrong key cycle because it keys in the key cycle with the event.
Let me try it a different way. Your analysis, or anyone's analysis, in conclusions regarding the timing and the location of the text stream data are only as good as your ability to correctly associate a key cycle with a particular event. Is that an accurate statement?
No. Again, you need to take the totality of the data. So that is one element. You need to look, for example, at the mileage. You need to look at the timing of the events. So this is considered a tool in the analysis process. You need to look at the totality of data to see how it matches up with the physical evidence.
So are you saying that you can have an incorrect key cycle with a particular trip, but you can still get accurate timing and location of text stream data?
So again, you don't get incorrect key cycle with the trip. The trip and the key cycle are coded in by the text stream. If you are attributing an event to the wrong trip, which has a fixed key cycle, that could be a problem.
Exactly. So if we could go, if Your Honor, if we could publish a slide, please, that is in evidence.
Okay.
Thank you.
What are we looking at?
Pardon me,
What
Your-
slide number?
I've got slide 9. Mr. Wolk, yes, I've got the correct one. Thank you, Your Honor. So I'm going to use the acronym VCH that you've used on your, do you recall using the acronym VCH on your direct testimony?
Yes, sir.
And VCH stands for Vehicle Control History, correct?
Correct.
You viewed the vehicle control history on September 23rd of 2024, correct?
In addition to the PCS data.
You viewed the vehicle control history on September 23rd, 2024. Yes?
That is yes.
You took photographs of the vehicle control history, including key cycle 1167?
Correct.
And in this screenshot, we can see 4 text stream events that
Actually,
are...
can you zoom in on the key cycle?
Oh, sure.
Because I think when I got to, no, scroll. So when I got to it, you can see it was that key cycle 1264. The blue highlight was the last file that was written on key cycle 1167.
Right.
So to answer your question, I got it at 1264.
So if we can go back so we can see the 4 text stream events, I just want to reestablish the foundation here. In this screenshot, we can see 4 text stream events that are associated with key cycle 1167, correct?
Correct.
But isn't it true, Dr. Welcher, that there were actually 10 text stream events associated with just that one key cycle 1167?
Correct. I gave you the original files.
Right. So you are aware that the Commonwealth had maintained up into your firm's engagement that...
Are you saying there's no basis for the question?
They're saying.
All right, I'm going to allow the question and I'll hear it.
You are aware that the Commonwealth has maintained up until your engagement in September of 2024 that all text stream events associated with key cycles 1164, 1165, and 1167 occurred while the Lexus was in the custody of the Massachusetts State Police at the Canton Police Department.
So the objection sustained. You need a foundation, Mr. Lessie.
Sir, as part of your work in your review of the many documents that you referenced on your direct examination, did you review the text stream events associated with the Lexus SUV?
I reviewed the one I downloaded.
Pardon me?
I reviewed the one I downloaded.
Right. And did that, what you download, include key cycles 1164? Did it include that?
It did.
Did it include 1165?
It did.
And did it include 1167?
It did. It did not include 1166.
I didn't mention 1166, sir. I only mentioned 1164, 1165, and 1167. I purposefully skipped because I didn't understand you had reviewed it. So here's my question. You therefore, based upon the fact that you reviewed them, and you said it's important to understand timing, etc. That's very important in your forensic analysis, correct?
Yes, sir.
So let's go to the timing question and you understand where the Lexus has been at various points in time. You testified to that in direct, whether it was at the Canton Police Department, whether it was being towed, correct?
In addition to having Mr. Burgess' analysis of the data.
In addition to Mr. Burgess' analysis, so in that analysis contained locations of where the Lexus had been.
It contained where it had been and also include date and time, when it was turned on, when it was turned off.
Exactly. So not only did you have all the locations, you had dates and times associated with the location where the SUV, the Lexus SUV, had been, correct?
Correct.
Now to the question. Based upon that review, that knowledge, that understanding, that those bases, you're aware, and you've reviewed, by the way, Trooper Paul's reports, correct?
I have.
There were 2 reports of Trooper Paul. There was his original CARS report and then a supplemental report that were listed in the documents you reviewed. Do you recall that?
I don't recall that, but I'll take your word for it.
I don't want you to have to take my word. Do you recall, sir,
No, I
that there
don't.
were do you recall that there was a report of Trooper Paul?
Yes,
Okay, and you read that report, I assume, sir.
I did.
And it would be important for you to read that report and read it carefully because it addressed the subject matter that you were addressing, correct?
No, I did my own independent analysis. As a matter of fact, it'd probably be more important that I don't do that to avoid confirmational bias.
But you did read Trooper Paul's report,
Of
correct?
course.
So, you therefore are aware that the Commonwealth has maintained up into your engagement.
Yeah, I'm going to see a sidebar on this.
Why are we at sidebar? Why are we at sidebar? Let me just rewind it really quickly. Let me just make sure I heard what I think I heard. Give me a
Confirmational
second.
bias.
But you read that report and read it carefully. Do you recall that there was a report of Trooper Paul?
Yes,
Okay, and you read that report, I assume, sir.
I did.
And it would be important for you.
He just said he read the report, so what's the big deal? Why are we at
Read
sidebar?
it carefully because it addressed the subject matter that you were addressing, correct?
No, I did my own independent analysis. As a matter of fact, it'd probably be more important that I don't do that to avoid confirmational bias.
But you did read Trooper Paul's report,
Of
correct?
course.
So, you therefore are aware that the
So you tried to avoid, you didn't want to read the report, or you feel like it's important to not read the report to avoid confirmation bias, but you then read the report. Oh God, here we go. I don't understand this.
Commonwealth has maintained up into your engagement.
Yeah, I'm going to see a sidebar on this.
Oh my goodness. I mean, why I don't understand why we are at a sidebar for this. He read the report. So if you read the report, you know what's in the report, and you know what Trooper Paul said, or I shouldn't say because it's a report, it's written. You know what he wrote in the report, and you're being asked questions about a report you read. What's the big deal? Judge Bev, what are you doing? I just don't, hold on, let's see if they're back from sidebar yet. Nope. This is going to be a forever sidebar. Well, Shmita, here's the thing. I don't know if I think if you're comparing who Judge Bev likes more, this witness or Mr. Alessi, I would have to say that Judge Bev prefers Mr. Alessi over Dr. Welcher. Okay. However, then there's, the other person in this little triangle, which would be Hank Brennan. And I think that at the end of the day, she still likes Alessi better as a human than Brennan or Welcher, but she doesn't want speaking objections in front of the jury. So that's a part of the reason why there's a sidebar at this point, but also because she doesn't want to, like what Neat said, she doesn't want the jury to hear her being unfair, even though it's clear that she's completely unfair. And even if the jury only paid attention 2% of the time, they would be able to suss out that she's completely unfair. She's like the worst ref ever. Okay. There's no way I would ever hire Judge Bev to referee any sporting event ever. I wouldn't even let her come and be the umpire at a t-ball game. Okay. At all. Can you imagine the calls that she would make if she were an umpire in a ball game, a baseball game? Let me be clear. Can you imagine? She'd be calling balls when it was clearly a strike. She'd be calling strikes when they were balls. She would be yelling safe, even though it's clear that they were out. Probably wouldn't even be able to keep count. Oh God, of what strike they're at. I just can't. I cannot with this lady. Seriously, it's too much. And at the end of the day, he's saying that, you want to not look at stuff to avoid confirmation bias, but here we go. I'm going to look at it. Did they just go to lunch? What's happening? Oh, I wonder. I notice that this happens sometimes. So sometimes I notice that when the sidebars go on a little too long, when they go on a little too long, that that they said then switch to our friend here, the OnlyFan. And I'm wondering if that's because, let's be honest, where they're focused is on the where the family is seated, John O'Keefe's family, and Mrs. O'Keefe does not have a poker face. And when her face is very expressive, and her face is very expressive, and she's taken a little bit of well, not a little bit of, she's taken a rash of shit on the internet. Let's just call it what it is. Oh, Betterow said that this should be allowed as it's the price the CW pays for changing theories. Absolutely. See, I said it should be allowed. I didn't say why it should. I was incorrect about why. Yes, Violet. What's the count, Blue? Bev, 17. Yeah, that's not how baseball works. Judge Bev. I can't. Judge Bev is always doing the most. Are we gonna go to lunch now, Judge? Thank you, Tess. I see how you guys, this is why I love you guys. You guys are very encouraging me. You were right though. Thank you, Tess. I appreciate that. See, sometimes I am smart, okay? And also there's the even a broken clock is right twice a day. There's also that. So it's a combination of things, I get lucky every once in a while, but I don't I let it in. Come on, Judge Bev. Let's go. You started an hour late. And they shouldn't be, they did change their theory. This is ridiculous. This is just, I cannot, this is going to be a day of frustration. I can already tell.
May I, Your Honor?
Yes.
Thank you. Are you aware that over the course of the Commonwealth's and your investigation into this case, that the theorized time of the alleged contact of the SUV...
So there's two words, just strike theorized.
Okay. Thank you, Your Honor. Are you aware that over the course of the Commonwealth's investigation and your...
Hold on, Mr. Leslie. The court reporter can't hear you.
Thank you. I will.
Thank you.
I'll object again to the question that's coming.
Oh, are you part of the Psychic Friends
Can I
Network, Brennan?
Go
begin
ahead
my
and
question?
ask a...
Is that what's happening here? You know what question's going to come because you're now part of the Psychic Friends Network? Well, congratulations. You can know what question's going to come, but you couldn't prepare your case to know what question was going to come out of Shannon 1N Burgess's testimony about his CV and his education.
It's an appropriate question, Mr. Leslie.
Sure. Do you have knowledge whether there is one time or more than one time for the Commonwealth's position, as you know it from reading documents that you said you've reviewed, that there are different times alleged for the incident to have occurred at 34 Fairview?
Objection.
Sustained. You can ask the question, remove part of it.
I'm sorry, Your Honor?
You have to remove part of that sentence.
Okay, understood, Your Honor. Do you know whether there is more than one time that has been proposed by the Commonwealth for the impact alleged to have occurred at 34 Fairview?
Objection.
Sustained.
I'm going to ask for an instruction.
I'm not giving the instruction now.
Dr. Welcher, in terms of the analyses that you have reviewed in this case, is there one time that you understand there to be for a hypothesis for the time of the impact at 34 Fairview?
Objection.
I'm going to see you again, folks. I'm sorry about this.
What's going on? Why is this not coming in? I mean, at the end of the day, he read the reports. If there was a hypothesis in those reports and you read those reports, that's what he's asking. I'm not an attorney, so I'm not like understanding what the issue is. To me, it sounds like it's not an issue of the question or the subject of the question, so the subject matter of the question, but more the way that the question is being asked, the order in which the words have been arranged coming out of Mr. Alessi's mouth. And Mr. Alessi is an incredibly smart and adept attorney. And I think even he is confused at Judge Bev and why Judge Bev is saying what she's saying. Red Solo cup, I fill you up, proceed to party. Violet. He's like, poo, huh? Oh, bother. I appear to be stuck. This is so ridiculous. I think, honestly, Christina J., I have to say, I think this might, for me, be right there in the top three. I can't decide between, for top two, this one or the West Memphis 3. I really cannot, because I just can't. Oh, I did too, Neat Noodle, and this is really interesting. Neat says, Tess, I saw many comments yesterday saying that this witness made a lot of ground yesterday. Do you know what the people in the trial are saying about the jurors' reaction to him? I'm curious about that too, because I also saw a lot of comments like that too. And all I could think in my head is, are we watching the same testimony? I'm confused. Did you hear the same things I heard? Because I didn't, that was not my takeaway at all. At all. I mean, interesting. So Tess says, they said the jurors took notes and were paying attention, but were very restless by the end of the day yesterday. And Violet says, I follow Sue on Twix, and she said that the jury made a lot of notes when he testified. I feel like they probably are taking a lot of notes during the direct, and I think that they're going to be taking a lot of notes during cross and comparing them as far as what did he say on direct examination, what did he say on cross-examination. I don't know. I'm curious how the jury is going to, what amount of weight the jury is going to give this testimony, which parts are going to get weight, which parts are not going to get weight. I'm very curious about it. All right, they're coming back, well, only one person is coming back. Hold on. Oh, they're all coming back. Okay, we should be getting started shortly. Maybe not. Okay. Sue, just a few minutes ago, 4 jurors taking notes. All are attentive. Some are watching the back and forth between defense attorney Robert Alessi and Judson Welcher of Aperture like a tennis match. I mean, that's the only way to watch it, really, because yikes on bikes. This is so much. Oh, Christina J. says, I didn't watch that one, but looking forward to your upcoming videos. I got to do it like I'm doing it chronologically. I thought I've mulled over so many times just doing a single documentary, right? But I don't think I can do that. I know that I cannot do that. I know I can't. There's so much information. I mean, yes, there's a lot of information generally speaking, but I do feel like there's a lot of information that is important and should be discussed. And so if I made one documentary, it'd be like 8 hours long. So I think it's better to be broken down in episodes, but also like if you've watched the Paradise Lost documentaries and even West of Memphis, this will be things that further discuss stuff that was in those documentaries. Tess says, one juror is nodding up and down as Alessi pressures Welcher on payment contracts. Ooh, interesting. And there, according to Tess, who's looking on the X-Twitters, the Twix, there is one juror who looks entertained by Alessi. Violet wonders, what kind of pizza Bev eats? Is she classic pepperoni and cheese, or is she a thin crust veggie, or meat lovers? I'm going to go with Supreme. I think that that Judge Bev gets all the toppings. What I'm really curious about is, does she dip it in ranch? Now, Bev just asked if the juror's lunch was there yet, so that's not good. Of course, because it's, 12:29, and even though we started an hour late and we were off for 5 days, we're on schedule apparently.
Excuse me. Yeah, Your Honor?
Yes.
Thank you. I'm going to move to, for the moment, we'll come back to the other topic a little bit later. As we discussed earlier, you've got on various documents, you're a biomechanical engineer, but I've also heard you make reference to biomedical. Can you just tell me what you consider yourself, sir? Is
Sure.
is biomechanical engineer something you consider yourself to be?
Sure. My degrees are in biomedical engineering. The discipline within biomedical engineering that I practice is biomechanics.
Right. And so is it accurate to say that you are a biomechanical engineer?
Yes.
And you say that much in your report, correct?
And the CV and resume I gave you.
Right. Now, in your report, and Your Honor, I have no issue if he refers to the
Thank you.
page of his report.
Do you have a paper copy or do you need your?
I do.
If you, sir, could turn to page 9 of your report.
Sure.
And on page 9, you state, as a biomechanical engineer, I have no opinion on any aspect of, and I think you're referring to Mr. O'Keefe's, medical treatment or medical diagnoses. I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. Did I read that correctly?
Did?
In that statement, I assume, given you wrote it, is a fair representation of your professional role in this case?
Yes.
And you go on to add on page 9, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. Did I read that correct?
You did?
And on your direct examination, is it correct that you stated as a civil engineer, you made an analogy, you assessed the cables and beams of a bridge as you would assess the cables and beams of a bridge, you assessed the human anatomy. You made that analogy, correct?
The analogy that bones are my bridge elements, cables are muscles and ligaments.
Right. And you stated that it's the job of a biomechanical engineer to quantify the force acting upon a person to determine the cause of their injuries, correct?
That is part of what we do.
It's part of, but it is therefore something that a biomechanical engineer does, correct?
If given sufficient data, yes.
So, you know how to, do you know what a force calculation is, sir, when I refer to that term?
I believe so.
What do you believe it to be?
Well, force is usually a physical measurement, but you can also use Newton's second law, which is force equals mass times acceleration.
That's exactly what I wanted to get to. Newton's second law is, and sometimes referred to as the second law of motion. And in the second law is force equals mass times acceleration, correct?
Correct.
And just sort of like simple algebra, sometimes you have one or more of those, but I'm focusing on when you're trying to determine, sir, you're pulling something out.
Calculator. I thought you were going to ask me numbers, do calculations.
All right. We need to do, if we're going to do that, we need to do it with the court's permission.
Sorry.
So if you feel you need to do that, just let me know.
You can just leave it right
All
here.
right.
So I just want to get the principles down first. So Newton's second law, force equals mass times acceleration, and force is oftentimes what you're trying to calculate in a force calculation, correct?
Calculate or measure, yes.
Yeah. And Newton's first law is the law of generally inertia. An object at rest tends to stay at rest. Object in motion tends to stay in motion. We're not talking about that in force. We're talking about Newton's just second law, correct?
You asked me two questions. Newton's first law is generally, as you said, it could be at rest or at constant velocity, but yes.
Okay. And that Newton's second law is generally just a mathematical calculation, correct?
Yes.
So what I'd like to do is to turn to page 11 of your report. And on page 11, you discuss the force calculation in conjunction with the part of your report where you discuss your experiment where you dropped a test dummy backwards, correct?
Correct.
You determined that a fall of 69 inches at that fall Mr. O'Keefe's head would have accelerated with 458 G's of force?
That's what we actually measured
Right.
in the test.
And can you tell the jury what is meant by G's?
So G's is a measure of acceleration. If you use the acceleration is measured in feet per second squared. If you divide it by 1G, which is 32.174 feet per second squared, that gives it to you in G's. People have often heard about fighter pilots losing consciousness at 6 or 7 G's, basically because your blood's getting sucked away from your head, not because you're being impacted. But G forces, or G's as they're more properly called, is a measure of the acceleration. It's just whatever the acceleration is divided by what we all feel when we're standing here, which is 1G of gravity.
And you estimated Mr. O'Keefe's head weight of approximately 15.7 pounds. You used a percentage. Is 15.7 about right for the mass of,
Yes.
of the head? So if we apply Newton's second law, we keep F force open as the unknown. We take and apply the mass, which is 15.7, multiply it by the acceleration. You end up with a force acting upon Mr. O'Keefe's head of 7,200 pounds. Do I have that right? That's right out of your report.
So that math is all correct. Falling backwards onto a hard surface from his standing height will give you approximately 7,200 pounds of force.
And that 7,200 pounds is the previous unknown F in the Newton's second law equation, correct?
Correct.
So now we have an answer for F, 7,200 pounds. Now you then go on to note that the applicable scientific literature states that a fracture to the occipital bone, and just to review, the occipital bone is the back of the head right here, right?
Correct.
So you then, as I understand it, you go to the scientific literature and you concluded that a fracture to the occipital bone can occur with an average force of 1,634 pounds from a fall distance of 40 inches, correct? I'm sorry. How many inches? 40. That's in your report?
Well, you mixed two things together. There was stuff that reported force data. You had those numbers correct. A range of between 1,150 and 2,150, a mean of 1,634 pounds, and then it says, and a drop distance as low as 40 inches.
Right. And is the number 634 pounds a proper number for an average force?
Did you say 1,634 pounds?
1,634.
Yes.
Okay. So what I want to do is see if this is correct. So if you can get a fracture of the occipital bone in an average force of 634 pounds.
No. 1,634.
I thought that's what I said. If I did, I missed.
Oh, I'm sorry. I just heard 634.
No, 1,634.
My apologies.
And you compare that to the 7,200 pounds of force that you calculated, surely you're going to have a fracture of the occipital bones through that calculation and that comparison, correct?
Correct. Falling on a hard surface can definitely fracture your skull.
So I'm not getting at the manner. I'm just applying the Newton's second law. Newton's second law doesn't look at manner, does it? It just looks at force equals mass times acceleration. Newton's second law doesn't look at the surface, does it?
So it's a function of the surface. The A value is a function of the surface you hit.
So you're saying acceleration depends upon the surface?
Yes, of course.
Okay, all right.
For an impact, it does.
Now, let's go to the study you cited. Injuries to pedestrians in real accidents in their relation to collision and car characteristics. That's in your report, correct?
What reference number?
May I, Your Honor, grab the report?
Yes.
Thank you. If you can, it's in your report, sir. If you can find it, I'll do it in parallel with you.
Is it number 25?
That's the one I think it is. I just want to check your report.
Would you like me to actually pull up the paper?
No,
Okay.
just want to get to the... That's it, number 25. We're talking about the same one. Now, isn't it true that this study states that head injuries are the most common injury type for motor vehicle collisions, constituting more than 61% of all injuries sustained from motor vehicle collisions?
Or can the witness see the document that's being referred to?
Do you have your report in front of you?
I have my report, but reference 25 is not in the section he's referring to.
Why don't you show it to him, Mr. Leslie?
I do not have with me a copy of the report he cites in his reference. He did... Can I ask another question, Your Honor?
Yes.
Thank you. Dr. Welcher, on your direct testimony, did you not discuss the percentage of pedestrian injuries and relate it to heads? Did you not, on your direct, talk about percentages of injuries that are head injuries in impacts of pedestrians with cars?
Yes, I did.
Okay, so you came up with a number. What I'm trying to do is to compare that number to the number in the study that you cite. If you don't remember, that's okay. We'll just move to the next
Can
question.
I go to my slide?
Whatever you can use to determine what was the percentage that's in the study that you cite in footnote 25 of your report.
Sure. That was also from my presentation that I gave. It's 61.5 for all injuries, 12.7 for fatal injuries.
Thank you.
You're
So I'll
welcome.
repeat my question, and then we'll get it in logic. So that study states that head injuries are the most common injury type from motor vehicle collisions, constituting slightly more than 61% of all injuries sustained from motor vehicle collisions, correct?
That number is correct. You're quoting a sentence. I would want to pull the paper up, but the number is correct.
Okay, so doesn't this article also state that of all head injuries sustained by motor vehicle collisions, only 12.7 of them are fatal?
That does, yes.
Did you mention that only 12.7 are fatal on your direct examination?
It's circled with a red box on my slide.
Did you mention that on your testimony on
I
direct?
thought I did.
This article was published back in 1979, correct?
I believe that's correct.
It's 46 years old, therefore, if I did the math correct, right?
That sounds correct.
Are you aware that given advancements in science since 1979, advancements in medicine, advancements in technology, the currently understood most common injuries as a result of pedestrian motor vehicle collisions are injuries to the lower extremities?
I'd have to see the study. It wouldn't surprise me. Car technology, especially, for example, with pedestrian safety systems, has caused autonomous braking. So you're getting fewer higher severity crashes, which results in a higher propensity for lower extremity injuries. It's the higher extremity crash that causes the head to either slap into the hood or the window and or bounce off, to where if you get the lower severity crashes, you can still maintain a standing posture. So it wouldn't surprise me if that's accurate.
So you would agree that as of January 2022, the most common injury as a result of a pedestrian motor vehicle collision is one to lower extremities?
No, I wouldn't necessarily agree with that date. And again, you have to look at frontals versus rears.
So you contest that the most commonly understood injury as a result of a pedestrian motor vehicle collision is injuries to lower extremities?
Maybe that's about a source.
I'll allow the question.
So I'd want to see the data. Again, most cars, for example, this Lexus has a pre-collision system in it that will start to apply the brakes if it senses a pedestrian at the front of the car. And so for frontal collisions, it's transitioning, taking what were head injuries, because they're more severe, higher speed crashes, making them lower speed crashes and shifting the injuries to the lower extremities. Just like airbags shifted the head injuries away from the severe ones, and we started getting more or higher ankle and lower leg injuries. So the change in the technology, but for backing, that may not be the case because you have different geometry on the vehicles and you have different safety systems.
I'll try it a different way. Do you have knowledge, as you sit here today, whether the most common injury from a motor vehicle accident is to the lower extremities?
I'd have to look at the literature. I have the article I gave you.
So the answer is you don't know the answer to that question. Is that correct, sir?
I don't know it off the top of my head.
All right. Newton's second law analysis that we went through, force equals mass times acceleration, where we came up with the 7,200 number. You didn't discuss that calculation on your direct examination, did you?
I don't think so. We didn't discuss a whole bunch of those things that were that wasn't necessarily an opinion, that was a sub-opinion or basis for my opinion.
You didn't discuss that Newton law calculation on your direct examination, did you, sir?
So in a way I did, because I said my drop testing shows that you can do this. So I didn't quote that number, but we are going through the specific numbers now. But I absolutely did say, as a matter of fact, I showed a video of my drop testing and talked about how falling onto a rigid surface, a hard surface, can cause a skull fracture.
Did you discuss on your direct examination applying 15.7 of the head weight to 458 Gs and come up with a number of 7,200? Did you do that on your direct examination?
Those specific numbers, no.
Thank
the general
you.
concept of the drop testing and what it showed, yes.
So instead of that calculation, you referred to a flow chart comparing injury characteristics of flaws versus blows. Do you recall doing that on your direct?
So you asked me two questions. You said instead of, so that's no, it's not instead of. They're two completely different topics. So no, I didn't do that instead of.
Okay.
I looked at a force analysis, then I looked at 3 peer-reviewed publications that were attempting to differentiate whether an injury is associated with a fall or a blow, an assault, and they came up with a metric for doing that. Those things are completely separate.
Let's ask it this way. Did you, on your slide presentation that you presented to this jury, did you put the inputs into F equals M times A in your slide presentation with the numbers we talked about of 15.7 for the M and 458 for the G to come up with 7,200? Was that anywhere on your slide presentation?
So the slide presentation showed the 458 Gs. The rest of it was not on there.
Thank you.
You're welcome.
You also indicated that the laceration above Mr. O'Keefe's right eye is consistent with the shape and height of the fin on the top of the Lexus SUV. Do you recall that?
Correct. It's actually properly called a spoiler.
And so you would call it a spoiler instead of a fin?
Correct.
Fair enough. We'll call it a spoiler. You visited the scene at 34 Fairview, correct?
I did.
You stated that you like to visit the scene while you're working as an accident reconstructionist so you can get a better understanding of the data?
I'd use the word like, but we want to go to the scene to see the scene.
When you visited 34 Fairview, did you go into the garage at 34 Fairview?
No. I actually didn't set foot on the property.
You didn't set foot on the property?
No, I stayed in the street. It's my understanding there were new owners.
Did you consider the scene limited to the road?
So the access I had was to the road. The laser scanners and the photographs will extend further, but I didn't have access to the interior of the house.
Oh, so you didn't access the entire scene, correct?
In my opinion, I did access the entire scene. I didn't physically step 7 feet onto the grass to the point of rest, but I stood and photographed where that was. I didn't want to trespass.
Where did you understand the body of Mr. O'Keefe was located?
I know it was 7 feet in from the grass. I've seen cruiser cameras showing people around a body. It's slightly north and slightly south and a little bit west of the flagpole.
But you didn't access that part of the scene that you just described, correct?
I absolutely did. I took photographs of it. I didn't trespass and stand at that exact location, but I stood right there. We scanned the whole thing. The scanner uses a laser beam that goes out, 150, 200, 300 feet. So we scanned all that stuff.
Did your scan topography?
Yes.
Then you know that there is a berm raised above street level, correct? If you did the scan.
Correct.
Do you know the height of that berm?
I believe it's 4 inches.
Nowhere in your report, when you're comparing the height of Mr. O'Keefe to the spoiler, do you account for that 4 inches of the berm, do you?
So yes and no. As I indicated, we don't know exactly where the point of impact is, whether he was completely in the road or up on the berm. But for example, where the tire spins on the Lexus, that could be where she's driving up on the curb. And so then that tire will be at the height of the curb. So if he's standing on the higher part and the right rear tire of the Lexus goes up there and spins, then that would be at the same height. We don't know the exact point of impact. So I don't know whether he was on the road or in the street. Excuse me, on the street or on the side of the road.
Exactly, but when you did your depiction on your slide, and you remember you had the ruler and you measured the height, you did
Absolutely.
all that?
Yep.
Where was it? Was it you in that slide?
It was
Where were your feet?
on the ground.
Not on the berm, correct?
Correct.
Okay, so you chose a measurement, which was the ground, to the top toward the spoiler, and you took a measurement. And you said that approximates the height of Mr. O'Keefe, correct?
Of the laceration of Mr. O'Keefe.
Exactly, because what you were doing was you were trying to determine and present testimony on whether or not that laceration could be caused by the spoiler, and to do so you had to take measurements, correct?
Correct.
So, you chose to place Mr. O'Keefe in your simulation on the ground. You didn't choose to put him on a berm that would be 4 inches higher, did you?
Nor did I put the Lexus 4 inches higher. I didn't do
Correct.
either one of those.
So the point is, it's certainly possible that if there's 4 to 5 more inches, that would take that eye out of the ability to be hit by the spoiler. Isn't that correct?
No, because if it's 4 to 5 inches higher and he leans his head down or reacts to it, again, we don't know the exact position of his head.
Did you, in your slide yesterday, describe the possibility that his head could be down? As I understand it, you're positioned in that photo just like this. You're not positioned like that in any photo you presented to the jury, were you?
I'm trying to make it clear. We don't know his exact body position at the point of impact, nor do we know the exact position on the ground. So, which is part of the reason why I haven't tried to exactly simulate this, because we don't have enough parameters to do that. So I don't have that information. I'm showing the geometry relative to someone of Mr. O'Keefe's height.
So you don't have the information to do that properly, so therefore you can't conclude that he had a laceration to the eye from the spoiler by your own answer that you just gave, correct?
So it was done properly. We don't have absolute information to say where exactly he was. I'm pointing out that the physical evidence, the height, matches the height of the laceration. That is one data point of many data points.
So you would have to at least concede that the level of his eye could be non-contacting that fin or spoiler because you don't have information as you just described.
Sure, it could be from contacting the ground.
Pardon me?
It could be from contacting the ground. It could be from other things.
But you don't have the information necessary to conclude with any certainty that Mr. O'Keefe, at the time of impact, had a level of his head in an upright such that it hit that spoiler. You don't have that information, correct?
We don't have that level of certainty. We have that the height and geometry matches.
And you didn't take into consideration the Burm, and you didn't mention the Burm at all when you were discussing this measurement with a jury yesterday, correct?
That is not correct. You asked me two questions. I absolutely considered the berm. And the second question, when I presented it to the jury, I mentioned the berm when we showed the picture of the shoe in the snow, but that was it.
That's my question. I'll ask it a different way. When we were talking not about finding a shoe in the snow, and you mentioned a berm, I'm talking about when you did the measurement of whether or not the laceration could be caused by the spoiler. You didn't mention accounting for berm height when you discussed that measurement with the jury, did you?
That is correct.
Likewise, you didn't present any Newton's second law analysis regarding the front of Mr. O'Keefe's head with respect to whether his head was contacted by that spoiler, did you?
Correct. Again, it was a glancing hit. We wouldn't be able to do that.
Oh, so it's a glancing hit to the front of the head is your hypothesis?
This whole pedestrian impact is a glancing hit.
So you can have your arm to the side like this, with the back of the vehicle coming like this, and you could glance the right eye with the arm out? Is that what you're saying?
That's what my picture shows when I'm standing next to the car. I could probably find the slide for you.
So you didn't do a force analysis to determine how much force would be applying, assuming a contact with the right eye, did you?
That's correct.
And force analysis is what biomechanists do, correct? That's what a biomechanist does?
That is part of what
Part of what they do.
So I lined up his anthropometry relative to the known height of the vehicle.
You attempted to line it up. That's one method, but another method is to apply Newton's second law like you did to the back of the head when he fell, correct?
Correct, if we had more information.
Mr. Alessi, why don't we break here?
Thank you, Your Honor.
So, jurors, your lunches are here. We'll see you.
Please rise for the jury.
Goodbye.
Okay, so we are now at lunch, and wow, oh my gosh. So I don't actually even know. I don't really even know what to say, honestly, because this is the perfect summary of this last bit of testimony before the lunch break. You don't know anything. That's the point. Correct. They know nothing. Nothing is known. Oh my God. This is like, This cannot be real life, y'all. This just cannot be real life. Honestly. All right. So let's go to the end of yesterday and listen to hold on, I need to fix this. To the end of yesterday's testimony and hear what had happened. Okay, hold on. Let me get there. Bruh. Now, mind you, okay, hold on. When this happened yesterday, okay, this was at the end of the day. Judge Bev had already dismissed the jury for the day, okay, and okay. So Tess says, the ward, I believe the reason the Commonwealth is fighting so hard is because they're basing their narrative on the key logs that were done by the Massachusetts State Police, not Karen Reed. Okay. Got it. All right. So this is what happened yesterday at the end of the day. And keep in mind, this was actually kind of a major thing. All right. And just listen to the amount of time that Judge Bev gives to discuss this thing that happened. All right. So let me go back to what caused this. Give me just a sec. Oh, hold on. Almost got it. All right. Okay, here we go. Let me put the closed captions on. All right, here we go.
Fairly severe skull fractures.
Thank you. Dr. Welcher, regarding your third part of your analysis, did you come to a conclusion to a reasonable degree of engineering certainty whether or not the defendant's Lexus collided with Mr. John O'Keefe on the evening of January 29, 2022, around 12:32 a.m.?
Yes.
Before you give me your opinion, I'd like you to share with the jury what that opinion is based on.
Sure. So it's based on the 130 slides you've seen. It's based on my personal inspection of the Lexus, the correlation of the text stream data with the infotainment data, as well as Mr. O'Keefe's cell phone data. It's looking at, I guess, where the taillight wasn't broken. It's looking at the physical evidence at the scene in terms of taillight fragments, glass fragments, red color in the snow. We have the cell phone data, the location and position of the arm lacerations, the air temperature at the time indicative of sufficient to freeze, the location of the fracture on the back of his head relative to the scientific literature, my testing of forces available falling onto a hard surface, published science on the fracture forces associated with falls. And, I'm sorry, I'm reading from my report.
Yeah, you're not supposed to be. Hold on.
I'm reading from my report.
Yeah, you're reading from your report, but you're not allowed to do that unless they ask for the court's permission. Okay, generally speaking, a witness's testimony, including an expert witness, right? Their responses are supposed to come from their brain. Okay. Eyes on your own paper, no cheating, all those things. If they need to refresh their recollection, they can ask. Okay. But not there. You're not just supposed to be getting up there and just reading from your report. I don't give a
Can you
shit.
answer without reading from your report?
Probably it's more complete if I read my report.
Any objection, Mr. Leslie?
I do, on this question, Your Honor, reading from a report for this question, so I'm going to reference some data.
So, try not to read, don't read from your report.
Okay, doke.
Okay, Dr. Welcher, let me ask you again. Based on your analysis, data available, reviews, study, based on the fact that you are an accident reconstructionist and a biomedical engineer, have you reached an opinion to a reasonable degree of engineering certainty whether the defendant's Lexus struck Mr. John O'Keefe on January 29, 2022, around 12:32 a.m.?
Yes.
And could you share the bases of your opinion before I ask you your ultimate opinion?
Sure. So again, you've seen my slide presentation. I've inspected the Lexus. I've looked at where it wasn't damaged. I've inspected the taillight. I got an exemplar Lexus. I ran lower speed contacts to verify that the injury pattern and location on the arm is consistent with the height and orientation of the taillight. I have looked at fracture tolerance data for falling backwards onto hard surfaces. I've looked at the metrics of where his injuries were and what injuries he didn't sustain. I've looked at the cell phone data, and then I've looked at Miss Reed's interviews as well.
Based on all the evidence you considered, could you share with the jury what your opinion is to a reasonable degree of engineering certainty about whether the defendant's Lexus struck Mr. O'Keefe on January 29, 2022, around 12:32 a.m.?
Objection, Your Honor.
Going to another.
That's, I cannot believe she allowed that.
Yes, based on the totality of the evidence, DNA, everything I've talked about, that is consistent with that happening with a reasonable degree of scientific certainty. That is what happened.
It's right there. To a reasonable degree of scientific certainty. Okay. Excuse me, you guys. I couldn't mute in time. I didn't mean to cough in your ear. Okay. That is the question for the jury. The jury is the fact finders in this case. Okay. The jury is the ones who will determine if that is what occurred. Okay. Because that's what she's actually charged with. So let's keep going. That's part of the issue. That's a huge issue.
Move to strike, Your Honor.
So I'm going to strike that. I want to see counsel's have up just.
She struck it. Then they go to sidebar. All right. They stay at sidebar for a while. They go to the fan. Judge Bev tells the jury to go home.
To see, hear, or read anything about this case, please disregard it and let us know, and please be very careful with your social media use. So we'll see you tomorrow. Oh, I'm sorry. We're starting an hour late tomorrow. Is that what this is?
Yes, Your Honor.
So we'll start at 10 o'clock tomorrow.
Yeah.
So
Yeah, 10, 10:30, whatever.
About your specific.
Pack all this up?
All right. Now we're about to get into it.
Do I need to pack all this up? It's okay. I mean, I can come in early. I came in early this morning and set up.
Welcome. I mean, we don't really want to walk ahead.
Yeah, I'll do that.
All right.
Did Dr. Welcher leave?
Dr. Welcher can step down. I know he has to come back and have his
So
equipment.
just leave everything here.
And then you'll come back in 5 minutes.
Roger.
All right. Yes, please.
5 minutes. 5 minutes. That's what she allowed. 5. Not 6, not 4, 5.
All right, so Mr. Alessi, I will hear you as to your objection.
Thank you, Your Honor. Would you like me to go to the podium or stand?
Right there's fine, and let's try and wrap this all up by 4 because I've already heard you at sidebar.
We'll do so, Your Honor.
That means both of you I'll hear from within the next 5 minutes. Go ahead, Ms.
Both parties get 2.5 minutes each on this. This is important. What the way that Brennan asked that question, okay, which is what elicited the response, which his response is ultimately the job of the jury to determine, not that witness. That's the problem. But let's keep going.
Mr. Alessi.
Thank you, Your Honor. The point number 1 is the question of whether, based on a reasonable degree of scientific or engineering certainty, he has an opinion whether a collision occurred. I'm going to give a dramatic and accurate example that happens in courts all the time in equivalent. So, by analogy, if the issue is whether or not a defendant has stabbed an individual and caused a certain event, that is the ultimate question for the jury. That question is never permissible in a trial. By analogy, this is the exact analogous situation. The question of whether there was a collision is the ultimate question for the jury. That is why we are having this trial. The defense strongly asserts there was no collision, and there is substantial evidence to that. We are going to cross-examine Dr. Welcher. We are going to put in our own strong case to demonstrate no collision occurred. That's no surprise. It was in our opening statement. This witness cannot, by precedent for years, opine on the ultimate question that is going to the jury. I accept, subject to evidentiary issues, the 2 questions that a biomechanist always answers in these situations. Is the damage to the vehicle consistent with a pedestrian hitting the vehicle? And are the injuries to the individual consistent with being hit by a motor vehicle? Those are the questions that are permissible, not the collision question. It is resoundingly improper in this trial, in any trial where that is the ultimate conclusion for the jury. Yes, an expert can offer opinions, but every expert is bounded by the extent of their opinion, and that opinion on whether there was a collision would invade the province of the jury and the whole purpose why we are here, Your Honor. Thank you.
All right, Mr. Brennan.
So what Mr. Alessi is arguing is that in their opening statement, they repeatedly invaded the province of the jury because they must have asserted vehemently over and over again there was no collision.
Opening statements are not evidence. So they said it, that there was no collision. They're allowed to say that in opening statements. What they aren't allowed to do, Mr. Brennan, that you're very well aware of, is get a witness to opine that there was a collision. That's the problem. It's the word collision, okay? And I must remind you once again, you should know this, you graduated law school. I certainly didn't. I didn't even graduate high school. Opening statements are not evidence. They're only a preclude for both sides to tell the jury what they expect the evidence will show. That's it. That's all. Stop playing with these people.
Over and over and over again. And he just told you that when his expert takes the stand, they'll have abundant evidence that there was no collision. This case is about the collision, but that is not the ultimate issue. The ultimate issue is manslaughter or mens rea for second-degree murder, not collision. They don't get to define the prosecution's case. They do not get to define or limit the prosecution's opinions. They have no case law. They have no study. They have no jurisdiction or jurisprudence to say what we are limited to. He's entitled to an opinion. His opinion is not limited to whether or not the defendant struck Mr. O'Keefe. That evidence is obvious. It's not whether or not there's damage to the car or Lexus. That evidence is obvious. He also is an enormous part of a biomedical engineer and an accident reconstructionist.
Wait a minute.
He studied.
Wait a minute. Wait a minute. Wait a minute. Is he a biomedical engineer or is he a biomechanics engineer? Because I'm really not sure about that. And I know that he testified about which one he is, but to be quite honest with you, sometimes I tune out. I can't help it.
The text stream data. They didn't, he did. And he's entitled to give an opinion. The text stream data, based on fact and science and data, tells us when, if you put it together with other evidence, and where, when you contribute it with other evidence, this collision actually occurred. We don't have to play peekaboo and close our eyes to the reality of the fact that the evidence supports the conclusion to a reasonable degree of engineering certainty that the defendant struck Mr. O'Keefe with her Lexus in front of Fairview Road. I am not interjecting the defendant. I always refer to her car, so it is sanitized, her Lexus. I've been careful about that. I don't have to, but I'm very careful about it. He is relying on the text stream data, the physical evidence, his independent studies. He is allowed to offer an opinion about whether the injuries are consistent with the damage to the car, whether the damage to the car is consistent with the injury to Mr. O'Keefe, and he's also allowed to answer, in his opinion, the issue of a collision.
Wait a minute. Back the milk truck up. Mr. Brennan, correct me if I'm wrong, but didn't your other witness, Shannon One N Burgess, testify that some of Dr. Welcher's calculations were calculated incorrectly, that he did not, which were based on the text stream data? Did I make that up in my head? All right, here we go. Is it Sissy's mom? Sissy's mom says it's a biomedical degree. Biomechanical is under the biomedical umbrella. I'm curious about that, and I'm not arguing with you. But the reason I'm curious about that is because there was a question by Mr. Alessi. And because there was a question, it seems that Mr. Alessi wanted to differentiate exactly what his area of expertise is, which tells me that they might be different. So I'm just asking. I'm not trying to be argumentative because I actually don't understand that part. All right, here we go.
Aside the fact that that was emphasized and repeated in the opening statement, and it's going to happen again when other people testify. It's not our fault that ARCA didn't testify or look into the text stream data or they don't have an expert for it. It doesn't belittle or limit that evidence. We expect to ask Dr. Welcher, does he have an opinion to a reasonable degree of engineering certainty whether the defendant's Lexus collided with Mr. O'Keefe on January 29, 2022 around 12:32 a.m. That is one of the opinions we're going to ask him. Nothing to do with the ultimate opinion of guilt or innocence or whether it's manslaughter or there's mens rea for second-degree murder.
And what was your second? You said that's one of the opinions you're going to ask him. What else are you looking at?
I will also ask him about the consistent with, whether the injuries are consistent with.
With what?
I'm going to ask him after this part about the difference between a clip or a side swipe as opposed to a full-on injury, pedestrian collision from a front or back of a bumper, and there are further slides to emphasize that point. And so there'll be an opinion regarding that as well.
And you,
consistency with a side swipe or a clip.
Okay, so this is not the end of Dr. Welcher's testimony. He's just moving on to another area.
It's close, but it's not the end.
Okay. Go ahead. Yeah.
Your Honor, here's a case. Attorney Brennan said, go to case law, here it is. Commonwealth v. Coleman, 366 Mass 705. And it stands for the proposition exactly that I articulated. I won't repeat it. Secondly, Your Honor, we practice what we preach. I have the ARCA report right in front of me. And I have the report of...
Is that a new one or is that a...
This is the new one.
Okay.
It's also, the old one is the same. So I can, either one is the same. They do not, Mr. Brennan incorrectly said what our experts are going to do. I don't know why he did that because he has these in writing. Neither Dr. Wolf or Dr. Rentschler talk about a collision or conclusion. It's consistency. It's those two questions I said at sidebar. And for reference, Your Honor, for the most recent, is page 15. There is no...
I don't have that report, so I'd like a copy of that report.
Your Honor, a copy, and I also, Your Honor, refer Your Honor to ARCA's existing report, which I'm going to do from memory. I think it's February of 2024 that was done for the U.S. Department of Justice and FBI, where they basically said and gave opinions on those two items I spoke to you at sidebar. So Attorney Brennan is incorrect when he says what our experts are going to say or not. We've already committed in writing to what they're going to say. We're consistent. We practice what we preach.
All right, so we will discuss this tomorrow before we start. I'll tell you my ruling tomorrow before we start. I need to go back and see what exactly came in to evidence today. All right, so I'll see you in the morning.
Okay, and that's how we got the ruling that we got this morning. So I went and looked it up for myself. Sissy's mom is correct. So this is what I Googled. Is there a difference between biomedical engineering and biomechanical engineering? So according to Google, here's the deal. Yes, there's a key distinction between biomedical engineering and biomechanical engineering, although they are related and sometimes overlap. Biomedical engineering is a broader field focused on applying engineering principles to biological and medical problems, while biomechanical engineering is a more specialized area within biomedical engineering that focuses on the mechanical aspects of biological systems, says a Reddit thread. Here's a more detailed breakdown. The biomedical engineering. This field encompasses a wide range of applications, including designing medical devices, developing diagnostic tools, and working on issues related to human health. It's essentially the application of engineering principles to solve problems in medicine and biology. Biomechanical engineering. This is a more specialized subset of biomedical engineering that focuses on the mechanical properties and behavior of biological systems, such as the human body. This includes understanding how forces, stresses, and movements affect tissues, organs, and the body as a whole. For example, biomedical engineers might work on designing implants, prosthetics, or studying the mechanics of human movement. Overlap. While distinct, there is a significant overlap between the two fields. Many biomedical engineers will also have a strong background in mechanics and materials science, and some biomechanical engineering projects will fall within the broader scope of biomedical engineering. In essence, biomedical engineering is the umbrella term, and biomechanical engineering is a specialized area within it. It's like saying computer science is a broader field and software engineering is a specialized area within it. So there you have it. There's the answer. And now I know and I understand it better. And because I remember from Todd Molis's trial or hearing on oops, hold on a second. Hold on. I messed up on something. When there was testimony during his post-conviction relief hearing, I remember the expert who testified was both. And yes, That's yes, like the hardcore lady from the corn rake case. Yes, she did both. Um, and maybe, Sarah Bellum, you're probably right that Alessi just asked it so the biomedical biomechanics was clarified for the jury. Yes. And yes, you do get a gold star. You are a good noodle. Way to go, Sissy's mom. I appreciate you very, very much. Because sometimes when there's like a lot of testimony, there are certain details that I just tune out. Okay. If it doesn't really have anything to do with what we're supposed to be talking about, as far as what data he analyzed and how he arrived at his, at his ultimate conclusion, sometimes I just be tuning that stuff out. I'm human. It is what it is. Okay. Um, Maybe I should try to tune out less, I guess. I should be more, um, I don't even know how to put it. um, I'm curious. Do you guys remember? Let me rewind to where they took lunch. Let me see what Judge Bev said, how long they would be gone.
That is part of what we
Part
do.
of what they do.
So I lined up his anthropometry.
Method. Your Honor.
Ah, crepes.
Thank you, Your Honor.
So jurors, your lunches are here. We'll see you.
50 minutes.
Goodbye.
She said 50. All right. 50 minutes. And we're at like 30. Okay. So we got about 20 more minutes for lunch. I agree, Sissy's mom, Jen, says, this is why I like to watch with the group. Between all of us, we get the facts. And yeah, that's why I like to watch with you guys, because you guys catch details that I didn't catch. You guys have answers to questions that I have. Sometimes I have answers to the questions you guys have. And I like our group study sessions. Okay. I need to take a human being moment. I will be back shortly. Okay. So BRB. Okay, so I'm curious, you guys, how you're feeling about Mr. Alessi's cross. I have to say, there was one point in the cross examination where I did a moment, okay, and that is when I think Mr. Alessi was questioning. I think his question was about the time frame, okay, and he said 2.5 years. And the witness said it's been like 8 months. Okay. The only reason why I did a little moment is because he is so detail oriented. Is it, I think I think he misspoke, but it happened. And I think what he was actually trying to say is basically it hasn't all of this data and whatnot been available for 2.5 years. And you guys have been working. Why were you guys called in the last 8 months? You know, if Trooper Paul analyzed the data correctly, then how come y'all are even necessary? And I really think that's what he was trying to get at, but it didn't come across that way. And so, obviously it really wasn't the best, but I think by and large, he's doing a really good job with the cross examination. I think that, yeah, he did it another time too. And I can't remember the other one because I only really noticed that one. That was the biggest one to me. But I didn't think it was too awful overall. I don't think it really took a whole lot of weight. Like, it didn't give the witness more credibility. That answer didn't, and that misstep or misspeak didn't really do anything. I don't think in the jury's mind. They're a younger jury, as I understand it, and I think that hold on a second. I need to acknowledge Mac. Just give me a sec. Sorry about that. I don't know if y'all could hear him, but I have headphones on and I could hear him. So I would imagine that y'all probably heard. He's still doing it. I already acknowledged him. There's nothing else I can do. So he's just going to cry back there. I'm not sure. Maybe he needs an acknowledgement for Alice. I think he's calling her too. But he can't. I don't know how he's missed where she's at. She's literally sitting on top of the dryer. Okay. Like, he just walked past her. I don't know how he missed it, but whatever. Anyway, I feel like one of the things that's kind of annoying to me about Dr. Welcher in some of his responses is, you asked me 2 questions. You asked me 2 things. I also don't like the fact that he is constantly looking at things he's not supposed to be looking at when he's testifying. Hey, Harley, good to see you. And I wanted to say hi to, I missed saying hi earlier to Lisa, who came in right before lunch. And I didn't want you to think I didn't see you. I do see you, and thank you for being here. I think that the thing that's particularly irritating to me about that is he's testified many times in many different trials and many different types of cases. He's testified both civilly and criminally, and he's testified at the federal level as well. And that is just like basic court knowledge, court etiquette, court behavior. Okay. The witness is not allowed to read from anything unless they're told to. They're not allowed to reference material unless unless it's asked. Looking at, your report, help refresh your recollection. And even then, it's only intended to refresh your recollection. So it's bothersome to me. It's distracting. I think it's poor etiquette. And, I feel like, I mean, he testified that he looks at he's been looking at his report almost every day since, the last since he wrote the damn report. Do you know what I mean? And adjusting and tweaking the slides, so like how do you not know how to testify to your findings without directly reading from your materials? I don't understand that. And he continues to do it. Exactly, Neat. This is my issue with him. Neat says a witness with no agenda answers the questions without getting defensive. The data is the data. It's not personal. And also, especially because he has trial expertise, and he ought to know that this is the other side's job, regardless of who he was retained by, okay, or the company was retained by, and who he did the work for. You're going to have your work is going to be questioned by the other side. And so what is what's your issue, bro? Like, this is how it goes, and you should know this, and you're so defensive. You've already admitted. I don't understand. It's like almost a prerequisite. If you're going to testify for the Commonwealth on cross-examination, you need to pretend like you don't understand the question that's being asked and give an answer to a question that wasn't even asked, that's basically justifying why you did a piss poor job or why your calculations were incorrect. Even Doc Brown, okay, always added the caveat before he would answer Marty's question: if my calculations are correct. You hear that if in there? Even, and by the way, Dr. Emmett Brown's calculations were always correct. But he every single time he would say, if my calculations are correct. He even understood that there is a potential for human error. What's your problem, Dr. Welcher? It's very frustrating. It's like that, it makes you wonder if when Brennan is preparing these witnesses, which they're allowed to do, there isn't anything wrong with that. Now, what you're not allowed to do is during the middle of the trial, Brennan, is to forward or send clips of the defendant making statements in interviews and ask the witness, hey, by the way, on the low, can you watch this clip I'm about to send you and make any changes or adjustments you feel necessary to your slideshow, to your report? Could you? Would you? If you think, just only if you think it's necessary. You're not allowed to do that, okay? But you are allowed to prep your witness. So it makes me feel like part of the prepping process is these instructions: get defensive, act indignant, answer a question that's not been asked, just justifying and explaining why you doing or not doing something is totes fine. It's no big deal. And you don't, and get this really squinched up, puzzled look on your face, like you don't even understand why you're being asked this question, that it's so outlandish. That's like his prep for the witnesses, because they all do it. Even lay witnesses. McCabe, looking at you. It just boggles my mind. I cannot wrap my brain around it. And I'm so curious. And I really, 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 really hope that when it's time, when the jury renders their verdict, I hope that at least one of them will be amenable to talking about this trial and how they viewed the evidence and their impressions, because I'm so curious if the jury is seeing it the way that we're seeing it. I mean, what's taking place in the courtroom is taking place in the courtroom. It's our perception of, what's taking place. And I'm very, very curious if our read and our perception on what's taking place in the courtroom is coming across to the jury, if they see it the same way. I'm always curious about that. You know, I just find that fascinating. And I'm also like, typically, this is another reason I'm annoyed with the Commonwealth's expert witnesses, because I typically defend expert witnesses. Typically, they're not, I don't know another way to say this, but like hired guns for either side. Okay. Typically, they are given data, they analyze it, and they make their reports and give their opinions based on that. Okay. These are people that have gone to school. They've, are highly educated. Educations are not free. They're expensive, not just financially, but time, all of the things. Okay. So they're not most times an expert witness isn't, they're not willing to mess up their reputation for whatever they're getting paid. Most of the time it's not worth it. Okay. But in this situation, and I vehemently defend expert witnesses, even if I don't agree with what they're saying. I will defend the fact that they believe it. They're not like, they don't, they said what they said. These are their determinations. You know what I mean? And yes, this time it happened to align with whichever side retained them. And so therefore they decided to go ahead and put them on the stand and have them testify. But it does feel like, because of the things that were done while the trial was going on behind the scenes by the state with respect to these two witnesses from Aperture, it does feel like that's what's going on. And that it really irritates me and it makes me mad, because it's such a bad look for expert witness testimony. And it's really frustrating to me, and it really makes me mad. Give me just a sec. Hold on a minute. Let me hold on. I got an email or a notification. I need to check something really quick. Okay. Okay. So sorry. I got a notification from PayPal, and it didn't make sense to me. It still doesn't make sense, but I'll take care of it when I'm done. Okay, so Violet says, Alessi, quote, "Sir, what color is a banana?" Judd Welcher, "Well, I drove my car to a store that sold bananas, so what do you mean by color?" Exactly. And to further that, he would say, like, he would ask follow-up questions. Are we talking about a peeled banana? Are we talking about the peel of the banana? And if we're talking about the peel of the banana, are we talking about a banana that's not ripe? Are we talking about a banana that's ripe? Are we talking about a banana that's overripe? Are we talking about all of the various stages in between ripe and overripe, and then subsequently rotten? I mean, what do you mean? Define the word color. It's like he's watched The Princess Bride and heard the thing that what is it? You keep using that word. I do not think it means what you think it means. Like, he's heard that phrase all the time, and that's just what he repeats. That's like part of his answer. That doesn't apply every time somebody asks you a question. Okay, that phrase doesn't apply every single time. All right. I I can't. It's too much. Yeah. What does the word color mean to you? I don't get it. I don't get it. It's too much for me. They ought to be coming back from lunch any moment now, I think. Let's see. Yeah, any minute. Any minute. They'll be back from lunch. Right. And then don't get me started on plantains. Do you consider plantains a banana? Are they just plantains? Are they part of the banana family? Yeah. Sissy's mom said this is going to be unpopular, but I don't like the Princess Bride. Listen, I can accept that there are movies that are near and dear to my heart that other people, they're not as near and dear to their heart. They might not be, it's possible that other people don't like the same movies that I do. I get it. And I've accepted that. Yes, Violet, mostly dead is slightly alive. I can accept that. I can. I have to. It's, I understand that that's the way that the world is, and I get it. Let me, I gotta go. My phone is about to be like done. So let me go grab my charger. I'll be right back. Just give me 1 sec. Okay. Be right back. Sorry about that. I actually think that you're right, Violet. Although, um, okay, The Princess Bride is on Max, and it's been a minute since I've watched it, and I feel like after the day that we're having, I feel like I might watch that tonight just to welcome back, Tess. It's good to see you. But yeah, I do like The Princess Bride. There's a lot of movies that I like that I have to go back and watch every so often, just to refresh my recollection. Yeah. So there's that. Good Lord. But rest assured that I'll be working on the West Memphis 3 before I watch The Princess Bride. Also, some of the other videos that I'm working on are the Gypsy, Rose Blanchard, Nick Godejohn, and the murder of Dee Dee Blanchard. I'm going to update and rework those videos a little bit, particularly because her some of the discovery in her case has now come out because Nicholas Godejohn has exhausted his direct appeals at the state level. So that stuff has been released. So I'm going to, and I never did get to the part 3 of it. So that'll be one of the things. There's just I have a ton of videos on my channel. And so I think that they deserve to be updated. Like if there's new information, and also I do feel like they deserve to have the editing skills that I have acquired over these last 4 years of making videos. So that is my plan. And that's, what I'm going to do. So yeah, there's that. That's my plan. Come on, you guys, come back for, like, my stomach is eating a hole in my back and I want to eat something for lunch, but I don't know what I'm going to eat. He had, yes, Violet, Nick got life without the possibility of parole. Sissy's mom, it's not about her. Okay. For me. And I get it. The story's not about her. The story is about what happened, the crime. And I understand, I get why people are over her. I'm over her, but I did promise that there would be 3 parts. And I have a feeling that there's going to be information in this newly released discovery that was, that I did not have at the time I made those other 2 videos. So I feel like, for completeness, I should go and look just to check, So I think that would be, fair. I think that would be the right thing to do. But I get it. If you feel like you're done with Gypsy Rose and you need to pass on that video, I don't blame you. There's plenty of other stuff on there that I'm putting up that isn't Gypsy Rose or the West Memphis 3. And so something on there should pique your interest, I'm sure. I hope anyway. I see some jiggling. I don't know if that is, we're going to be moving and panning down, or if that means that somebody bumped into the camera, but I'm guessing it should be any moment. I agree. Sissy's mom, she didn't. You're so good to take care of your parents, Tess. I hope that when I get to the stage that I need to be taken care of, that one of my kids, I've got 4. So, hopefully one of them will be like, mom did kind of take care of us, or, maybe we don't want to, shuffle mom off to the home. No matter how big of a pain in the butt she is, we're not shuffling her off to a home. So I'm hoping that one of my kids, at least, just one. Hell, it might end up being that, my little chicky nugget pot pie, she'll probably be the one who's like, no, I'll take care of Granny. I hope so anyway. Somebody. I hope. Oh, you're welcome, Tess. Yeah, I mean, it can be I can imagine it would be frustrating. My mom, rest her soul, she used to frustrate the shit out of me. You know what she used to do? Okay, so she used to call me and she'd be like, Jen. And I knew right then from that tone, oh God, she's going to ask me about the freaking computer. She'd say, I have a question about the laptop, which when somebody isn't really familiar with how a computer works in the first place, doing it over the phone is like 10 times harder. Okay. And God love my mom, right? But I would tell her every single time when we started out, all right, Mom, tell me what's going on and we're going to work through it together. But for the love of Pete, don't click on anything unless I say click on it. And inevitably, every dadgum time, she'd just be randomly clicking on stuff. And I'd be like, Mom, and then wouldn't know how to go back. She wouldn't know what to do after she just clicked on something that I specifically told her not to click on. And then she wouldn't know how to undo the click. And I sometimes I would sit on the phone with her and I would never give up. I'd be like, Mom, we're going to figure it out. We're going to do it together. Boy, she would test my patience. But anyway, sometimes I'd have to be on the phone with her for like hours, trying to figure this out with her, because then I'd have to figure out what it is that she actually clicked on, because sometimes she wouldn't even know what it was that she clicked on. So she couldn't even undo the click. And then I had to try to figure out, but you know what? If it meant that I could have my mom back, I would do it all over again. I would sit on the phone with her for hours. I actually miss that. Now I'm not going to, look, my mom was a human being. She was not infallible. She's not a saint. Nobody needs to canonize her, but it's weird, the things that I miss. You know what I mean? Like things I wasn't prepared for. And that's why, even though what happened, my mom, her death was sudden. Okay. And it was, she had the widowmaker heart attack. Okay. And it was sudden. I can't imagine how I would feel if her life had been taken at the hands of another person. Okay. I don't know how I would feel about that, but I do understand, even though it's not the same type of death, I think grief is grief. And I think that, I think that's why I kind of like, I'm not frustrated with Mrs. O'Keefe or the O'Keefe family. I feel like they have to come. I feel like it's a process, and they'll come around to seeing things that, maybe the Commonwealth doesn't have it right. Maybe maybe they will have questions, but they'll do it in their own time. And I feel like it's different for us. We're watching as an outsider's perspective, and even though we really care about the victims and want to see justice for them, the details matter to us. We don't know these people. So it's easier for us to be objective about the evidence and about the way that the evidence was collected and the crime was investigated. It's much easier for us in that way. And I think that we should give Mrs. O'Keefe a little grace, probably a lot of grace, really. I give her grace because of that, because grief is complicated. And, if I felt like when we finally, my mom had to have an autopsy because, it happened at her house. So if I would have felt like the autopsy wasn't conducted correctly, or if I ever had a question, if I thought that it was something, if I thought that it wasn't the widowmaker, and I did think that somebody had taken her life, I can't imagine how frustrated it would be if somebody were telling me, no, she died of natural causes. I would be frustrated. So I feel like with the O'Keefe family, it's the other way around. And I feel like I would want grace in that situation. So I will give grace. I'm not judging anybody for what they do. I'm just saying for me personally, Yeah, Sissy's mom. What a good memory, though. Sissy's mom says, my mom would call me 11 billion times on my birthday, telling me what was going on at that moment, whatever age I was. It drove me nuts. 28 years later, I still miss those calls. Yeah, you miss that stuff. And I tell my kids all of the time, you know how you guys roll your eyes and you're so over all the nagging and the worrying that I do and the fussing and stuff? You're going to miss that. In fact, that's going to be the first thing that you miss, because you're not going to have me around reminding you all the time and, nagging at you. They call it nagging. I call it reminding, bringing things to your attention. I do it because I care. I'm over here like Monsters Inc., okay? I scare because I care. you know? If I didn't care, I'd just be like, you know, you're an adult now, figure it out, you know? But I would never. I care about them too much. And if I can see a way of showing them how to do something that'll make it easier on them in the long run or prevent, you know, a negative consequence, well, I feel like it's incumbent upon me to do that as a mother, you know? And let me tell you, I do miss those days. I miss the days when my kids all looked at me like I was the smartest woman in the room at all times. I knew all the things, you know, I hung the moon. And then it's like one day they ask you a question and then you give them the answer and they look at you like you have potatoes growing out of your ears or something. I don't know. It's just like it's so abrupt. Nobody like even though I have 4 children and there's a significant difference in age between my youngest daughter and my oldest daughter, like it's not like I hadn't been through it 3 times before. But when it happened, when it happened with Minnie Bindi, it was still abrupt and it was still shocking and it didn't. I was still not prepared, and I walk around all the time wondering how could I not have been prepared for that. Oh, Carolyn Cooper says, my dad was 91 when he passed in 2019. He didn't know how to use a cell phone or computer. I took care of both of my parents until the end. I'd give anything to have them back. I'm lost. And that's the thing. They don't tell you, like, when you become an adult, okay, even though, like, you are aware that you know, nobody lives forever. Like, everybody's aware of that, right? But they don't tell you how it messes with you, like how it throws your, even though you've been living apart from them, you and all that, and you're an adult and you have your own family and your own life and everything like that. Nobody tells you when your parents pass how much of a tailspin it throws your world into, and you don't ever recover from that. That's why I don't really like that phrase, time heals all wounds. I don't think that's true. I think the more accurate description is that in time, you learn how to live with that wound. It doesn't heal. All right, let's go. Oh, I love that. Violet said, I send my kids random. Today is National Whatever Day. Like on National Pie Day, I Venmoed them $3.14. I love that. Exactly. The pain just gets more bearable. You just learn. It becomes part of your everyday life. The hole in my heart that exists for my mother is never going to be healed. I've just accepted it.
Go ahead, Mr. Lassie, whenever you're ready.
Hold on. I was totally talking and I muted myself. Let me just say this one last thing and then I'll be quiet. I like Karen's outfit of the day today. I like that color. I forgot to mention that earlier. All right, let's get going. Sorry about that, y'all.
Just take a moment, Your Honor, to reorient. I'll be right. Good afternoon, Dr. Welcher.
Good afternoon. Nice to see you again.
Same. We had left off talking about some examples of Newton's second law and the application of it in the parlance of force equals mass times acceleration. And I now want to continue on with that discussion. It is correct that you can conduct a force analysis on any part of the body, correct?
I mean, it's more difficult on internal with live people. Like if you wanted like my appendix, I really necessarily couldn't.
Let's talk about the musculoskeletal system, the outside bones. You can conduct a force analysis
So your
on any
bones are
bone.
on the inside.
Sir, if I could finish my question, please.
Okay.
You can conduct a force analysis on any bone in the body, correct?
More or less, yes.
So the force analysis I use as a synonym with Newton's second law is not exclusive to the head, correct? You can do it on other bones in the body, correct?
Correct.
On direct examination, your direct examination here, you did not present a force calculation representing what you allege to be contact between the vehicle and Mr. O'Keefe's right arm, did you?
Correct.
And nowhere in your report do you present a force calculation for Mr. O'Keefe's right arm, do you?
Correct. We didn't have enough information to do it.
We're going to get to that.
Okay.
Now, given that you stated that, quote, determining the effects of physical forces on the human anatomy, end quote, is the job of a biomechanical engineer, you must have conducted several force calculations related to accidents involving humans in your career, correct?
Hundreds.
Hundreds. Now, you didn't present a force calculation in your materials, as you've stated on direct, with regard to the arm, and I'll include in the right arm going from the shoulder all the way to the tip of the hand, okay? So that's my definition of a right arm. You didn't present any force calculation on that part of the body of Mr. O'Keefe, did you?
Correct.
Assume, and we're going to apply Newton's second law. Assume Mr. O'Keefe's hand weighed 7 pounds. So that's the M in the F equals MA.
That's not a good assumption.
Well, what number would you like to apply for an M for the hand of Mr. O'Keefe? I'll take any number you got.
Just the hand?
Just the hand.
Oh, the whole arm of Mr. O'Keefe weighs approximately 12 pounds.
Okay, fair enough. So the whole arm, is either from the shoulder down to the tip of the fingers, is about 12 pounds, right?
Correct.
Okay. So assume that the Lexus SUV was traveling at 20 miles an hour. All right? Under your theory going backwards, 20 miles an hour. And the third variable I'd like to give you is to assume an impact window of 10 milliseconds.
Okay.
Can you calculate the G's of force from that data?
You need more information.
Well, let me ask you this. What more information would you need?
So we talked about the glancing impact.
I'm talking about a force calculation of an impact, not as to whether it's glancing or not.
So you want a direct head-on impact in the arm, not a glancing hit to where the Lexus comes in, hits the arm, and they continue off together?
I'd like to start with that, but just so we can hopefully expedite it for the jury.
Okay.
I'm going to want to get to what you have depicted in your diagram of holding the arm out. And that's not a glancing impact. Is that, sir, with the right arm in parallel with the back of the Lexus?
Yes, it is. So really I'm sorry, let me finish, please. What you're concerned about is where the center of mass is. With the center of mass out towards the corner of the car, that becomes a glancing contact. So you don't have a center of mass contact, you have a glancing contact.
Okay, fair enough. Well, so let's start the first force calculation.
I need my calculator.
I'm going to let him use his calculator.
Sure.
Okay,
Tell me when you're ready, sir.
go ahead.
So let's take a scenario where it's a center of impact,
Center of mass.
center of mass impact, right?
Okay.
impact to the right eye.
Okay.
Let's start with that one.
Okay. And you want me to use like a 10 millisecond?
Yeah, be conservative. Yeah, let's use a 10 millisecond for
Okay.
the impact window.
Okay. Question?
What do you get for F of force in the F equals m times a calculation?
About 2,188 pounds. I made a triangular crash pulse assumption.
Right, and if you took the milliseconds in half, become less conservative, would you end up doubling the 2188 number?
If you cut it in half, you would double, yes.
Exactly, through a simple mathematical, semi-algebraic application of the numbers, correct? You divide.
Correct. We're doing a little simplification in terms of the crash
Yes.
pulse shape, but generally, yes.
Right. So, but let's take the conservative number, the lower number, 2188, that you came up with. Do you know from the literature, as you did with the head, you went to the literature and said, this is how much pounds of force, the F, you would get to have to cause a break at the occipital bone. Do you know from the literature how much force it would take to break an arm bone?
I have an idea, yes.
What is your idea?
So for a distributed load, such as this, not a concentrated load, you're going to need somewhere between, I've seen, and this is for cadaver tests, a low of like 2,500, maybe a little lower, to a high of 7,000.
Sir, you have switched, haven't you? We're talking about center mass impact. Did you in your calculation just switch to a side swipe impact to
No.
do your calculation?
No.
I'm asking about a center of mass impact. How much force would you need? Let's start with the hand. Maybe it's a simpler one. Do you know how much force it takes to break, any of the hand bones, you know what I'm referring to, the phalangeals?
Yes.
The metacarpals, and the carpals?
Correct.
How much pounds of force do you need to break any one of those bones?
Actually, I didn't find any distributed loading on the amount of force. I don't know.
Well, no, I understand. But I'm asking, Do you know from the literature, not a calculation, doesn't the literature tell you, can't you go to the literature like you did with the head, and you say, okay, to break the occipital bone, the literature says you need a minimum amount of force of this. I'm asking you the same question for the hand. If you don't know, it's okay, but do you know what the literature says for how much force is needed to break a bone in the hand?
So for a distributed load across the hand, there are distributed load tests that show you need over 300 Gs on the arm to do that. So it would depend on the mass of the hand.
What is the range of force that you would need to break a bone in the hand? Do you know from the literature? If you don't, that's okay.
I could probably figure it out.
How long would it take you to figure it out? Do you know from the literature what that number is?
Not off the top of my head, no.
Is 300 to 400 pounds of force sound right from the literature that it would take to break a bone in the hand?
For a distributed load,
Yes.
such as the taillight, no.
No, not a distributed load. A load from a motor vehicle going backwards.
Right, that's a distributed load.
Right. So you're saying 300 to 400 pounds of force would not be enough to break any bone in the hand. Is that your answer?
So for a flat distributed load, like hitting the taillight, you're going to need higher.
How about another part of the back of the vehicle?
I guess if you hit on the very corner and it wasn't a distributed impact, like if you had a more concentrated impact,
Yes.
that could increase or decrease the amount of force required.
How much would it decrease it from the number you gave?
Depends on what you're hitting, what it's made out of,
The
contact
Lexus
area.
SUV. Let's assume, I'm sorry.
Mr. Les, can you repeat the question, please?
Absolutely. Thank you. Let's assume we're talking about this Lexus SUV, right? Well, let me back up. You don't know where exactly, under your theory, that there was a contact. You don't know, you testify to on direct, you don't know exactly where that point of contact is, do you?
Correct.
You don't know.
Except it's on the taillight.
Well, you're saying it's on the taillight, but you didn't observe any impact yourself personally, right?
Did I see Miss Reed's Lexus?
You didn't see the impact, correct?
That is correct.
So, and there is no firsthand witness that saw, under your view, that a collision occurred. There's no witness to say where the arm was, correct?
There's no person that saw it.
Right. And you have chosen a point of contact, okay? You chose that for your analysis, correct?
Correct.
And you picked that location, but it's also possible that under your theory that a collision occurred, that that arm could have been impacted any part of the back of the vehicle. That's possible, isn't it?
That's not probable, no.
I'm asking, is it possible?
Anything is possible. I don't deal in possibilities, I deal in probabilities. It's not probable.
So, but you don't know exactly where the point of impact was, correct?
So within the range of the light and the exact angle of the hand, no, I don't. What I do know is at the rear tail light area.
So your assumption is that it had, that because there's a tail light that is altered, it must have been by Mr. O'Keefe's arm. That's your conclusion, correct?
My conclusion is there are tail light fragments, a broken glass, lacerations to his arm, and his DNA on the back of the vehicle in the area of the tail light.
Sir, and Your Honor, I'm going to move to strike the DNA part of that answer for obvious reasons.
I'm not going to strike it.
Okay, so you're making assumptions. You're taking what you view to be certain data, and you're coming to a conclusion, but that is based upon circumstantial information, correct? Is that fair?
Are you calling like pieces of the tail light at the scene around his body circumstantial information?
Sir, let me go to the force and go back to the force analysis. Let's go back to the numbers. I want to stay on, if we can, just the calculation. So let's go back to the minimum amount of force you understand from the literature that it takes to break any bone in the arm from the finger up. Let's start with a hand. What's the minimum amount of force that can be applied to break a bone in the hand?
So it depends on the loading. So I don't actually know. In terms of the forearm, I can tell you there's data that shows up to 300 Gs of loading, you will not get fractures. There's one up to 750 Gs showing no fractures for a male of similar height and weight of Mr. O'Keefe.
Thank you.
You're welcome.
So let's take those numbers,
Okay.
okay? You said 300 and 750. Did I hear it correctly?
You did?
Okay, that's the numbers you gave that would break a bone, correct?
So the 300 actually didn't break any bones, I believe. The 750, the one example, didn't break a bone, but as you got above 350, you started to break bones.
So as
300.
you got above 350,
300.
above 300, yeah, because that's what I thought you said the first time. You got above 300, you start to get breaking bones, correct?
Correct.
And so if you take that 300 number and compare it to the 2,188 pounds of force, you have 7 times the amount of force necessary to break the bone, correct, in the force analysis?
No. If you take 300 Gs times a 12-pound arm, you get 3,600 pounds. The calculation you asked me to run earlier gave you 2,188 pounds.
Right.
So you are 1,412 pounds above the force required. Like the tolerance is 1,412 pounds above the force you would say get in a 20-mile-an-hour impact in terms of the fracture forces.
Let's do it this way.
I'm sorry?
Let's do it this way.
Okay.
The force that you calculated from my hypothetical of this Lexus SUV going backwards, you came up with the F number of 2,188, correct?
I'm sorry, I didn't. What was the? You said
2,180.
You said dyslexic. Or do you say Lexus? I didn't understand what you said.
The Lexus
My apologies.
SUV that you've been talking about.
Gotcha.
Okay?
I didn't hear
you
it.
Came up with a number for F for force of 2,188. Are you changing that number?
Nope.
Okay,
Absolutely
so
not.
let's go with your number of force from this vehicle of 2,188. I'm just simply asking, how much force does it take to break a bone in the right arm of a human being? How much force, not acceleration, how much force does it take to break a bone in the right arm?
Sure. So somewhere between 2,500, the one cadaver tested the distributed load of someone of similar size and weight and actually close in age to Mr. O'Keefe showed about 7,000 pounds of force to break it.
Let's go to the hand. Do you disagree that the literature shows it only takes 300 to 400 pounds of force to break a bone in the hand? Do you disagree with that?
Your question's too general. I can't answer your question. It depends on the loading. If I take my pencil, which has a very fine point, and jam it through my hand, I can jam it right through my hand because it's a very small point. But if I distribute the load in a broader load, such as hitting a taillight, it takes much more force because the load's distributed across it. It's like if I sit on the corner of my bed. I might sink in this far when I sit on the corner of my bed, but what happens when I spread my load out, when I lay on my bed like this? I don't sink in as far. Has my weight changed? And weight is basically force. No, but I've distributed it over a larger area, so for a given force, you get less sinking into the mattress. So if you hit a broad surface like a taillight or a wall like this, it takes much more force than if I were to take a singular small round object and jam it into the hand. That hurts. This does not.
Okay, if you can hear my question, if it's unclear, you tell me. For not a pen, not your bed, but for a Lexus SUV of 6,000 pounds, Is there any part of the back of the Lexus in any manner where you can get a break to the hand from 300 to 400 pounds of force?
Any part on the back of the Lexus?
Yes.
Probably.
Okay. So probably, your words, you can get a break to the hand from just between 300 to 400 pounds of force. That's what you just said, correct?
So you're taking the totality of the back of it? Like if you got it stuck in the bumper? Potentially, yeah. But from a taillight or a broad flat surface? No.
I'm not asking about a taillight. Any part of the back of an SUV, you agree that it is probable that you can get a break of the hand bones from just 300 to 400 pounds of force.
Your question is incomplete, right? You said any part of the back, but then you wanted me to not include taillights or not include the rear body panel. If you hit a very narrow part of the car, like say the edge of the tailpipe, that creates much more of a narrow contact. So force divided by area is pressure. So if you have a very tiny area, you have very high contact pressures. And so, but if you distribute the load over a larger area, the number on the bottom of that fraction is much bigger, so your contact pressure drops. So hitting the edge of the exhaust pipe is going to have a much higher likelihood of causing a fracture than hitting flat against the tail light.
Okay, what we're going to do to make this more efficient, excuse me, sorry. Mr. Wolk, can you pull up a slide from Mr. Wolk's, or Dr. Welcher's presentation for the back of the Lexus, please? The back hatch, and Your Honor, may we publish that?
Sure. Do you know what number, though, Mr. Lessons?
Mr. Wolk does, and
And
I
then
know
he'll
you
tell
need it,
us.
so he'll tell me before I publish, and then we'll give you the number.
Your Honor, may I look here?
Yes, I'm going to let Dr. Welcher look at his slide
Oh, sure.
here
Yeah.
instead of just up there.
The back hatch, yes. Do you have one of just the rear gate? The one measuring the height, maybe? There we go. Thank you. Okay, this is your slide presentation. Is there any part of the back of the Lexus SUV that has that more concentrated area where if the hand hit it, 300 to 400 pounds of force could break it? Is there any part, for example, the edge of the license plates, above the license plates, the L symbol that sticks out that would be concentrated? Anything you see there, could 300 to 400 pounds of force contacting at any of those points cause a fracture of any of the bones of the hand?
So, I don't know how to show this because in the middle photograph, right where the 2 is on the license plate,
Yes.
there's a vertical edge. That area is recessed in. So if you hit right on that vertical edge, that could potentially do it.
That could do it. How about the L of for the Lexus symbol if the hand is there?
No, it's not deep enough. The compliance of the hand is just going to sink into the car.
Is there any other part other than the license plate that the force applied, you would only need 300 to 400 pounds of force to break the hand?
Maybe the exhaust pipe, and potentially if you hand your hand up near the spoiler.
Right, so now let's go from 300 to 400. Let's go to the 2188, which is your number. Use 2188. Is there any place where in 2188 force you could have a fracture of the hand on that back gate?
Just to be clear, 2188 is the number I calculated for you. It's not, quote, my number.
I understand, but we did.
So-
I understand, but we did the calculation. Is there anywhere on the back of the vehicle where 2188 could cause a fracture of the hand?
So that was a forearm fracture tolerance I thought we were talking about, because we used the weight of the whole arm for that.
We did. And my question is there anywhere in the back of the vehicle, in your opinion, that could cause a fracture with that
I'm sorry, what, to the hand? Just the hand or the whole arm?
I'll take any part of the right arm. You call it the hand, the forearm. Is there any part that could cause a fracture?
So probably similarly, if you got your forearm down near that transition, like, I don't know if you can see the little dot. I'm talking about this area.
Yes. Yes.
Right here.
Yep.
So that transition between the two body panels.
Yes.
That could potentially do it. That's back where the reverse lights are. I'd have to look at whether, that would take it before breaking the plastic. And then, again, maybe if you hit the exhaust pipe as well. It's a much more narrow loading condition.
How about the corner of the tail lamp?
The corner of the tail lamp. I suppose if you had just your hand on the very, very corner, potentially.
Potentially. But you didn't do any of that force analysis for this case, did you?
For the hand, no.
But you did it for the head, correct?
Correct. Because that I'm able to quantify.
Mr. Alessi, that was slide 108. I just want to
I'm
keep
sorry,
you
Your Honor. Yes, Mr. Wolk. Yes.
All right, thank you.
Thank you. You are aware, Dr. Welcher, that Mr. O'Keefe suffered no fractures of any kind in his hand, correct?
So there were no fractures noted in the autopsy report, but they didn't actually x-ray, from the records I've seen, either his hand or his arm. So there was, at least according to the autopsy report, no overt fractures, but the x-rays I saw, none of them were of the arm, and the autopsy report said no sternum, spine, I think it said torso. They didn't say that there were no fractures there.
Was there any evidence in the medical records that you reviewed of any indication whatsoever of a fracture in Mr. O'Keefe's hand?
No.
Was there any indication whatsoever in any of the medical records you reviewed that there was a fracture of any bone in the right arm of Mr. O'Keefe?
Not that I saw. Again, it wasn't x-rayed.
Was there any indication in the medical records and the autopsy that you say you reviewed of any fracture of any bone anywhere in the body of Mr. O'Keefe?
Yes.
Other than the occipital bone or the skull?
There's a couple bones in the skull that were fractured, but other than the skull, no.
Correct. So, are you aware that the medical examiner for the state of Massachusetts, Dr. Shorty Bello, performed an autopsy on Mr. O'Keefe? Are you aware of that?
Yes.
And you're aware of it because you read the autopsy report, correct?
Correct.
Are you implying, and it's a question, that Dr. Shorty Bello missed a fracture or didn't look properly for a fracture on Mr. O'Keefe?
No. I'm simply indicating that, for example, a hairline fracture, I didn't see any evidence that they actually x-rayed the structure, so there would be no overt evidence of that.
There were wounds on the right arm of Mr. O'Keefe, correct?
Correct.
And you are saying that the medical examiner should have x-rayed that to determine whether there was a hairline fracture? Is that your testimony?
No, you're asking me about evidence and proof of absence of fracture. So I would look for an x-ray to see if that was the case. I haven't seen any evidence of an x-ray of the arms.
So it's your position that on every autopsy, there should be an x-ray of every bone in the body and that the clinical judgment of the medical examiner should not be accepted, and there should be an x-ray of every bone before a conclusion can be drawn that there's no fracture to a bone in the body of the deceased. Is that your testimony?
Absolutely not. Like, I'm an engineer. You're asking me about proof. And so proof is somebody looked at it, somebody took an x-ray, somebody palpated it and found a comminuted fracture. So we're talking about proof.
Sir, I didn't use proof in my question.
You're asking me about the opinion of a medical examiner? I'm not a
Hold
medical.
on. Only one person at a time. Mr. Alessi, let him finish, and then you can ask the question.
Your Honor, I hadn't finished my question.
Okay, then finish your question, Dr. Welcher. Wait for the question. Then let Dr. Welcher respond. It's a nightmare for Madam
I
Court
understand,
reporter.
and I think I've been doing that, but I'll redouble my efforts. Dr. Welcher, I didn't use proof in my question. I'm going to repeat the question. Is there any indication in any medical record, autopsy report of the deceased of any fracture of any bone in the body?
That was not your original question, but to answer your question, no. Except for the skull.
Except for the skull.
Correct.
Do you understand whether the absence of any fractures other than the skull of Mr. O'Keefe was of significance to the medical examiner, Dr. Scorty Bello, in the conclusion she reached in the autopsy report that you read?
System.
Did you read the conclusions of Dr. Scorty Bello in the autopsy?
I believe so.
Are you aware of whether Dr. Scorty Bello has analyzed whether the injuries to Mr. O'Keefe are inconsistent or consistent with a motor vehicle impact? Are you aware of any analysis to that effect?
So I'm going to see you on this one.
I'd like to see everybody at Sidebar. What in the absolute F is going on around here? This witness isn't allowing Mr. Alessi to finish his question before he answers, and he's taken the extra measure in the answer prior to in his response prior to actually answering the question to correct Mr. Alessi. He's rude. Period. So to answer Allie, okay, apparently it's a new feature on the tubes. It's basically audience participation. The more you participate via chat, via super chat, super sticker, you get higher XP. And it resets every single time it resets after every live. And I think I can't figure out if it resets every live stream, but I don't think it keeps like a running total of like cumulatively in a week. Like, for example, I have, 400 XP and Tess has 11 billion XP, like at the end of the week. So it doesn't do that, but I guess, I wish it would though. But it does, no, it just came on, Allie, the other night when I came live, boom, there it was. And the more you chat, the more you get one. So, yeah, And I would not I wouldn't clarify, I wouldn't say that Tess says it shows I yap too much. I wouldn't classify it that way. I wouldn't characterize it that way. What I would say is that it shows how much you participate in what's going on. Yes. Yes. Sissy's mom, like, it's, yeah, you get it, then you lose it, then you get it again. And I mean, you don't ever actually lose the crown. You just, the place moves up and down. You know, like pretty much Sissy's mom has been in first place, and then boom, they just yank it away from her. So I signed up, Allie, a long time ago to be a beta tester for YouTube. And that might be why I have it. I don't know. I don't know how I got it. I just came live one time and boom, there it was. And I was like, oh, look at this little feature. Isn't this handy dandy? So yeah, there it is. Oh boy. Oh wait, hold on. I saw something here that it made me want to look at. Yeah, but you do lose it. You do lose it. Oh, we might be a little bit behind. Let's see. That did not help us. I don't know if, I don't think that the jury is sleeping, but I will say, Lisa, that I do think that the jury probably finds the way that this witness is testifying on cross-examination off-putting. It's not that it's okay for a witness to not understand a question or need clarifying of a question before answering. Like that's not an issue. But it's the way that it's the tone, which in my opinion is stank. And it's the way that he comes across as needing to be the smartest person speaking. And you'll notice that that wasn't an issue with Mr. Brennan. I'm going to leave it there. You take that how you want. But when it comes to Mr. Alessi, he comes across as needing to be the smartest. And it's really off-putting because he's arguing with the defense attorney, number one, not really asking for clarification, but instead correcting Mr. Alessi. Mr. Alessi knows exactly the question that he's trying to ask this witness in order to elicit specific testimony. He is, he knows what he's doing. He's quite competent. And I feel like it's a mess. It's coming across like he's not actually confident in his work. I'll give you guys an example, and I know only because this is something that I'm doing right now, and so it just comes to my mind. But whenever I have made videos about with the West Memphis 3, inevitably I will get at least three comments or more that say something to the effect of, you've based your opinion on the documentaries, okay? Even though it's clear from the videos where I actually show documents, testimony, stuff like that, exactly where I came up, where my opinions come from, okay? And because of that, because it's such a ridiculous thing to say, I typically don't address it. You know what I do? I give him a heart and I keep it moving. You see what I mean? This guy's so defensive that it comes across like he's not confident in his work.
May I, Your Honor?
Yes.
Thank you. Dr. Welcher, I would like to talk now about your paint exercise.
Oh my God, hold
You did
on.
not-
Hold on, Mr. Alessi, I do not want to interrupt you. Please pardon me, Mr. Alessi, but we need this right now. Where is it out? Because now we're going to get into the paint. You thought he was defensive before? Wait until Mr. Alessi starts questioning him about his craft project. Here we go.
present, as you
Let
have
me rewind
stated, a
it.
force exercise. I would like to talk now about your paint exercise. You did not present, as you have stated, a force calculation with regard to the arm. You did a paint exercise, and what I want to do is to reference, and if we need to bring it up, sir, to refresh you, slides 103 to 120 of your PowerPoint presentation in this trial. I'll just call it the blue paint exercise. Is that descriptive enough for you to know what I'm talking about?
No, it's not an exercise, it's a test.
Okay, you want to call it a blue paint test?
Sure.
Okay, let's call it a blue paint test. I just want to try to expedite things and use parlance that we can agree on.
Okey-doke.
So your blue paint test involved painting the right rear tail light blue, correct?
Correct.
Positioning the test subject behind the tail light, correct?
Correct.
With the arm held out, correct?
Correct.
And at a right angle, correct?
Correct.
And then the vehicle, the Lexus SUV, is backed into the test subject, correct?
So I ran 3 different tests.
I know. Well, let's just do each one at a time, okay?
Okay, so you're starting with the last one.
I'll start with whatever one you want.
Okay.
How about if we start with the one at 1 mile per hour?
None of them are at 1 mile an hour.
2 miles per hour?
2 miles an hour.
Let's do 2 miles per hour. Let's start with that one,
Okay.
okay? Now, did you conduct that test in an attempt to show that the injury patterns on Mr. O'Keefe's right arm are consistent with being struck by the Lexus tail light on that arm?
So generally, I wanted to show that the location, area, and span over which that headlight covers matches the location and area of the lacerations on his arm.
That's what I want to get to. So you discussed data that you say shows that that you say shows the Lexus SUV was traveling above 20 miles per hour during the period that you allege the SUV made contact with Mr. O'Keefe. Is that correct?
No. Where'd you get that from?
Hold on. Okay. The answer is no. So did you do a test involving 20 miles per hour?
I did some other backing tests.
Yes.
I was looking at how the rear pedestrian system and what warnings you got from the rear pre-collision system, the PCS system.
Let me ask you this.
Mm-hmm.
Would you agree that you did a blue paint test with the vehicle going at 2 miles per hour? Did you
Of course.
do that? Okay. You didn't do a blue paint test with the vehicle going at 20 miles per hour, correct?
That is correct. I
Okay.
was not going to hit myself with a Lexus at 20 miles an hour.
You could have done other tests where the vehicle was going at 20 miles per hour if you used a crash test dummy, correct? You
If
could have
you-
done that.
If you use the right crash test dummy,
Right.
and then to set up the test, because generally you only get 1 or 2 shots at it, because you damage the car, you have to know everything about the parameters. And so, again, pedestrian impacts are so very sensitive to initial angles. If I were to do a test and it was off a tiny, tiny bit, and we got some different results, I would be in here having to defend it. Well, your own testing didn't show it. Point is we don't have enough information to be able to conduct that testing.
So, your assumption, as I understand it, is that the Lexus was going 24 miles per hour in reverse and made contact with Mr. O'Keefe. That's your analysis, sir?
No. There is not one single slide I have that says this is the speed he was hit at 24 miles an hour.
Do you know, do you have a hypothesis at what speed you believe there was impact? Do you have the point of impact speed?
I do not know the exact speed. We don't know the initial point of contact. We don't know where exactly he was on the road. We don't have enough information to determine that.
Exactly. Let's talk about the other information you don't have.
Okay?
You don't have the information as to the, from your alleged point of contact to where Mr. O'Keefe landed. You don't have that information, do you, sir?
I'm sorry, where is my alleged point of contact?
You allege that there was a point of contact of impact. You don't have where in the road there was impact under your allegation.
Those are the same thing.
Right. You don't have where the, under your view, the body of Mr. O'Keefe landed precisely. You don't have that information, do you?
What do you mean by precisely? We know it's 7 feet off the road. We know it's near the flagpole. We don't know where it started. The problem isn't where it landed. The problem is where it started.
Right. And you don't have that information.
I don't have where it started.
The paint tests that you used, aren't those used, if they're used at all, as an element of physical impact reconstruction, an element not as the focal point of the test itself?
So that was the focal point of that test. The focal point of the purpose of that test was to show the contact width and location of how someone of Mr. O'Keefe's height, which happens to be me, contacts and where it would contact where the broken taillight was. So no, that was the focal point of the testing. That's why I did the testing. That's why we're calling it paint transfer testing.
Right, but my question, sir, I understand you use paint tests as the focal point, but aren't paint tests in accurate accident reconstruction not used as focal points? They're used as supplements to other tests to get more accurate information. Do you agree or disagree with that?
You didn't give me enough information. I can't agree nor disagree. It depends on what you're trying to do.
Let's go to, on direct examination, you testified that after the 1162-2 trigger event, Ms. Reed's vehicle traveled a distance of 87 feet. Do you recall that?
You are mixing up two things. Remember, the trigger is in the middle of the event.
Give me the chart, please. Your Honor, I'll give you the, as soon as Mr. Woke gives it, the slide 23, I believe it is.
I'm sorry, what slide?
Well, I want Mr. Wolt to go through it to check. Let me ask it this way, see if we can get to it quicker. Do you remember talking on direct about a calculation of 87 feet where you added, there was like a 30-something number and a 50 number and you came to 87? Do you remember that in your slide presentation, sir?
Slide 37, yes.
Right. So if we could bring up that slide, please, Your Honor, with your permission.
Okay.
That's 36, but okay.
Are you on 33, sir?
No, I'm on 36.
Mr. Woke, do you have 33? If you could go to 33, sir.
Oh, sorry.
Yeah, because that's where your 87 number is, not on the other.
It's on a bunch of slides.
Yep.
Go ahead.
All righty. So if you could zoom in, Mr. Woke, so Dr. Welcher can see the numbers in the column.
You're going the wrong way.
Yep. To the farther to the right.
Oh, I'm not the only one that has problems. No.
Okay.
You still
Sir, do
don't
you
have
remember testifying about this? To the farther to the right?
it. Farther to the right.
Yep.
Keep going. Keep going. A
Is
little
that
more.
53 number down there? That column?
Right.
So
can
you
we
take-
can we scroll up a tad so you can see the headers? There you go.
Okay.
No, okay, go ahead.
So am I in the right column relative to start? Is that the column?
So there's two columns. Like Z is relative to where it started, and then positive is forward, and then as you back up, once you go past 0, it becomes negative.
Right. So what I want to do is have you direct us to the column where you calculated 87 feet.
It's in two spots. It's at the end of column Y.
Right? We go all the way down. Is that in the yellow there? Is that 87, sir?
It is.
Okay, is that the 87 number you were
Hold
referring
on a
to?
second. You asked me to identify. So then it's, see where the one next to it says minus 53?
Yes.
0.429. If you go up, so it's not a little bit down, a little bit, and add, see where it's changing directions at 34.157?
Yes.
You add those two together, that gives you the same result. So it went 34 feet forward and then 50-something feet backwards.
Right. And what is the 87 feet traveled, is that what you're indicating is the distance traveled during the trigger? Is that what the 87 represents to you?
That is so 87 represents the total rearward distance traveled during the trigger.
Okay. So you believe 87 represents the total rearward distance. Did I hear you correctly?
Correct.
Now, can you please...
Hold on, to be clear. So it starts, it pulls forward, then it backs up, passes where it initially started, and goes 53 feet further back.
That's what I want to get to. How many feet did you say on direct, and did you just say now that it went 87 feet in reverse?
Correct.
Okay.
From its furthest point forward.
Well, that's what I want to get to because I want to have this point clear. How many feet do you believe the Lexus went in reverse based upon your PowerPoint presentation? Not when it went forward and then came backwards. How many feet do you believe that vehicle went in reverse?
Your question doesn't make any sense because when it went forward, then it went in reverse.
How many feet do you believe the Lexus went during the trigger?
So it went a total of 80, it went 34 feet forward, then it came back another 53 feet past where it went.
Exactly. So, you've testified that the 1162-2 trigger event represents a backwards maneuver, correct?
So again, if I was clear, it initially pulls forward and then backs up.
I would like you to define, so it's clear to the jury, do you consider the event of 1162-2 just backward movement, or do you consider the trigger to be forward movement and adding to it backward movement? Which one?
So can we pull the slide up?
Sure.
Could you zoom in? There you go. No, go back to the left. So that T in the third column for data ID represents the trigger. If you scroll over a little bit to the right, where the highlighted yellow blocks are, you can see 1 is a forward drive gear, 0 is neutral, 2 is reverse. So that's where it's switched from forward to reverse. I mentioned the brake. So you have it on the brakes coming in, slowing, stopping, going into reverse, and then backing up.
So you conclude that the vehicle for this trigger went 34 feet forward, is that correct?
Correct.
How do you know the vehicle didn't go 150 feet forward? How do you know it just went 30 feet, 4 feet forward? How do you know that?
So the only data we have is this 10-second window. And so we have the velocity when it's going forward. We know how much time it took to do that. So that tells us how far it would travel. Velocity times time is distance.
So are you saying that it is a certainty that it went forward 34 feet and there's no other number of feet it could have gone forward? You're absolutely certain of the 34 number?
No. Again, if you look, see where it says vehicle speed?
I see it.
So at the start of this event, which is the trigger -5, so the trigger is actually where it's triggered, and it takes 5 seconds before, 5 seconds after. But when the trigger happens, it's actually stopped. But the 5 seconds before, it's going 13.6 miles an hour forward. So at the start of the data, it's still going 13.6 miles an hour forward, but it's slowing down. You can see you have the brake, where it says brake SW, which is short for switch. The brake switch is a 1, which means it's on. So when this event data started, it's going 13 miles an hour.
I'll ask the question a different way. Are you certain that the distance traveled forward during this trigger event was 34 feet? Are you certain?
Yeah, I'm pretty certain during this trigger event.
Pretty certain or certain?
Well, I've checked the math. I've had people check my math. So I try to be as accurate as possible. I would say I'm certain,
Okay.
but I'm an engineer.
Okay.
So there's no absolutes. There's no 100% in my job.
So you're certain of the 34 feet, and is it correct that you're certain of 53 feet going backwards? Are you certain of that, sir?
So backwards from its initial starting position.
Yes.
Correct.
Okay. And therefore you are certain of a total of 87 feet traveled that you have at the bottom in that yellow-orange. You're certain of that as well?
87 feet of backing, correct.
Okay. Now, you also testified on direct, as I understand it, in slide 23, that different numbers represent different gear states of the vehicle, correct?
Correct.
And a 0 represents neutral?
I think it's either neutral or park, but I'm pretty sure it's neutral.
A 1 represents drive?
Correct.
A 2 represents reverse?
Correct.
Or a 2 can represent slowing down, is that correct?
Not for a gear shift number.
So you didn't say on direct that 2 could represent reverse or slowing down?
God, I hope not. It doesn't. So those numbers simply represent, is the transmission in drive? Is it in neutral? Is it in reverse? It doesn't tell you anything about whether it's slowing down or not. But the brake switch and the brake pressure and the longitudinal accelerometer data gives you some information on that.
Okay. So if, Your Honor, we could go to slide 30, please.
Okay.
Mr. Wolk. And I want to do it generally. There's not a need to read any specific number. I just want it clarified.
Mr. Lessie, so is this 30 or 31?
I'm sorry, Your Honor, you are correct. It's 31 in the most up-to-date presentation. Thank you. You see all the numbers in blue font on that slide, sir?
I do?
Those are all numbers that you have placed on that slide. Did I have that correct in your direct presentation?
You do?
Okay. So this Excel spreadsheet, there's also numbers in black, correct?
Correct.
So all the ones that are in blue, those are numbers that you have placed into the spreadsheet. Correct?
Correct. The one exception is column N, where it says ship position.
Yes.
I changed green to forward and red to reverse.
So the data in the columns in blue are not from the original data that was downloaded from the vehicle, correct?
Like, for example, if you look at column H, I simply did a unit conversion. So it's the same number, it's just in different units. But the black numbers represent exactly as it comes out of the vehicle, but it's the same number.
All right, that's what I wanted to get to. So for clarity for this slide, when you download this data from the vehicle, what is in black, those numbers just come right out, correct?
Correct.
As they're stated. But the blue numbers, they don't come out like the numbers in blue. You have to do something, some calculation, some application to get to the blue, correct?
Correct.
Okay, thank you.
You're welcome.
Now, we're going to keep that up, Mr. Woke, please. Thank you. And when we need to get to the specific numbers, we'll be fair and make sure you can see them. Now, in these columns, do I understand it correctly that you attempted to account for wheel slippage in the revolutions per minute speed values produced by the car?
Not here. You're looking, this is 1162-1. The wheel slippage occurred in 1162-2.
Okay, and so if we go to a slide with 1162.2, we will then go to the slide you believe represents wheel slippage, is that correct?
There are data points in that represent slippage.
That's my question. In which slide, sir, would you like to pick?
35.
Thank you. So we will go to slide 35. So,
I've highlighted the slippage.
exactly. So you agree that there is data that shows that there is wheel slippage with the Lexus SUV during trigger event. Let's enlarge it for this one here. The trigger event, the number 1162.2, correct?
Correct.
And as I understand it, you testified that this trigger event was caused by a depression of the accelerator pedal at more than the 30%. Is that correct?
It's a transition into reverse and then a quick acceleration exceeding 30%.
So let's
In reverse.
Okay. Got it. So the accelerator pedal being depressed to this degree, more than 30%, can be the result of wheel slippage, correct?
It doesn't necessarily work that way. I mean, you can have wheel slippage at any acceleration, technically, depending on the roadway. It's just what is in the data that shows that it's slipping. It isn't necessarily because of the accelerator. Normally, that's what causes slippage. But it's the data. When you look at the data, you're like, well, that doesn't make sense. It's increasing in speed, but yet the longitudinal acceleration is dropping.
My question, again, doctor, is you can have an accelerator pedal depressed greater than 30% and it be caused by wheel slippage. That can occur, correct?
The wheel slippage does not cause the accelerator pedal.
I'm not saying a cause and effect. I'm just saying a correlation. Do you understand what I mean by a correlation?
Let me, if I may, try and straighten this out. So, applying heavy acceleration can cause the wheels to spin. Is that what you're asking me?
Yes.
Yes.
Okay, that's all I wanted to get at. Alrighty. So in your review of the materials that are related to January 29, 2022, did you become aware of whether there were, and you said you extensively reviewed documents, did you become aware whether there were people at 34 Fairview?
Yes.
And approximately how many people, without regard to names, just number, how many people did you become aware were at 34 Fairview on January 29th, 2022, the early morning hours? How many people approximately did you become aware were present?
It depends on which time, but there could be as many as 16.
As many as 16. And let's talk about the time period from midnight to 1 a.m. Do you have an understanding of how many people could have been present at 34 Fairview at that time period?
So I'm going to see you at Sidebar on this. Mr. Mayor.
Wow. um, yeah, I mean, I will agree with this. I think Sarah says these two minds work differently and they are struggling to say the same thing differently. I wouldn't say that I'm not 100% sure that they're trying to say the same things some of the time, although I do think, okay, I'm going to tell you how it comes across to me. They are, okay. I think there are times when the witness knows exactly what Mr. Alessi is saying. And what he does is he answers the question in a way that it corrects Mr. Alessi and is also saying the exact same thing. It feels like the witness is determined to prove that he is the smartest. That is how it comes across to me, because and also with this, LGZ says, if I'm a juror, I'm having a hard time determining the takeaway here. Agreed. You know, I mean, the witness is talking about, shoving a pencil through his hand when the question that's being asked is about the arm. Look, at the end of the day, John O'Keefe had injuries to his arm that don't look like typical being hit by a vehicle injuries. Okay. And that's what Mr. Alessi is trying to get out. The witness knows that, and he's just playing games, and it's irritating. I'm annoyed. All right. Here
May I,
we
Your
go.
Honor?
Yes.
Thank you. Dr. Welcher, am I correct in my understanding that you believe under your theory, the Lexus for event 1162-2 backed up 53 feet? Am I correct?
No, it backed up a total of 87 feet.
Okay, let's take your 87. It backed up a total of 87, okay?
Correct.
And also, his own teammate, Shannon One N Burgess, testified that that this witness's calculations were not correct. Okay, so he has that going on, and I don't give a rat's hat kneecap what he says. He knows that's what Mr. Burgess testified. He knows. Okay. I just want to, all I can hear when he gets all frustrated and, squeaky voiced is all I can hear is Dr. Emmett Brown, 1.21 gigawatts. That's all I can hear. 1.21 gigawatts. It can't be done.
Your further theory is that it did so and reached 24 miles per hour, correct?
Correct.
And you stated you have an understanding of a certain number of people, and I don't want to talk about the inside of the house, but just that were at 34 Fairview between roughly 12 and 1 a.m. Do you have an understanding of that, sir? Approximately.
I believe I do.
And what is that number?
Do you want them, people that were there for that entire window of time, or just?
Yes, 12 to 1.
Oh,
So, Mr. Alessi, just move to the last question.
Right, sure. So, sir, did you assume that there were cars parked out front of 34 Fairview at that 12 to 1 o'clock window? Did you assume any cars parked out front?
the entire time?
No, I'm just talking 12 to, yeah, any time between 12 and 1. Did you make any assumptions whether there were cars parked out front on the roadway at 34 Fairview? Did you make any assumptions with regard to that?
At a point in time, there was a vehicle behind it.
I'm sorry?
There was a vehicle behind it.
Just one?
That is my understanding. In terms of on the street, is
On
your
the street,
question?
exactly.
Yes.
And what, do you remember the type of vehicle?
Yes.
What kind of vehicle was it?
An F-150 pickup?
Did you have any understanding as to whether there was a Jeep vehicle on the road at that 12 to 1 time period?
I had seen testimony somewhere to that effect, but the majority of the testimony was there were no other vehicles.
But you did see testimony that there was also a Jeep type vehicle on the front, out the front of 34 Fairview between 12 and 1. Is that what you're recalling?
So I'm going to let that answer stand, what he's just testified to. Just go ahead and.
Okay, so Dr. Welcher, what I want to do is to have you, using your data, you say 87 feet for the backup, correct?
Correct.
1162.2, up to 24 miles per hour. Isn't there a likelihood, if there is at least one vehicle out in front of 34 Fairview, that there would be a collision of the Lexus SUV with the vehicle out front?
No, the vehicle had left prior to the end or prior to event 1162-2.
What information do you have with regard to how many vehicles are in front of 34 Fairview at between 12 and 1?
So I have Ms. Reed's interview statements. I have statements of a number of witnesses. I don't know if I'm allowed to say the names.
Let's not.
I was just going to say, let's not just number of vehicles.
Okay, so I have a number of witness statements at multiple statements from the same witnesses at different times, indicating the path and following the Lexus to the house and then leaving before the event.
Assume that there were vehicles, at least one vehicle, parked out front of 34 Fairview. Is there a likelihood that, given 24 miles per hour over 87 feet, is there a likelihood that there would be a collision given the weather conditions as you knew them to be at that time?
Well, the weather I don't think necessarily plays into whether there would be a collision or not, but we know it backed up 87 feet. So again, it goes forward like 35-ish and then back like 60-something. And so if something is within 65 feet of the rear of it, or whatever the numbers are, I would need my slides.
It was 50.
50,
okay. Yeah,
57. If something is within that window, then it would hit it.
All right, good. So now let's look at another scenario. If it's going as you describe it, is there a likelihood that the Lexus would also go upon the lawn in front of 34 Fairview?
It depends on where it starts.
You have an opinion, don't you, as to where it starts?
No, I do not. That's actually why I have that diagram showing it off to the side.
That's
I'm
right.
simply showing how far it moved forward, how far it moved back.
Exactly.
We don't know where on the roadway it started.
Exactly. You don't know where on the roadway it started, and therefore all you have is the distance covered, correct?
Correct.
So, but you're saying the distance is 87 feet, correct?
87 feet backwards, yes.
So backwards, 24 miles an hour. Have you ever driven a vehicle backwards 24 miles an hour, sir?
Yes, I think I've driven this Lexus backwards 24 miles an
Right.
hour.
So if anybody who's driven a vehicle back, have you ever driven any vehicle back 24 miles an hour at 1 o'clock, 12 o'clock in the morning?
Probably not since I got out of high school.
Have you ever done it when there's a storm that is beginning?
No.
Have you ever done it when there is less than clear visibility?
No and no.
And have you ever done it when there's low lighting?
Oh, maybe when I've been up skiing in the snow, I've done it. But again, that's been decades.
Right. So 87 feet, 24 miles an hour. Are you saying that in every instance that vehicle will stay on the road and for 34 Fairview it wouldn't go up on the lawn?
When you mean every instance, mean like every possible location on the road it starts from?
Correct.
No, there's some spots, if you start here, it's going to go up on the road, on the yard. If you start too far on the other side, you're going to go over into the neighbor's yard. So it depends on where you start.
Right. And so in given the conditions that we've just described, right?
Conditions
the weather,
have nothing to do with where you start.
I need to finish my
Hold
question,
on.
sir.
Only one at a time.
Yes, ma'am.
Let him finish his question, please.
Given the conditions that you've described, it is reasonable to conclude that that vehicle, under your parameters, would have gone up on the lawn. Is that a reasonable conclusion?
No.
So you don't think there's any possibility that could occur, a vehicle going 24 miles an hour at this location, 87 feet backwards, in the dark, with wet pavement at a minimum, and low lighting, you don't believe it's possible for the vehicle to, under your scenario, to have gone up on the lawn? That's not possible.
So your first question was reasonable, and I said no. Now you're asking possible. It, of course, is possible. Whether it's reasonable or not, I'd have to know the starting position.
Right.
If it's very close to the side, then it could be reasonable. If it's further towards the middle of the road because snow is building up on the side of the road, then it's probably not as reasonable. I would need more information to be able to determine whether it's reasonable or not. It's certainly possible. It's possible it could have shot off into space as an engineer, but not probable.
Oh, you think it's possible that it could have been shot off into space, sir?
As an engineer, it's a possibility.
It's a possibility that
Absolutely.
this Lexus could have been shot off into space.
Yeah. Highly, highly unlikely. But
All right.
again, you're asking an engineer about possibilities and probabilities.
Let's get back to reality. So in terms of the Lexus itself, because you, under your method of analysis, don't have the starting point, you can't rule out that under your scenario, the vehicle would have gone up on the lawn. You can't rule that out, can you, sir?
I cannot. No, it could have.
Okay. Now let's go to the next topic. If we could, Your Honor, have Exhibit 168 published in evidence, which is now under the 167. Now, as I understand your testimony, Dr. Welcher, you believe that it's possible that the Lexus taillight could have caused these wounds to Mr. O'Keefe's right arm. Is that correct?
Correct.
And more specifically, it's your belief that the lacerations would have been caused by the vehicle scratching Mr. O'Keefe's arm as it drives past him. Is that correct?
I don't know. I'd characterize it that way. What happens is, this 6,000-pound vehicle is coming, and he's standing on a, icy, snowy roadway area, and it's going to contact him and move his whole body and induce rotation.
Right. So it's going to contact him and, under your theory, induce rotation. So wouldn't such a movement of the car relative to his right arm result in horizontal injuries to Mr. O'Keefe's arm, as can be seen on his bicep above the elbow?
So could we pull up one of my slides to address this issue?
Sir, I'd like to
I'd like to answer your question with a slide that I have that addresses this exact point.
I'd like to stay with this slide, Dr. Welcher, and see if you can answer my questions off of this slide. So I'll repeat it.
Sure.
Do you agree that the injuries up at the upper part, where you're familiar with the bicep brachialis?
I am.
And aren't those two up at the top, right over the bicep brachialis?
They're actually about midway between the biceps and the triceps.
Right. So you know which two I'm talking about, the two up there. Can you just use your laser pointer just so we're talking about the same two? Do you have one?
I'll give it a try, but the upper ones.
I know it's not your fault, but
On the
sometimes it
image,
doesn't
the
show.
upper left. I mean,
Yes.
technically, the ones right to the right of that are also on the biceps and triceps.
Right, but
the
I'm talking
biceps goes all the way to the elbow, so do the triceps.
Right. So I'm talking about the two that are the farthest up.
Correct.
All right. Would you agree that those are in a horizontal orientation?
Generally, yes, which is what you'd expect with your arm like this and the tail light coming across like this, which is what I showed in my slides.
My questions are trying to keep this moving. I just asked if those are in a horizontal orientation.
Yeah,
Yes
more
or
or
no?
less. They're angled down slightly, but more or less horizontal.
Okay. Isn't it there would be injuries caused in two different directions by the same movement of the car? Agree or disagree?
I'm going to say I disagree. You need to give me a little more. You're going to have, again, this is a glancing or a
Hey, Cash, good to see you, bud.
clipping type impact. And so it's going to be it's going to sweep across the arm, which is what causes the horizontal lacerations.
We're talking about a flat surface, right, sir?
Approximately, yes.
And therefore, you would have to maintain contact with the arm as the car moves. Am I correct about that?
Maintain contact with the arm? I'm unclear what you mean.
What do you mean? You don't understand which word
What I'm trying to
which word are you struggling with? Contact or arm or maintain? I mean, Jesus.
do, sir, is to get under your theory, right, given the contact that you've described, what would you expect to be the orientation of the wounds to the upper part of the arm and to the lower part of the arm?
Just like it's shown in this photograph.
Okay. Isn't it the case with your theory that the tail light would have to break, and after the break, the arm would have to maintain contact with the arm as the car moves?
So that is what happens in pedestrian contacts. There is a contact duration. For example, you asked me earlier in that calculation you had me ran, you said 0.01 seconds. That was the contact duration. So when you have things like this, and that's why you have to allow, if you do testing, the body to move, because the car is going to hit the body, it's going to cause it to move, the body's going to rotate away, and the car is going to continue on in that clipping type impact. So the arm is definitely in contact with the rear of the car for some time.
That's what I wanted to get to, is simply that under your theory, the taillight would break, and also the arm would need to maintain contact with the taillight area as the car moves. Is that your supposition?
So at a point in time, it'll stop contact, but the 6,000-pound vehicle is going to want to continue moving on. It's going to push. It's going to initially contact the arm and then push the arm away as it rotates the body. So yes, it's going to maintain contact until the clipping is over and the vehicle continues on.
So my next question is simply, how long do you believe the arm needs to maintain contact with the taillight after, under your theory, it breaks to produce those types of wounds that you say came from a taillight?
We don't have enough information to determine that.
Right. You don't have enough information to make that determination, do you, sir?
Correct.
And-
But we know because of the laws of physics that it has to be some amount of time. It doesn't occur instantaneously.
So now we do apply the laws of physics to the right arm that weren't applied before because you applied a paint experiment. Is that correct? You're now applying the laws of physics to the injury to the right arm. But you
No.
didn't do that in your report.
Nope, always applied the laws of physics. The paint experiment, as you're referring to it, was to look at basically the orientation of the scratches that matched this. So that was an engineering experiment to correlate height, position of the taillight relative to height, orientation of the lacerations on Mr. O'Keefe's arm.
You just said, sir, if I heard you correctly, you, to answer my previous question, applied the laws of physics. That's what you just said, correct?
So the laws of physics cover more than Newton's second law. There's a whole law of physics. The whole field of physics is a broad subject. So
Hold on before he goes into explaining to everybody what the physics is. Thank you so much, Cash. I appreciate that. Yes, the aliens did it. I've been telling y'all this whole time. I'm not saying it's aliens, but it's aliens. All right, please explain to us physics.
a simple measurement of height is a physical measurement.
Sir, I have your entire report in my hand, right here. Where in the report do you apply the law of physics to the right arm of Mr. O'Keefe? Where?
So in the paint experiment we did, the laws of physics about gravity, orientation, things like that, I didn't apply Newton's second law as we already went through. But again, those simple positions, arm angles, the possible physical arm angles, those are all generally governed by the laws of physics. The laws of physics are very broad.
Sir, I'll ask it this way. Where in your 14-page report do you even mention the laws of physics related to the right arm of Mr. O'Keefe?
So in terms of applying the laws of physics.
I'm not asking applying, just where in the report is it mentioned law of physics relative to the right arm? Can you point me to where?
Would write a report that said these are the laws of physics. I would say these are the numbers, but for example, the timing in GPS, how a clock times, the concept of a second, what does that mean? Those are all concepts of physics. So the timing, the GPS, the mileage, how we calculate the mileage, those are all based on the laws of physics.
I'm talking about injuries to the right arm.
That's not what you asked. You asked me about my whole report.
Sir, if you could, please, I just need to finish my question. Where in your report do you use any laws of physics in connection with injuries to the right arm of Mr. O'Keefe? Can you point me to a word or a page in your report?
Yes.
Where?
2A. 2A Roman numeral 1. 2A Roman numeral 2. 2A Roman numeral 3, 2A Roman numeral number 4, 2A Roman numeral number 5.
Sir, I followed all of it, but what I'm asking about is where in all of what you just mentioned is the word right arm? I'll take what you just said. Where in 2A and all of those is the word right arm? Where is it?
Oh, sorry, it's in number 3.
So let's go to 3. You state the location and orientation of the laceration on John O'Keefe's right forearm and right arm are consistent with the geometry and orientation of the right tail light of the Reed 2021 Lexus LX 570. Where?
Can you read the next sentence?
I'm sorry. Is it see PowerPoint slides 102, 120, correct?
Correct.
All right. I want to just start with the report. Did you apply any force analysis to support 3?
So in terms of the force analysis, I did not do an F equal MA analysis, but in terms of, say, the contact pattern, I obviously had to apply some force, even at 2 miles an hour, to do that.
So the answer is, what you cited, number 3, you did not use a force analysis, correct?
So force was applied to my arm in the paint test. I didn't do an F equals MA force analysis.
Thank you.
You're welcome.
So now let's go to the horizontal movement we were talking about with regard to the car. And you can agree or disagree.
Sorry, the picture's done.
I'm sorry, we'll take that down. Thank you. Do you agree or disagree that given a horizontal movement of the car, vertical lacerations would be an inconsistent injury pattern?
So horizontal motion generally will cause a horizontal laceration. You can get what are called stellate, which are a blunt force, and it causes a splitting of the skin as well. But generally, when the vehicle is clipping or running horizontal across it, it will generally cause horizontal lacerations. But when you have a fractured taillight, you can get pieces going off in other directions. So it's not necessarily going to be perfectly horizontal.
So my question is, not with clipping, you keep inserting clipping into my question. My question is this. If you're given a horizontal movement of the car, do you agree that it's more likely than not that vertical lacerations would be an inconsistent injury pattern?
I'm trying to help you, but you got to give me more. So, like, is it a clipping contact or is it not a clipping contact? Is it a direct in the center of the car impact?
Okay, are there only 2 variables you need to answer the question?
But this is a good start.
All right, so let me do it this way. You can't answer the question on a general basis of whether there's horizontal movement of a car, whether vertical lacerations would be an inconsistent injury pattern. You can't answer that question without more information. Is that your answer?
So generally, again, horizontal motion should cause horizontal lacerations, but again, it depends on what's being hit.
Okay.
So for example, if I have something that bends as a result of the impact, it could bend up and create a vertical laceration.
So you would agree, based upon what you said, that generally horizontal movement of a car would be expected to cause horizontal lacerations.
Generally,
okay.
yes.
Now, during your blue paint test, the blue paint was featured more predominantly on your upper arm than your forearm. Is that correct?
I think it depends on the tests.
Do you want? We bring up a slide. Will that
I'd
help
love to
you?
bring up a slide.
We're going to be running the thing, so we'll just bring one up, and you tell me whether this slide works for you, sir.
Do you want me to tell you the slide I want?
If we could take a shot at it first, and then we may ask you for it. But I think we've got a slide for you. And what number? 111 is on the screen, sir.
Thank you, Your Honor.
Cash says, should not be laughing watching a trial. I'm going to hell. We've all been laughing all day long. So we'll be seeing you there. If that's the criteria for going to hell, all of us today will be going to hell because we've laughed 11 billion times. This is just utter poppycock. All right, let's keep going.
Is the blue paint more predominant?
Hold on, I'll rewind it. But I forgot to say, hey, Bogart, I missed you coming in. My bad. I'm sorry. Good to see you. All right, ready? Okay, now I'm ready. Here we go.
Is the blue paint more predominantly on your upper arm than your forearm? Is there more blue paint on your upper arm than your forearm?
Probably. This is the one where I actually walked sideways into the back of the car. The one where the car's moving is probably a little better representation.
Sir, I'm just asking you a question about this slide. If you could just focus on this slide here, and if you can't answer it, so be it.
Just effing answer the question about the paint, bro. Just answer. It's all he wants to know. You don't need to give additional information.
I'm so tired of you.
Yet,
I just answered it.
is the blue paint featured more predominantly on your upper arm than your forearm?
It sort of looks like it. I didn't actually measure the total area of it.
Alrighty. So on direct, you stated that in order for the injuries on Mr. O'Keefe's forearm to have been caused by an impact with a taillight, his arm would have needed to be held outstretched as you did in your demonstration, correct?
You would need some degree of outstretch, yes.
Yes. So isn't that an example of confirmation bias?
No, that's matching the contact pattern to the injuries.
But don't you have to select among other choices this outstretching of the arm? You have to make that selection from among others, correct?
So that was matching the physical evidence on his arm to the physical evidence on the car, and then running a test to see if dynamically those matched up. So it's, I didn't have it hit the exhaust pipe, for example, because there was no assertion it hit the exhaust pipe. There was no damage to the exhaust pipe. So it was based upon the evidence, and the testing was done to test, to use your vernacular, the hypothesis that that's where it came from.
Sir, have I ever asked you anything about a tailpipe in any of my questions today?
Yes.
I have not. I've never
Yes,
asked.
you have. You asked me about the totality of the rear of the Lexus, which includes the tailpipe.
All right. I am not going to be asking any questions that involve the taillight in any fashion. So what I'd like to do is to go back to the question that I'm asking, which is, did you consider, as part of the scientific method, in terms of more than one hypothesis, did you consider in your analysis any other orientation of Mr. O'Keefe other than the one you selected for your paint test?
Yes.
And where is that consideration of other hypotheses stated in any report?
It's not. I was just looking at the damage that was up on the sheet metal.
Okay. So, are you saying that you considered other orientations of Mr. O'Keefe relative to the vehicle as part of your analysis?
In terms of where exactly the hand would be, some slight different angles in the forearm, which is from the elbow to the hand. I did consider that, but all the physical testing is done with the hand hitting the approximate center of the taillight.
Do you have any notes that you took for these alternative orientations?
No, no. I think I just included photographs of that damage.
Do you have any proof at all that you consider those other orientations? Anything in writing?
No, I don't believe so.
Did you consider any other locations of Mr. O'Keefe under your theory relative to the back of the SUV?
Sure. In the beginning of this, I started about, hey, it's all over. Could be anywhere on the back of it. Then whittled it down based upon the evidence, started eliminating various hypotheses based upon the evidence, and came to this conclusion, eliminating hypotheses based upon the taillight fragments near his body, the lacerations, his height, the height of the taillight in a Lexus. So it was an iterative process.
Did you mention any of these supposed hypotheses in your direct testimony?
No, because I was able to reject them. I didn't come in here to tell these people what didn't happen. I came in here to tell them what I believe happened.
Would you agree, sir, that the scientific method earlier has the scientists identify various hypotheses, go with the data that supports it, but you show your math as to why you're rejecting hypotheses. As you said, you rejected them. I'm asking for proof that you considered other hypotheses. Do you have anything in writing, any notes at all, any videos, any tests that you did, documentation of other hypotheses other than picking this one? Do you have any documentation of that?
So I did a bunch of tests with the Lexus. I did backing tests. I looked at how the rear system worked to see if it would autonomously brake. I confirmed it did not, so I eliminated that as a hypothesis. I tested the steering. I tested the transmission, what 1, 2 represented. So I did a whole bunch of tests on the vehicle.
I understand you say you did a bunch of tests on the vehicle. My question is, did you ever take the vehicle and position yourself or anybody else in various locations to determine whether or not your hypotheses could be properly rejected? Do you have any documentation that you did that?
I mean, I did do one static and 2 dynamic tests in very similar positions, though. So I did a total of 3 tests relative to the arm.
Where is the documentation for that, sir?
It's in the file. I gave it to you. Some of the slides are some of it.
Okay.
All right, so Mr. Alessi, I think if we're going to...
I am, and I'm going to move on, Your Honor.
So
Okay, but Mr. Alessi, hold on. We're going to do that for you.
Can I ask, I just have one other area, Your Honor. I can do it in short order if I could,
Okay.
please.
I wasn't finished with my
Go ahead, finish your answer. I'm
So
sorry.
slides 109, 110, 111, actually through, I guess, 121 deal with the testing of the hypotheses.
We'll come back to this at another time, Dr. Welcher. So what I want to do is to finish up on this point. So is it your testimony that no part of what you did in selecting this area, no part of it is confirmation bias? You say there's no confirmation bias at all in what you did. Is that your testimony?
That's certainly my goal. I try and eliminate all confirmational bias. I didn't start out at this particular location. This is where the physical evidence led me to. So I would say the conclusions are supported by the science.
My question is, did you engage in any confirmation, and this will be my last question, did
The
you
answer is no.
engage in any confirmation bias in terms of how you approach the issue that you have testified about in written reports?
The answer is still no.
This is for cash. Just for cash. Nobody else look or listen. This is just for cash.
You will respect my authority.
That's for you, Cash. Just for you. Nobody else. Just you. All you. Ah, cripes. Hold on. I'll when this is over, I'll read the motion because it's ridiculous from Lori Vallow. I was saving it for the end. So here we go.
It's a good
All right,
provision.
so, okay, thank you. All right, so jurors, we're going to send you home because we still have work to do here and we don't need you waiting there while we do it exactly. So, tomorrow is a half day. We'll see when exactly that half day ends, but we won't be here we won't go until 4 tomorrow. Those 3 cautions: do not discuss this case with anyone.
Yeah. We know these, Bev. You play that game at your house too, Sarah? I used to play that game all the time. Sarah says, the ward, that sounds suspiciously like a game we play at my house. Mommy wins. Yes, that we used to play. How are we on schedule if Bev is giving half days and shit? Bev, what you signing for?
All right.
Get it together, Bev.
Okay, Mr. Alessi, it's your voir dire.
If I have a moment, Your Honor, to switch.
Yeah, take a sip of your drink there, Judge Bev, and chill out. You'll be fine. But before we get into that, let's just hold on a minute. I do not want to interrupt Mr. Alessi. As you know, I just absolutely adore him, but I do think we definitely need some level of a palate cleanser. And so let's have one.
What you just said is one of the most insanely idiotic things I have ever heard. At no point in your rambling, incoherent response were you even close to anything that could be considered a rational thought. Everyone in this room is now dumber for having listened to it.
All right, we just needed that little we needed a little palate cleanser. A little break. Let's have this one as well.
Everything's perfectly all right now. We're fine. We're all fine here now. Thank you. How are you?
All right. Now let's hear from my favorite and yours, Mr. Alessi. Take it away, Mr. Alessi.
Your Honor,
Yes.
can I have a look at my slides?
Yeah, can you do that while you're sitting here answering questions? Yes.
Did he just whine to the judge?
Your Honor, could I have a moment to wind up my slides?
Jeez. Yes, Violet. I want to know this question, the answer to this question. Mr. Welcher, when we are being launched into space, can we bring the pets, or are we limited to just what's in our vehicle at the time that we're being launched into space? Whew.
I'm going to start with Your Honor with regard to true fall.
Okay. And we're on a very limited schedule here.
Oh, shut up, Bev. It's not even.
Your Honor.
Shut up. A limited schedule. This is your job, ho. Sometimes you have to stay after.
Mr. Wilk, with Your Honor's permission, if we could pull up the January 30th, 2025 PowerPoint of Dr. Welcher in slide 36. You see that, Dr. Welcher? Do you recall that from your January 30th, 2025 PowerPoint?
I thought I had replaced the video on the left-hand side by the time I produced
Sir,
it.
I got to
don't
go through
recall
this
that.
quickly. That image is a drone image on the left, correct?
Oh, correct.
And you had that in your original report, but you removed it in subsequent reports, correct?
Correct.
Where did you get that drone image from?
It was in the file.
Wasn't it in the CARS report of Trooper Paul?
I believe it was.
So you took that drone image from the CARS report of Trooper Paul, correct?
Correct.
Let's, if we could, Mr. Woke, go to diagram 1. Do we have that electronically of Trooper Paul's report? Do you recognize that as diagram 1 from Trooper Paul's report?
Yes.
So, and that's the diagram that you took that image and you put it in your January 30th, 2025 PowerPoint, correct?
I'm pulling up my version of PowerPoint. Yes, that's correct.
Okay, if we could take that down, I'm going to go to the next example. We could go to Dr. Welcher.
I'm sorry, actually, can we go back to that?
Yes.
Oh my God. What do you need to add to it now?
Your Honor, why do we...
Well,
I have limited... Go ahead.
so that particular diagram I did not use. If you notice, the diagram I use has different cars and doesn't have all the writing about the position of things on it.
I am going to now, Your Honor, have to take the time to go to Trooper Paul's report. Can we have the hard copy of Trooper Paul's?
Could you turn the lights on, please?
Hey, Lil D, yes, this is now. This is outside of the jury's presence.
I'm going to
And I do not know where this is going at all. We're watching
But the
this.
report, that image is not
What
in
the
that report.
frack?
Did you get
Hold
the
on.
drone image? My question is, do you know an image from?
So,
Do you
yes, it is.
image from any file from the Trooper Paul, Trooper Paul,
What the hell
State
happened?
Police?
Yes.
Okay. Image from
Not, no, I'm not sure I got it from the report. I recall getting it from the file.
My question is, do you know of any other source other than Trooper Paul's report that you could have gotten that drone image from?
So this image is not in that report.
It's not
Yes, it is. You asked me anything but the report. That image is not in that report.
Did you get the drone image from any file from the Massachusetts State Police?
Yes.
Okay. Did Trooper Paul work on any drone images to your knowledge with respect to 34 Fairview?
I don't know.
But you would agree that the drone images are from the Massachusetts State Police file, correct?
Give me 1 second.
Sir, let me know you've had a fair opportunity to answer that question.
Yeah, give me a second. Yes, it came in a file called cars-trp.jopal.
Okay. So it came from, and that's the report of Trooper Paul, correct?
No, these are drone images that are not in the report.
No, I'm saying what you just read. Can you repeat it again, what you just read, where it came from?
I read you a folder
Yes.
that contains a bunch of things, including the report.
Understood.
That image is not in his report.
Okay. Can you read the file name again that you just read?
The folder name
Yes.
is cars-TRP period Joe Paul.
Okay. And did you get the drone image from that file folder?
I did.
Okay, thank you.
You're welcome.
Now let's go on to the May 26, 2025 PowerPoint that you created. And I'd like to go to slides 25, 26, and 27. Have you discussed with anybody today at all the source of what is depicted up on this slide?
No.
Okay, so let's now go to where did you get the, you see the larger chart to the left there in the, looks like mostly a rectangle. Do you see that, sir?
What slide are you on? What slide is that?
25, I
25,
believe.
okay.
Okay, and then if we could click to 26, because it looks like it's the same. If we can go to 26 and 27, looks like it's the same one. You tell me.
Similar.
Similar, okay.
Yeah.
In 27,
Correct.
see the same or similar one there. Okay.
These are all from Google Maps.
Well, my question is, may I approach, Your Honor?
Yes.
Thank you. Well, let me ask you this so I don't have to keep going back and forth. Do you have access, sir, to the cars report of Trooper Paul on your computer?
Think so? You remember the name of it?
I don't. We'll do it there with the hard copy. Mr. Brenner, I'd like to show this one. Thank you. So, if I could approach, Your Honor?
Yep.
So, you see what I'm pointing to right here, which is page 10 of Trooper Paul's cars report. Do you see that?
I do. Is this the same report? Is it dated 1/29/2022?
I believe so, sir. Let me just take a peek. This is, you can just compare, this is the one I have in my hand. Take it and look for any identification that gives you, right? We got the same one.
Yeah, mine's frozen.
Okay,
So let's do paper.
okay. So we have that report, and I now am referencing page 10 of that report, and I'm looking at the chart on page 10. Is that chart on page 10 the same or substantially the same as the chart that is up on your slide presentation right now?
So it's not the same. I did not use this data at all, but we both use Google Maps.
Okay. Alrighty. Now let's go to your, continuing on the same slide. If Mr. Woke, we could go to slides 22 and 23.
Okay, and this will be the last on this, Mr. Lessie. If you want to get to the autopsy photo, we're wrapping this all up at 4:10.
Okay, Your Honor. You see these photos?
I'm sorry?
You see the photos that are up on that?
I do.
Okay. Do you, in terms of those photos, do you recognize any aspect of those photos?
Yes.
What do you recognize in terms of the person in it?
Oh. You want me to limit it to just these 3 photos?
Any photo that would be, this photo or any photo similar to it?
Before he answers this, or before he answers the question, I want to answer Sissy's mom. What's the purpose of this voir dire? I suspect the purpose of this voir dire is, did he use elements of Trooper Paul's report? Is this the state's way? Is this a backdoor way? I think this is where he's going. Is the state trying to backdoor in Trooper Paul's report without having Trooper Paul testify to the report?
But let's start with just these 3.
If I have to limit it to these three, I don't know who that is.
Okay, and if you don't limit it to those three, who would you conclude it is in those photos?
It appeared to be Trooper Paul from other photos.
Okay, so you can tell from other photos that this is Trooper Paul in these photos, correct?
I have photos of Trooper Paul in the car. I don't know that someone else switched out. I have no reason to believe this isn't anybody but Trooper Paul.
Okay. Would you have any understanding that there's any other trooper that would be doing this type of analysis other than Trooper Paul?
Someone else took the photographs?
No, I'm talking inside the vehicle.
I'm sorry?
Inside the vehicle doing what's depicted here.
Someone is inside the vehicle taking the photograph.
What's your best conclusion as to who that is?
Trooper Paul.
Thank you. Your Honor, that is...
Okay, so next topic.
Yes,
Go right
thank you.
ahead.
And I just need to reload, if you will, with regard to that topic.
Crocheting Bammy says, I don't understand how she can tell him not to ask any more questions about a particular subject. She can because she is, hold on.
Go to slide, and I think I can...
She can because she's the judge and she's running this court. However, is it fair? No. Is it right? No, absolutely not. I understand the need to, I mean, obviously this voir dire shouldn't go on for the next 7 years. Okay. But, this way, the way that Judge Bev does it is ridiculous. I mean, I could understand if we were getting into a contest about, the meaning of is, all right? But that's not what's going on here. I think it's important.
Do this fairly quickly.
Okay.
If you can go, Mr. Woke, to slide 131 of Dr. Welcher's PowerPoint presentation. And it's now 132. I don't believe that's the right one. It's the...
One before that.
Yep. I think you're... Yeah, okay. So this is slide 131 from your slide presentation, correct, sir?
Correct.
And if you look to the far right... I'm sorry, Mr. Woke, you go to the other one. Yes, that one, and scroll down so we can see what's in green. For that depiction, that is from Dr. Scorty Bellows' autopsy report, page 3, correct? Is that where you got that from?
It's from the report. I'll take your word for it on page 3.
So, but it is from Dr. Scorty Bellows' autopsy report, correct?
Correct.
Now, if you could go to, if we could zoom back out and go to the multicolored image in the center, up at the top. Yep. 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 I got it. Yep. Got it. Thank you. If you can go to the very top line, it says autopsy report performed by Irene Scorty Bello, MD, PhD. If you could scroll back over, Mr. Date of autopsy, January 31, 2022, and then you see final diagnoses. That is all directly from the autopsy report, is it not, sir?
Yes.
And that is in your slide presentation, correct, sir? This is page 131 of your slide presentation, correct?
Oh, I get it. Hold on.
That's all I have, Your Honor.
Okay. You are all set, Doctor?
Thank you, Ron.
All right. Oh, did you have any questions, Mr. Brennan?
If it'd be helpful to the court, I have a couple quickly.
Okay.
Can I keep under 2 minutes?
No, Rachel, this is outside the presence of the jury.
Dr. Welcher, you were shown a photograph of the street of Fairview Road. Did you know that didn't come from Trooper Paul? It came from the CERT report, and Trooper Paul then took it from the CERT report and put it in separately in his presentation? Did you know that?
I had no idea. I just was given it as a folder.
And the photo you were using, it didn't have the markings that Trooper Paul put on his report, did it?
It did not.
When Trooper Paul, when you used that photo, was it because you were borrowing, relying on, or using any of Trooper Paul's reports for your conclusions or any of your decisions or analysis in this case?
I did not use his report at all.
It was simply limited to the use of the photo to show a different demonstrative issue.
Correct.
And then when you saw diagram 1, again, that was different than what was used in Trooper Paul's report because it had absent in it all the writing. Isn't that fair to say?
That's fair to say.
Did you rely on Trooper Paul's analysis or conclusions in this case for your conclusions and your analysis?
Not at all.
Is that why you went and downloaded the information and looked at the car and did everything individually, separately, and uniquely from Trooper Paul?
I wanted it to be independent in my analysis.
Regarding Dr. Scotabello, did you ever consider her conclusions regarding manner or cause of death as a basis for your analysis and conclusions?
Yes.
And when you considered her analysis, did you consider the conclusion of undetermined cause of death? Was that part of your analysis?
Oh, no. I was using like the skull fractures, the description of the injuries.
So you were considering the information in her autopsy report?
Correct.
How about her conclusions? Did you rely on her conclusions to do your studies or any analysis in this case as far as cause of death or manner of death?
Only I thought I said blunt force trauma and hypothermia.
Okay. Regarding her conclusions about whether this was caused by a car accident or not, did you consider that as the basis of your opinion?
No, I wouldn't take a person like that's opinion for that.
Did you ever have a conversation with Dr. Scotabello about her expertise limitations?
No, I would want a biomechanical analysis.
Was your opinion regarding the collision in this case, did it have anything to do whatsoever with Dr. Scotabello's conclusions regarding cause of death, whether it was accident, undetermined, or homicide?
No.
Okay.
Thank you.
Yeah, Your Honor.
All right, one question. Can we just wrap it up? I'd like to hear you argue, but we don't have time, so I'm just going to...
I have
Decision.
two questions, Your Honor.
What do you, hold on a second. I'm sorry, I just coughed. What do you mean you don't have time? Do you have a hot date somewhere, Judge Bev? Where are you going? This is your entire job until the conclusion of this trial. This is where you're supposed to be, right here, right now. I sound like, who sang that song? Is it Jesus Jones? Right here, right now. Yeah, this is where you're supposed to be, ma'am. What are you doing? Where do you have to be? Good Lord. This is ridiculous.
You put in your slide presentation information from the autopsy report of Dr. Scotabello for a reason, correct, sir? And that reason is because you considered the autopsy report as part of your analysis, correct?
So I considered portions, which are the portions I included here for the autopsy report.
And part of those considerations were the final diagnoses. We can put that back up, Mr. Woke. But you recall the slide that you had has the final diagnoses of Dr. Scotabello, and you put that in your slide presentation because you considered that as part of your analysis, else it wouldn't be in there, correct?
So the final diagnosis is in there. There's a line, then it says cause of death, and then manner of death.
Right.
The things I highlighted are the things I thought were important. So the highlighting on slide 130. So the final diagnosis, again, does not include cause of death. It does not include manner of death. There's that horizontal line demarcating those. The important things that I was looking at are the under or highlighted, which is why I highlighted them.
Exactly. So the ones that you highlighted, you considered are from the autopsy report. That's why you're highlighting them, right, sir? You considered them.
Correct.
Thank you. No
You're
questions,
welcome.
Your Honor. I
All
appreciate
right.
that opportunity.
So I'm not going to let you argue now. I'll hear you very briefly tomorrow before we stop. But Mr. Lessie, how much longer are you going to be tomorrow?
If I could have a motion, Your Honor.
Yes.
You see how she, oh my God, I can't with her. You're so rude, Judge Bev. You have zero coops.
Halfway through, Your Honor. I think it will take up, we'll look for it tomorrow. If we can get through things quicker, I would like to do that, but given today, that's my best estimate.
So we're half a day tomorrow.
Oh, that's right.
So it may be that we have a 20-minute break tomorrow, and we finish up by 1:30 by going straight through. We've got a juror who has an appointment. that we told her she'd be able to make. So I'd like to do everything we can so that Dr. Welcher doesn't have to come back or stay here another day. So let's just see what we can do, and we will do the same thing for your experts as well.
No, I understand, Your Honor, and I respect everything that Your Honor is saying. I must say, Your Honor, to state the obvious, this is the key aspect of the case, and we've got to be able to proceed through with the questions. He covered a lot on his direct and he properly.
And I'm not asking you to curb it. I'm just hoping that we can do it. So I will ask you.
No, Judge Bev, you're not coming right the fuck out and asking, can you keep it short? No, you're not. But the 11 billion sighs that you do prior to asking the question, and then the 11 billion 1100 sighs that you do after the question is answered, not even completely, just in the middle of it as he's making his answer, you're sighing all over the damn place. Like you've got a hot date that you know that can only see you tomorrow night. Get the hell out of here. That's how you act. Okay, you don't have to come out and say, can you curb it? Everything you do, everything else that suggests and oh, you're getting me yelly, that suggests and implies that you want him to hurry the F up. You know, it's like you treat the defense like they're toddlers. And you know how like 3 and 4 year olds, that's when they really start to get independent and they want to do everything themselves. And it takes you at least 10 extra minutes to leave the house because they insist on putting their own shoes on. And inevitably, bless their sweet little hearts, they put them on the wrong feet and they got to start all over again, which all the things we've all been there. We all know what the hell I'm talking about. You don't even have to be a parent, just be around a toddler. That's how they roll. Okay. And this is how you're treating the defense, as if they're trying. You're irritated and frustrated with them because they won't just let you put the shoe on them. They have the right to question this witness. This witness is integral to the Commonwealth's case, and they have a right to impeach any testimony that he gives. Get out of here, Bev. Is this your first day on the fucking job? God. This is why I'm angry with you. And the fact of the matter is, I don't give a rat's fat kneecap how he wants to dress it up, fancy it up, pretty it up. This witness used other reports as the basis of some of his findings, okay? And he put them in that slideshow intentionally because he used them. I don't care how he tries to skirt around the issue. He did use some of Trooper Paul's stuff. And it's only a problem now, Brennan, because the state has decided they're going to change their theory about what happened and when it happened. Get out of here. Stop playing with these people. Ridiculous. Let me let Judge Bev finish, and then we'll read. Then we've got more ridiculousness.
Tomorrow at a certain time to see whether we're able to do it with the 20-minute break and finish.
Fair enough, Your Honor.
Okay.
That would be my answer if that's
But maybe you ought to wait a minute, Judge Bev. While you're giving out admonitions and suggestions and shit like that, why don't you address the witness to answer the fucking question? Okay. If it wasn't like pulling teeth with Homeboy, where he starts out the question that's asked requires a simple yes or no answer. Yet Holmeslice over here is not doing that. Starts out the response by correcting the attorney, then answers in such a Miss America way that it ends up coming out where he's actually saying yes, when he could have just saved everybody at time and headache and just answered the fucking question yes. God.
All right, thank you.
All rise for the court, please.
Thank you, Dr. Welch.
Fuck off, Judge Bev. I'm done with you. All right. Now, on to more ridiculousness. Okay? Here comes Lori Daybell. She big mad. The defendant, Lori N. Daybell, files this motion with her affidavit as required by 28 U.S.C.A. Southern something 144 to show that Southern Second, to show that the Honorable Justin Boreski has a personal bias or prejudice against her. As a result, the defendant cannot receive a fair and impartial hearing or trial before this court. Based on the affidavit, the defendant respectfully moves that the Honorable Justin Boreski proceed no further in this action and that another judge be assigned to hear the case. Dated this May 20th, 2025. I, Lori Daybell, being first duly sworn, say, Mrs. Daybell has made multiple motions for Judge Justin Boreski to recuse himself from her cases. He has refused to recuse, knowingly and willingly violating the Code of Judicial Conduct, Canon 1, 2, Code of Judicial Conduct, manifesting bias, prejudice, and cannot be impartial in the defendant's cases. On May 14th, 2025, the defendant's cases are in the worldwide media networks. Judge Boreski refused to recuse himself in direct questioning by the defendant. The judge proceeded to breach his duties of the codes of judicial conduct, Canon 1 and 2, by further commenting with opinions of the defendant prior to groups of counsel, the defendant's advisory counsel, and the defendant's motions that he denied without cause or decision to support his denial of request. A judge should have recused himself related to the merits of their own ruling. In regard to the complaint of the judicial misconduct, 605 F3D 1060, a judge commits error of laws in the process of reaching discretionary conclusion is abuse of discretion. On May 14th, 2025, court proceeding, Judge Boreski's behavior and judicial acts fall within the scope of bad faith. The acts were intentionally committed, and the judge knew or should have known that his actions were beyond a judge's lawful power and without lawful power of judge, but for the corrupt purpose, which includes any other than faithful discharge of judicial duty. Regarding Rita Jett, 180 Arizona, 103, 1994, in Judge Carroll v. versus Commission on Judicial Conduct or Otherwise Committed Acts Deserving Discipline, USCA Constitution Amendment 14. The motion that the defendant's prior two legal counsel teams, the defendant and her current advisory counsel, have advised for the defendant to file for evidence and further motions of request are crucial to the defense preparation, witnesses, experts, evidence, proof of innocence, cross-examination, rebuttals, and foundations to the defense, all which Judge Boreski has deprived the defendant of access to the evidence. A judge abuses his discretion in controlling discovery. U.S. versus Jennings, 1960 F2D 1488 USCA Constitutional Amendment 614-28, USCA Southern 2nd 1253. Judge Boreski crossed the line of neutrality when he misemployed his powers, when he assumed role using his judicial powers to advantage or disadvantage a party unfairly, thus giving the impression that this court has opinion. Improper judicial intervention results in prejudice. The facial expressions this is a quote, the quote, facial expressions, attitude, demeanor, and statement deprived the defendant of a fair and impartial hearing, ER 8.4 violation, in conduct that is prejudicial to administration of justice. A request for presiding disciplinary judge is being made on Judge Justin Boreski. On May 14th, 2025, Judge Boreski refused to apply or understand the direct guidelines of the Maricopa County Sheriff's own attorney, Maricopa County Attorney's Office Civil Attorney Joseph Vigil. On March 20th, 2025, Maricopa County Sheriff's Office response to remove restraints during trial on page 3, quote, without any restraints in the courtroom, MCSO would recommend an unarmed detention officer and an armed sheriff's deputy in the courtroom, end quote. The belt is visible on the defendant and has fallen off the defendant in prior trial proceedings. The motion was denied by Judge Boreski. Under the Sixth Amendment, jurors' glimpses of defendants in restraint rise to a level of due process violation. A person quote unquote, subjects another to the deprivation of constitutional right within the meaning of Section 42 U.S.C.A. 1983, if he, she does not does an affirmative act, participate in another affirmative act, or omits to perform act which he, she is legally required that causes deprivation, anyone, quote unquote, causing any citizen to be subjected to a constitutional deprivation is also, quote unquote, liable. The requisite causal connection can be established by a series of acts by which the actor inflicted the constitutional injuries and abuse of discretion. Judge Boreski's denial of both Maricopa County Sheriff's Office and, hold on a minute, and Maricopa Attorney's Office Civil Attorney, Mr. Vigil's recommendation and the defendant's motion for removal of restraint belt. The defendant is pro per, filed May 10th, 2025, and denied by Judge Boreski. On May 14th, 2025, Judge Boreski denied defendants. Are you guys okay over there? Okay, good. All right. You look like you guys are doing all right. Oh, cripes. Here we go. On May 14th, 2025, Judge Boreski denied defendants' motion to dismiss for abuse of discretion by Judge Justin Boreski, filed on October 26, 2025, for the violation of Speedy Trial Act. Under 18 U.S.C.A. 3161B and 1, resulted in miscarriage of justice, failure to make prescribed findings to justify, quote, ends of justice, quote, continuance cannot be excused as harmless error under the Speedy Trial Act. A, quote, end of justice, end quote, must be filed, therefore. Violation of Rule 15.7 due process and 3161H and 7. The Sixth Amendment right to a speedy trial. Congress enacted the Speedy Trial Act, STA, which criminal trials must commence. Under 18 U.S.C.A. 3161, the Speedy Trial Act and case law are silent as to what a non-statutory factor district court should generally consider. A court abuses its discretion when it fails to consider all factors relevant to the choice, and the factors it did rely on were unsupported by facts under 16 ARS Rules of Criminal Procedure, Rule 8.6, denial of speedy trial. If the rules have been violated, the court must dismiss the prosecution with or without prejudice. Violating speedy trial rule does violate spirit of rule and the fact the defendant is deprived of due process. The state and Judge Boreski failed with the, quote, end of justice for continuance. Judge Boreski therefore violated the Speedy Trial Act with failure to justify a continuance. May 11th, 2025 was the Speedy Act limit of timeline for trial. Judge Boreski violated 16 ARS Rules of Criminal Procedure, Rule 8.2, 8.6. This was motivated by, quote, bad faith. Jimenez versus Judge Chavez, 234, Arizona, blah, 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 reversed, remastered in Maricopa County. The speedy trial clock has exceeded the maximum days. The act is violated. Thus, the case should be dismissed. Dismissal without prejudice is not a toothless sanction for a Speedy Trial Act violation. And then it cites, the court failed to request findings to justify end of justice continuance, thus violating the Speedy Trial Act, warranting dismissal based on court violations, 18 U.S.C.A. 3162A and 2. The Speedy Trial Act imposes strict specificity requirements for, quote, ends of justice. The district court fails to comply with them, and then it's listed. No continuance period may be excluded from speedy trial computation. A continuance period is not excluded from speedy trial calculation. The trial court's failure to set forth in the record its reasoning for finding by not granting a continuance violates 18 U.S.C.A. 3161 through 3174 H, 8, and A. The indictment period violates the Speedy Trial Act. The defendant's conviction would be reversed and the cause of remanded for dismissal of indictment U.S. v. Perez Revelas. On April 9th, 2025, Judge Boreski, in trial, which media networks aired his comment against the defendant violating 42 U.S.C.A. 2000 BB Religious Freedom Restoration Act of 1993, Judge Boreski stated, quote, I guess to the extent that you are comparing yourself to those biblical figures, I will allow it. He did say that. This was a malicious act by Judge Bresky to the defendant, manifesting discrimination and religious prosecution against Mr. Daybell and Mrs. Daybell's religious exercise. No, it wasn't. What he was doing is what you asked him to do, okay, when he said, I guess to the extent that you are comparing yourself to these biblical figures, I will allow it. Remember how you were saying that he just dismissed and overruled and did all the things to you just because? And he's just a big meanie, mean man with no merit. This is why he said what he said. Okay? Because you are comparing yourself to these figures, that's why it was allowed in. Okay? That's a legal basis. He's explaining the law to you, which is what you asked for. But yet here you are a bitchin'. This was a malicious act by Judge Bresky to the defendant, manifesting discrimination and religious prosecution against Mrs. Daybell's religious exercise, beliefs, and practices under USCA Constitutional Amendment 1 and First and Fifth due process. The comments compound the prejudice of an erroneous misunderstanding for the purpose of fundamental error. The defendant only needs to establish one prong to prove fundamental error. A judge who engages in improper behavior while on the bench is sanctions imposed. ARS Constitution ART 6.1 unprofessional conduct violates ARS Supreme Court rules Rule 41 duties and obligations of members. Under SCR Rule 4.090 disqualifications 1 grounds a judge must recuse himself from any proceeding while a judge expresses an opinion concerning the merits of the proceeding or in which the judge has a personal bias against a party regarding Alred 395 South, whatever. A judge violates due process by not recusing under 14th Amendment. With judicial decree does not justify public comment by a judge related to matter which is outside of context of official proceeding. He didn't do that. You're ridiculous. Code of Judicial Conduct, Canon 123. Oh my God. A judge's public comment risk of appearing the judge impartial. Jesus, Lord, could you even copy this correctly? A judge's public comment risk of appearing the judge impartiality and objectively is compromised in violation of Canon 1, 2, and 3. The comment is order for dismissal. I am the defendant in the above entitled case. I am informed and believe and based on the information and belief allege that the Honorable Justin Bresky, the judge before whom this cause is pending, has personal bias against the defendant, Lori N. Daybell, in favor of the state. A judge who manifests bias or prejudice in proceeding impairs the fairness of proceedings and brings the judiciary into dispute. Code of Judicial Conduct, Canon 1, 2, 3. Facial expressions, attitude, demeanor, and statements deprive the defendant of a fair and impartial hearing. ER 8.4 misconduct 28 USCA 144 bias or prejudice of a judge. A judge shall not preside once affidavit is filed. The facts and reasons for the belief that such bias and or prejudice exists are comments or are statements of facts above. So basically, she wants Judge Bresky to recuse himself. Okay. However, okay, she also wants a speedy trial, which I don't really know how she can have both at the same time. Because let's just say that she's successful, okay, and Judge Bresky has to recuse himself. Then everything starts all over again, okay? Yeah, not completely all the way over. For example, the new sitting judge will read over the history, all of the things that have gone on thus far in preparation for the trial that's about to take place. It's supposed to be next week. He or she will look over that and likely, probably agree with Judge Bresky's rulings, okay? Because he didn't do it out of prejudice. He wasn't trying to just be a big meanie head because it's Lori Vallow. The fact of the matter is there are rules, Lori. You wanted to represent yourself. You should familiarize yourself with those rules, which also include, okay, the fact that you're incarcerated. All right. You want to have two things simultaneously. You are incarcerated, and yet you want to have a speedy trial, knowing that the judge cannot do anything about the way that the jail is run. He doesn't have, no judge has discretion over that. Okay. So the jail's policies are the jail's policies. And you know damn right well that being incarcerated, things move slowly. That's how it is. They're just slower than if you were on the outside. I mean, duh and or hello, that's common knowledge. And that's just common sense. Okay. But you want two things to happen at the same time. Well, guess what, Shug? It ain't going to happen. So you need to pick a struggle. All right. Either cop to the charge and take a plea. Okay. Or waive your right to a speedy trial. That's the only thing that you can do, in which case all your continuances will be granted. You will be allowed to, take your sweet time and wait on those subpoenas to get served and all of the things. You'll have way more time for your quote unquote expert witnesses to get their reports in order and submit them to the state, which is what is required under the rules of evidence laws and criminal procedure. So you should you should really familiarize yourself with the rules before you start, claiming that it's not fair. See, you don't know the rules, and yet you're saying, "Oh, it's not fair. It's not fair." Get out of here. I'm over you, Lori Vallow, Daybell Esquire. Go on somewhere. All right. So you heard Judge Bev. Tomorrow's a half day. But I'll be back. I'll see you guys tomorrow, and we'll listen to whatever is happening tomorrow. We'll do all the things. We'll talk about it. I hope you guys have a great rest of your Wednesday afternoon, early evening, some places, and I'll talk to y'all tomorrow. All right. Bye, you guys. Oh, hey, give me a thumbs up or a thumbs down. I would appreciate that if you don't mind. All right. And shout out to Tess who sent that to me. Tess, you the real MVP. Couldn't do it without you. Thank you so much. All right, y'all.